Morning, Osceola County Corrections. Can you hear me? Somebody give me a thumbs up or a wave or something. Got it? Okay, you can hear me. Thank you. Welcome, everyone. We're here for pretrial today. I have a number of completed plea forms. Are these, anybody ready to go for a plea?
Honorary Jimenez, on behalf of Eric Sepulveda Torres. Case is on page 8 of the docket,
All right, thanks.
20 CF 1233.
Mr. Sepulveda Torres,
He's a Spanish interpreter here.
He's going to need a translator.
all right, thank you.
Good morning, Your Honor. This is Oliver Ross. This is the Spanish County Interpreter.
Good morning, Mr. Interpreter. Have you been sworn?
Yes, Your Honor.
All right, thanks. We have Mr. Sepulveda Torres. He's at the Osceola County Jail facility. He'll be doing the interpreting over the intercom system. The case number is 2020 CF 1233.
Thank you, Your Honor.
Mr. Sepulveda Torres, we're going to place you under oath. Please raise your right hand.
Señor Torres, por favor, levante la mano derecha para prestar juramento.
Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Jura, promete que el testimonio que rendirá será la verdad, solo la verdad y nada más que la verdad. Yes.
Mr. Sepulveda Torres, I have a 4-page document. It is a plea form. This plea form is in English. It has a signature on the back page of the document. Was this form explained to you?
Señor Torres, tengo acá un formulario oratorio que está escrito en inglés. Veo acá una firma que se encuentra al reverso del documento. ¿O usted leyó y se le explicó este documento?
Mi abogada me leyó los papeles.
My attorney read them to me.
And did you sign this document?
¿Y usted firmó el documento?
Sí,
Yes.
What your signature on the document tells me is that you understood all the rights and obligations on this plea form. Is that correct?
Lo que me indica su firma en este documento es que usted entendió todos los derechos que constan en el mismo, ¿correcto?
sí,
Yes.
It also tells me that you wish to plead no contest to the count 2, driving without a valid driver's license. Is that what you wish to do?
Y también me indica que usted desea sentar declaración de no me opongo ante el segundo cargo de conducir sin licencia válida. ¿Es eso lo que usted desea hacer?
sí.
Yes.
That is a second-degree misdemeanor. It's punishable by a maximum sentence of up to 60 days in jail, 6 months of supervised probation, or a $500 fine.
Eso es una falta de segundo grado sancionable con hasta 60 días de cárcel, con hasta 6 meses de libertad vigilada y con hasta $500 de multa. Yes.
You understand if I accept this plea of no contest, I will go along with the agreement you're making with the state, and we're not going to be having a trial in this matter.
Y he entendido, señor, que si yo acepto este convenio, yo me acataré al acuerdo que se ha llegado con la Fiscalía y no se celebrará juicio en este caso. Yes.
Is anyone forcing you or pressuring you into making this decision?
¿Acaso alguien lo ha obligado o presionado a tomar esta decisión?
No,
No.
Has anyone made you any promises other than what is written on your plea form?
¿Acaso alguien le ha hecho alguna promesa además de lo que ya consta en el formulario?
no,
No.
You understand if you are not a United States citizen, entry of this plea would subject you to deportation proceedings.
Y si acaso no fuese ciudadano estadounidense, al aceptar este convenio puede quedar sujeto a deportación. ¿Lo ha entendido?
sí,
Yes.
Understand if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment.
Y si acaso usted ha sido hallado culpable de algún ilícito sexual o de índole sexual en el pasado, al aceptar este convenio puede quedar sujeto a internamiento forzoso civil si ese fuese el caso. ¿Lo ha entendido?
sí,
Yes.
Court finds that you appear to be alert and intelligent.
Determino que usted ha tomado una decisión consciente.
You've told me you've talked this over with your attorney and you make this decision of your own free will.
Me ha indicado que ha hablado con su abogado al respecto y que ha tomado esta decisión de su libre albedrío.
Does the defense stipulate to a factual basis for purposes of the plea?
Your Honor, for purposes of the plea, defense
La
will be
defen-
stipulating.
La defensa estipula ante los fundamentos fácticos y su señoría para el convenio, la defensa estipula ante los fundamentos fácticos.
The court accepts your plea of no contest to count 2. You will be adjudicated guilty.
Bien, acepto su declaración de no me opongo ante el segundo cargo. Se emitirá un dictamen de culpabilidad.
You will be sentenced to the time in the jail that you have already served, which is
128 days.
Se le sentenciará al tiempo de cárcel que ya ha cumplido, lo que es un total de 128 días.
the maximum sentence is 60 days, so the sentence will reflect 60-day sentence with credit for 60 days that he has served.
Bien, la cantidad máxima de sentencia es de 60 días, así que reflejarán 60 días acreditándole los 60 días cumplidos.
You will owe court costs, Mr. Sepulveda.
Deberá pagar las costas judiciales, señor Sepúlveda.
Court costs of $273 and a $50 PD lien for a total of $323.
$273 de costas judiciales más $50 de solicitud de defensor público para un total de $323.
You have 30 days from today's date to appeal the judgment and sentence of the court.
Tiene 30 días de la fecha de hoy para apelar la sentencia emitida por el juzgado.
If you wish to do so, you must do it in writing.
Si desea apelar, tiene que hacerlo por escrito.
If you can't afford an attorney, one will be appointed for you.
Si no puede costearse un abogado para la apelación, se le designaría uno para ello.
The court costs need to be paid off to the clerk of the court collection program within 12 months.
Las cantidades que deberá pagar, el total, deberá saldarlo dentro de un plazo de 12 meses al Departamento de Cobros de la Secretaría del Tribunal.
Anything further, Ms. Jimenez?
No, Your Honor.
¿Algo más, señorita Jiménez? No, su señoría.
State as to count one.
Good case 2020 CF 1233, the state will have to Taiwan.
Fiscalía, algo que anunciar ante el primer cargo. En el primer cargo del 20 CF 1233, la Fiscalía desestima el caso.
As to this case, Mr. Sepulveda, you should be released today.
Bien, ya usted quedaría en libertad hoy ante este caso, señor Sepúlveda.
Good luck.
Buena suerte.
Your Honor, also, that's my only Spanish interpreter case.
Do we have a need for Mr. Interpreter on any other cases?
No that I know of.
Mr. Interpreter, thank you for your assistance this morning.
Not a problem, Your Honor.
Your Honor, also, I have on the add-on docket, Sean Lee Crosby, 20 CF 2561.
Thank you. Mr. Crosby? Good morning, Mr. Crosby.
Morning.
Mr. Crosby, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Crosby, I have that same 4-page document. It's the plea form, looks like this. On the last page, there is a signature. Did you sign this document?
Yes, I did.
Did you have enough time to go over it with your attorney?
Yes, I did.
You understand all the rights and obligations on all 4 pages of the plea form?
Yes.
Plea form also tells me that you wish to enter a plea of no contest in count 1 to battery on a law enforcement officer, count 2 resisting an officer without violence, and count 3 trespass in an occupied structure. Is that what you wish to do?
Yes.
Count 1 is a third-degree felony. It's punishable by up to 5 years in prison, 5 years of supervised probation, or a $5,000 fine. Counts 2 and 3 are first-degree misdemeanors. They're each punishable by up to 1 year in the county jail, 1 year of supervised probation, or a $1,000 fine. Do you understand those are the maximum sentences?
Yes, I do.
You understand that you are agreeing to go on 18 months of supervised probation if it is later proven to the court that you willfully and materially violated that probation. You're still subject up to the maximum sentences. Do you understand that?
Yes, sir.
You understand you have a right to have a jury trial as to all these matters. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of the offenses that you were charged with. At that trial, your attorney, Ms. Jimenez, would have been with you, would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights? Because if I accept this resolution, I'm going to go along with the agreement you're making with the state, and we're not going to be having a trial. You understand all that?
Yes.
Anyone forcing you or pressuring you into making this decision?
No.
Has anyone made you any promises other than what is written on your plea form?
No.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
You understand if you are not a United States citizen, entry of this plea would subject you to deportation.
Yes.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that?
Yes.
Defense stipulating to a factual basis for purposes of the plea.
Yes, Your Honor.
Court accepts that stipulation, finds I have a factual basis with which the court can accept this plea, find that Mr. Crosby appears to be alert, intelligent, he's had an opportunity to think about it and discuss it with his attorney. You satisfied with your attorney's help?
Yes, sir.
You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. Court's going to accept your pleas of no contest as to count one. The court is going to withhold adjudication. You'll be sentenced to 18 months of supervised probation with the special condition that you enroll in and successfully complete Solutions by the Sea program. How long a program is that, Ms. Jimenez?
I don't have that information at hand, Your Honor. Give me 1 second.
Is he accepted in the program? Is
Yes,
he-
Your Honor, he has been accepted and transportation has been coordinated. Personnel from our office will pick up the defendant tomorrow at the jail, so he will have to have a hold until tomorrow. He's gonna be transported to the bus station. Tickets has already been purchased and he's gonna be on the bus to Daytona. After that, he's gonna be picked up back from the program directly to the bus station and transported directly to the program.
All right, thanks. So as a condition of your probation, you're to be enrolled in the Solutions by the Sea program within 48 hours of your release and released directly to transportation to that program. You'll be randomly tested for any drugs in your system while you are on probation. You are to consume no drugs or alcohol as a condition of your probation. As to count two, the court will withhold adjudication. You'll be sentenced to 12 months of supervised probation. That's to run concurrently, meaning at the same time as the probation in count one. As to count three, you will be adjudicated guilty. You're going to be sentenced to the time that you have already served.
95 days.
Is he being adjudicated guilty as to count two as well?
Count two is a withhold, Your Honor.
Withhold. Okay, count two would be a withhold. Count three is an adjudication. And Madam Clerk, I missed the time, sir.
95 days?
Be sentenced to 95 days in count three and given credit for the 95 days that you have already served. You're going to have court costs that you're going to be responsible for. They're going to be made a condition of your 18 months of supervised probation.
Court cost of $413, a 201 battery surcharge, $100 cost of prosecution, $100 PD lien, for a total of $814.
These costs are owed by you to be paid off within the 18-month probationary period. Anything further, Ms. Jimenez?
Nothing further, Your Honor.
Anything further, Mr. Tagdarian?
Nothing more to say, Your Honor.
Madam Clerk, we good?
Court reporting is just asking that Mr. Takadir get closer to a mic.
All right. Mr. Crosby, you'll have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. Can't afford an attorney, will be appointed for you. There'll be a brief hold on you while your attorney arranges transportation over to Daytona. After that's sorted out, you should be released to that transportation to begin your participation in Solutions by the Sea. Is he going to check in with probation?
Yes, Your Honor, and he can, we will be asking the court if he's allowed at least, I don't know how the program starts initially, so my concern is his capacity to reach probation within 24 hours of his arrival, if the court will be willing to give him 48 after he's arrived.
Mr. Crosby, you need to check into probation within 48 hours after your release. I don't know how we're going to get that accomplished. You need to stay in contact with your attorney and the folks transporting you. We'll give you some contact information on your court minutes that will assist you in calling over there.
Yes, Your Honor.
All right, thanks. That's going to complete our hearing. Good luck.
Your Honor, I think Mr. Perez is on the lobby waiting to be admitted.
Good morning, Mr. Prey. Can you hear me?
Morning, Judge. I can hear you.
All right, thanks.
Your Honor, the next case that I have is on page 3, is Adrian Evans, 20 CF 1726.
Mr. Evans, good morning. We're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Evans, I have a similar plea form, 4 pages long, looks like this. It has a signature on the back page where it says defendant. Did you have a chance to read and sign this document? What your signature tells me is that you've understood all the rights and obligations on the plea form. Is that correct? Also tells me that you wish to enter a plea of no contest to 1 count of grand theft 3rd degree. Is that what you wish to do? All 3rd degree felonies are punishable by up to 5 years in prison, 5 years supervised probation, or a $5,000 fine. You understand that's the maximum sentence for this type of charge? You understand you have a right to have a jury trial as to this matter. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, your attorney, Ms. Jimenez, would have been with you. She would have cross-examined the witnesses and examined the evidence against you. You could have presented your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified at your trial or not. That would have been your decision after you talked things over with Ms. Jimenez, and your decision to remain silent. Your jury would have been instructed not to consider in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of those trial rights? Because if I accept this resolution, I'm going to go along with this agreement. We're not going to be having a trial. You understand all that? Yes. Anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what's written on your plea form?
No, sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
You understand if you are not a United States citizen, entry this plea would subject you to deportation.
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry this plea could subject you to involuntary civil commitment. Do you understand that?
Yes, sir.
Is the defense stipulating a factual basis for purposes of the plea?
Yes, Your Honor, for purposes of the plea.
Court accepts that stipulation, finds that I have a factual basis with which the court can accept this plea. Find that Mr. Evans appears to be alert, intelligent. He's had an opportunity to think about the decision, discuss it with his counsel. Are you satisfied with your counsel's help?
Yes, sir.
Seems like she did a good job for you. You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. You'll be adjudicated guilty of grand theft 3rd degree. Sentenced to 6 months in the Osceola County Jail. We'll give you credit for the time that you have already served,
36 days.
which is 36 days. This sentence to run concurrently, meaning at the same time with any other sentence that you're currently serving. The court's going to order restitution in this case to Dylan Ruggieri, and I will reserve as to the amount. You're going to owe court costs on this case.
Court costs of $413, a $100 cost of prosecution, and a $100 PD fee, for a total of $613.
Can you tell her to speak up?
Yeah, you're going to owe $613 as a result of this case. All those amounts will be on your paperwork when it gets over to you. Court's going to give you a period of 18 months to pay off those costs to the clerk of the court collection program. As long as you're making little payments to them, they'll be satisfied. If you don't make payments and they don't hear from you, they could suspend your driving privileges. Do you understand? You'll have 30 days from today's date to appeal the judgment sentence to the court. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. Anything further, Ms. Jimenez?
No, Your Honor.
Anything further from the state? Hearing nothing?
Nothing to say, Your Honor. I apologize.
That's all right, Mr. Collins.
This is a lesser fee. Statute that she put on the plea form, not just the statute of charge.
Excuse me, Your Honor.
Give us just a minute, Mr. Evans. I'm sorting out some paperwork. Is this a lesser included offense of a third-degree felony? Mr. Collins, what's it pled in the information? 812014, subsection 2, subsection C, subsection 6. Is that an F3?
Yeah, a third-degree felony motor vehicle, Your Honor. Just double check.
Yes. That's my understanding and the
Okay.
facts to Your Honor.
All right. Mr. Evans, you understand that this is grand theft third degree, but it's motor vehicle. Do you understand that?
Yeah.
All right. You had a question for me, Mr. Evans?
Yes, sir. I would like to open plea onto my misdemeanor.
Okay, I don't have your misdemeanor in front of me.
A moment,
Ms.
Your-
Jimenez, is he also represented by your office on a misdemeanor?
Yes, Your Honor.
Okay. Can you get that information to his counsel?
Yes. It's case number
20 CT 1531.
yes, Your Honor.
All right. Ms. Jimenez heard your request. She's going to get in touch with your misdemeanor attorney, and that needs to be done in county court. Okay?
And no way we can do it today. With that number driving and all.
Yeah, I don't have the other judges' calendars, so I can't give you a date from here. But Ms. Jimenez is aware of that. She's going to be contacting that attorney, and that attorney will get you on the books as soon as possible. All right. Good luck, Mr. Evans. See you.
Thank you.
I'm sorry?
Ms. Jimenez?
I don't know why.
Your Honor, the next case that there should be a plea form available is for case number 2. I'm sorry, page 1, Joshua Paul Brannon. I'm sorry, there's not a plea form for that case, Your Honor. It's for, these are missed address cases.
I have Mr. Padro Rexick.
Yes, that's the one. Case is on page 6 of the docket, Your Honor.
All right, Mr. Padro Rexick or Rexick.
Is it Brandon or Padro that you need?
Padro. Yeah, Mr. Brandon can have a seat. Sorry about that.
No problem. He's coming up.
No problem. Good morning, sir.
Good morning.
We're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Will you pronounce your last name for me?
Red Charles.
Rachat? I'm sorry.
Red Charles. I can't even pronounce it myself.
All right. Mind if I call you Mr. Padro?
Yeah, that's okay.
All right, thanks, Mr. Padro. Mr. Padro, I have a 4-page document. It looks like this. It's the plea form. You've heard me go through that a couple times. There's a signature over the green area where it says defendant. Appears to be your signature, and there are a set of initials after each of the 26 paragraphs that look like an E and a P. Did you have a chance to sign and initial this document?
Yes, Your Honor.
What your signature and your initials tell me is that you had enough time with the document, you've read it, you've understood it, you've had enough time with your attorney to go over it. Is that correct?
Correct.
It also tells me that you wish to plead no contest to 2 counts, count 1 being attempted burglary of a dwelling, and count 2 being attempted burglary of a conveyance. Is that what you wish to do?
Yes.
Those are each third-degree felonies. They're each punishable by up to 5 years in prison, 5 years of supervised probation, or a $5,000 fine each. You understand those were the maximum sentences?
Yes, sir.
You understand you have a right to have a jury trial as to each matter. At the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of the offenses that you were charged with. At that trial, Ms. Jimenez would have been with you, would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. You understand you are giving up all of your trial rights because if the court accepts this resolution, I'm going to go along with the agreement that you're making with the state of Florida. We're not going to be having a trial. You understand all that?
Yes.
Is anyone forcing you or pressuring you into making this decision?
No, Your Honor.
Has anyone made you any promises other than what's written on your plea form?
No.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No.
You understand if you are not a United States citizen, entry of this plea would subject you to deportation.
Yes.
You also understand if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that?
Yes.
Is the defense stipulating a factual basis for purposes of the plea?
Yes, Your Honor, defense will stipulate.
Court accepts that stipulation, finds that I have a factual basis with which the court can accept this plea, find that Mr. Padro appears to be alert, intelligent. He's had an opportunity to think about the decision and discuss it with his counsel. Satisfied with your attorney's help on this matter?
Excuse me?
Are you satisfied with your attorney's help on this matter?
Yes. Yes, Your Honor.
You've indicated to me no one has forced you or pressured you to make this decision. You do so of your own free will. As to counts 1 and 2, you'll be adjudicated guilty on each count concurrently, meaning at the same time. You're sentenced to 8 months in the Osceola County Jail. You'll get credit for the time that you have already served,
108 days.
which is 108 days. Court's going to order restitution in your case to Richard Purcell. I will reserve as to the amount. There's going to be some court costs assessed in your case. You're going to be responsible for those within a period of 18 months.
Court costs of $418, a $100 cost of prosecution, $100 PD lien for a total of $618.
As long as you're making little payments on those costs, you'll have no issue with the clerk of the court. If you are unable to make payments, let them know what's going on. They'll try and work with you. If you don't pay and they don't hear from you, they could suspend your driving privileges. Do you understand?
Yes, Your Honor.
You'll have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. Ms. Jimenez, anything further?
No, Your Honor.
State?
Judge, in 2020 CF 2385, this, oh, sorry. In 2020 CF 2385, the state will announce a null pros on count 3, and I'll follow that up with an e-filing.
Mr. Padro, the state of Florida has followed through with their part of the bargain and dismissed count 3. Good luck. All right, we have a gentleman here in court. Mr. Drew?
Yes, Your Honor. Mr. Helms, I filled out a police form. I hadn't.
Sorry.
Prepared yet to
I'll
sign
call you
that.
next.
I didn't hear, I thought it was me.
Do you just have the one case?
I do have one case.
Let me take you real quick and then get you on your way.
It's
No worries.
Chelsea Moore on page 1. We have had no contact with her. From what I understand, she was arrested and received a bond on this case, and she bonded out, and her record suggests that maybe we need to do a KPS again.
All right, Chelsea Moore, is that correct?
Chelsea Brown.
I'm sorry, Brown. Got another case going. Chelsea Brown on page 1, number 3.
Got it, thank you. Can we call the hallways for Chelsea Brown, please?
So are you staying in the same position at the end of the year?
Yes, sir.
Okay.
Fire me out of here.
No response, Your Honor.
Thank you. All right, we have called the hallways for Chelsea Brown. I'll note that it is now 9:40. Ms. Brown was noticed for today's date for a hearing at 9 o'clock. Let me take a look at her notice. Right, the notice was generated on November 2nd, 2020. We did notify Ms. Brown via general delivery, which is the only address that we have for Ms. Brown. She is listed as transient. Her bondsman, All-Star Bail Bonds, was also noticed for today's date. She's had no contact with her counsel. She's not present. The court is going to issue a warrant for her arrest. Mr. Collins, do you need to address the court?
I was just going to ask for that. I have no other information.
Right, we're going to revoke any previous bond. We'll issue a warrant for Ms. Brown's arrest. Bond at this point will be set at none, and the court will find a waiver of speedy trial, 2020 CF 3065.
Just so you're aware, I am in the process of transferring. I have applied for administrative transfers for several cases that are in front of Judge Morgan to be transferred here. Her co-defendant has the Lowe's case in here, which is bringing those cases with her,
Okay,
basically.
all right. I'll anticipate some more of Ms. Brown's cases as they arrive.
I will advise Mr. Shields.
Thanks, Mr. Zaleski. Is that all you have with us?
That's all I have for that.
Thank you.
Thank you.
Mr. True?
Your Honor. So, I have Mr. Holmes, Joshua Holmes, who's here present in the courtroom.
Thanks.
We have a signed executed plea form and a score sheet. Prior to going forward with the plea, we wanted to make a request to the court.
Yeah, come on up, Mr. True.
Your Honor, Mr. Holmes was going to ask to be released pending sentencing. If the court were to look at Mr. Holmes' score sheet, the court would see that he has absolutely no history outside of this one incident. While he was in custody, his partner had given birth to his first child. He has some property he was going to try and sell to be able to raise some money to give to the family while he is incarcerated. He did have some other things that he wanted to mention to the court, but I wanted to highlight some of the key facts for the court when making his determination. Also, if the court were to look at the facts of the case, the way we see the case, this was actually set up by someone else. He was merely kind of in the wrong place at the wrong time, and while he's not skirting responsibility of the charges themselves, he wasn't I would say the principal actor or the mastermind of the incident. And then one step further, I have already discussed with him that if he were to be released pending sentencing and either fail to show, pick up a new charge, or violate the court's conditions in any way, this plea would be off the table and the court would sentence him as the court saw appropriate in the case, knowing that there are 2 life felonies and a second-degree felony that's punishable by 15 years prison.
All right.
Going a little further into the case, while it maybe shouldn't completely get rid of the charges, this kind of is one of those situations where it was a drug deal that was set up and then kind of went in a different direction. It wasn't, the parties didn't completely fail to know each other.
All right, so Mr. Petro, your request is to have Mr. Holmes enter a plea and then the court to set off sentencing and release him pending sentencing?
Correct, Your Honor.
What's the state's position on that request?
The state does object to that. There's no agreement as to that. The state would not withdraw its offer if the court were to grant this request. I would leave, the sentence would be what the state's offered, but I do object to a furlough or however the court wants to phrase it. In July, we had a bond hearing in this case where the state proved proof evident or presumption great for the purposes of holding the defendant without bond on the penalties that are, or the charges that are punishable by life in prison. The court did find proof evident presumption great and did not find it appropriate to exercise the court's discretion to release the defendant on bond pending trial or resolution of the case. There's been nothing presented today that I think would assuage the court's view at that time that the defendant posed a danger to the community and should not be released, so I do object.
All right, thank you. Mr. Holmes, in resolving his case today, would be pleading guilty to 2 crimes that are punishable by life in prison, as well as a second-degree felony. And both of the allegations involve a firearm. Is that correct, Mr. Petro?
Yeah, sure, but he's not pleading to actual possession of the firearm. It's constructive possession.
Right. Right. Do you wish to present any witness statements or any testimony regarding the request? You had indicated Mr. Holmes wanted to tell me something.
Yes, Mr. Holmes would like to make the request to the court and further elaborate, Mr. Holmes.
Thanks, Mr. Holmes. We're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Yes, sir, Mr. Holmes.
How you doing?
Good, thanks.
Along with trying to be able to give my fiance and my child money to be able to support themselves for a little while at least during my incarceration, I would also like to be married to her, and I'd also like to be able to give money to my mother and my sister because my mother hasn't been working, and before incarceration, I was the sole provider for money for her with her living establishment, and that's pretty much it.
If I may ask some questions.
Of course, Mr.
Mr. Holmes, what type of work were you doing prior to your incarceration?
I worked at a restaurant called Ocean Prime.
Okay, and that's over, where is that?
It's in Sand Lake, I believe, in Orlando.
Over by iDrive?
Yes, sir.
Okay. And was that how you were helping provide to your mother?
Yes, sir.
Okay. If you were released from custody, did we discuss the need to follow any orders that the court had imposed?
Yes, sir.
And that if you committed a new offense, it could withdraw the sentence. The court couldn't sentence you to anything that the court saw fit.
Yes, sir.
And that you have to appear for future hearings.
Yes, sir.
Okay. Sorry, when was your child born?
June 21st.
Okay. So that was during your sentence, or during your incarceration?
Yes, sir.
Okay. And you're saying if you were to commit a new offense, the court would be able to impose any sentence that saw fit at that point?
Yes, sir.
Okay. And knowing that the courts, if it were to release you, would set your sentencing date, you understand that, correct?
Yes, sir.
And you would appear for that date?
Yes, sir.
Okay. I don't have any further questions, Your Honor.
Thank you. State, any questions?
No, sir.
Thank you. All right, the request is completely discretionary of the court. I'll note that the proposed resolution is a plea to 2 crimes punishable by life and a second-degree felony. It would encompass a significant amount of Department of Corrections time. I understand that would be the minimum sanctions. Is that correct?
Yes, Your Honor.
All right. Mr. Holmes, it's a reasonable request. I understand your desire to get out and get your family situated before you begin any incarcerative sentence. The charges are serious. I do note that you don't have a prior record, but leading off with 2 punishable by life offenses that involve a firearm. I don't know if it alleges that you were actually in possession of it or in constructive possession of it. They're too serious for the court to consider a release prior to your sentencing. So if you wish to accept the minimum sanctions as contemplated by your plea, I would be imposing the sentence today. So you can factor that into your decision-making process. Yeah, I won't. So the answer is, I appreciate the request, but I won't be releasing you prior to sentencing.
Your Honor, we're willing to go forward and enter the plea today. Mr. Holmes indicated that's what he wants to do.
All right. All right, Mr. Holmes, you've heard me go through the plea discussion several times this morning. This one is important because it's yours, and I want to go through the whole thing with you. The plea form looks like this document. On the last page of the document by my finger is a signature where it says defendant, kind of far away from me, but can you tell if that's your signature? And after each of the paragraphs, there are the initials J and H. Are those your initials?
Yes, Your Honor.
What your signature and your initials tell me is that you've actually read this document. You've had enough time with your attorneys to go over this, and you understood all the rights and obligations on this plea form. Is that correct?
Yes, Your Honor.
It also tells me that you wish to enter pleas of guilty to count 1, carjacking with a firearm, and that would be constructive possession, so it does not carry with it a minimum mandatory sentence. Count 2, robbery with a firearm, constructive possession, so there is no minimum mandatory firearm sentence. And count 3, aggravated battery, a second-degree felony. Is that what you wish to do? Do you understand that counts 1 and 2 are punishable by life in prison, a lifetime of probation, or a $10,000 fine each? Count 3 is punishable by up to 15 years in prison by itself, 15 years of supervised probation, or a $10,000 fine. Do you understand those are the maximum sentences? Do you understand that you have a right to have a jury trial as to these allegations? And at the jury trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, your attorney, Mr. Petru, or were you previously represented by Ms. Broadway?
Yes.
Yeah. Or both would be there with you. They would cross-examine witnesses and examine the evidence against you. You would have a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked the court to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorneys, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have those trials recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights because if the court accepts this plea, I'm going to impose the sanctions that are written on your plea form and we're not going to be having a trial. You understand that? Is anyone forcing you or pressuring you into making this decision, Mr. Holmes?
No.
Has anyone made you any promises other than what's written on your plea form?
No.
Are you under the influence of any alcohol, any drugs, or any mental issues that cause you not to understand the decision that you're making?
No, Your Honor.
Do you understand if you are not a United States citizen, entry of these pleas would subject you to deportation?
Yes, Your Honor.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of these pleas could subject you to involuntary civil commitment. Do you understand that?
Yes, Your Honor.
Mr. Petru, is the defense stipulating to a factual basis for purposes of the plea?
Yes, Your Honor, for purposes of plea.
Court accepts that stipulation, finds I have a factual basis with which I can accept Mr. Holmes' plea, find that Mr. Holmes in our discussions appears to be alert, intelligent. He's had an opportunity to think about the decision and discuss it with his attorneys. Are you satisfied with your attorney's efforts on your behalf?
Yes.
Okay. All right. Seems to be a minimum resolution with no minimum mandatory. You will be eligible for consideration for good and gain time and the time that you've already served. So it appears to the court that your attorneys did a significant amount of work for you. You indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. Mr. Baird, was the victim in this case consulted?
He was, Your Honor. He does not wish to be present today.
Thank you.
Also, for the court's information, this is the same resolution that co-defendant Darren Prescott received. The third co-defendant, Ms. Segarra, received a considerably lesser sentence in exchange for her cooperation with the state and her far less level of culpability in this offense.
Thank you. Mr. Holmes, the court is going to accept your pleas of guilty as to counts 1, 2, and 3. You'll be adjudicated of each count as to counts 1, 2, and 3 concurrently, meaning running at the same time. You'll be sentenced to 103.5 months in the Department of Corrections. The court will give you credit for the time that you have already served in our jail,
254 days.
which is 254 days. You will owe court costs. I'm going to reduce those to a civil judgment based on the length of your sentence. Court is going to order restitution and reserve to amount. I cannot reduce those amounts to a civil judgment. So the court will order restitution. That restitution will be joint and several with any co-defendant, and it will be the state's obligation to come forward with an amount should they choose to do so. You will have 30 days from today's date to appeal the judgment and sentence of this court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. State as to count 4.
The state does announce a nolla prosequi as to count 4, and I'll be following up with our written document.
State of Florida has followed through with their part of the bargain and dismissed one of your counts, that being count 4. If you are not being held on any other pending charges, you're going to be transferred to the Department of Corrections to serve the remainder of your sentence. Mr. Holmes, good luck to you. Anything further, Mr. Petru?
Just for clarity, Your Honor, we waive a pre-sentence investigation because Mr. Holmes had no prior criminal history.
Thank you for that clarification.
And then, did the court mention the public defender lien? I understand it'll be put to civil.
Yes, it is reflected on the plea form that there would be a $250 public defender lien that will be added in with the costs and reduced to judgment.
Thank you.
Thank you.
And so you're not waiving those costs?
Not waived, they're being reduced to a civil judgment.
Okay,
Thank you. All right, Mr. Holmes, we're going to get some fingerprints from you. Good luck, sir. Next case that I have is Ryan Kane. Good morning, Mr. Kane.
Good morning.
Mr. Kane, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Kane, I have been presented with a plea form. It has a signature on the last page of the document as well as a set of initials. Did you have a chance to sign and initial this plea form? What your signature and your initials tell me is that you've actually read it. You've gone over it with your attorney and you understand everything on this document. Is that correct?
Yes, Your Honor.
Also tells me that you wish to plead no contest to 2 counts, count 1 being possession of methamphetamine and count 2 being possession of drug paraphernalia. Is that what you wish to do?
Yes, sir.
Count 1 is a third-degree felony. It's punishable by up to 5 years in prison, 5 years supervised probation, or a $5,000 fine. Count 2 is a first-degree misdemeanor. It's punishable by up to 1 year in the county jail, 1 year of supervised probation, or a $1,000 fine. You understand those are the maximum sentences for these types of charges?
Yes, Your Honor.
Do you understand you have a right to have a jury trial as to each allegation? At the jury trial, the state of Florida would have to prove to a jury beyond to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, your attorney would be with you, would cross-examine the witnesses and examine the evidence against you. You'd have a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights? Because if the court accepts this plea, I will go along with the agreement and we will not be having a trial in this matter. You understand those things?
Yes, Your Honor.
Is anyone forcing you or pressuring you into making this decision?
No, Your Honor.
Has anyone made you any promises other than what is written on your plea form?
No, Your Honor.
Are you under the influence of any alcohol, any drugs, or any mental issues that cause you not to understand the decision that you're making?
No, Your Honor.
Do you understand if you are not a United States citizen, entry of this plea would subject you to deportation?
Yes, Your Honor.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this plea could subject you to involuntary civil commitment. Do you understand that?
Yes, Your Honor.
Is the defense stipulating a factual basis for purposes of the plea?
Defense would stipulate.
Thank you. Court accepts that stipulation, finds that Mr. Kane appears to be alert, intelligent. He's had an opportunity to think about the decision and discuss it with his counsel. Are you satisfied with Ms. Dupre's help, Mr. Kane?
Yes, Your Honor.
You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. As to this case, you'll be adjudicated guilty as to both counts 1 and 2. As to each count concurrently, meaning at the same time, you're sentenced to 150 days in the Osceola County Jail. You get credit for the time that you've already served with us,
14 days.
which is 14 days. There will be court costs that you will be responsible for upon your release. Court's going to give you 18 months to pay off those court costs to the clerk of the court collection program. Madam Clerk, the cost, please.
Court costs of $418, a $100 cost of prosecution, a $100 PD fee, a drug case fine of $315, a drug paraphernalia surcharge of $15, for a total of $983.
Those costs are owed by you at to the clerk of the court collection program as previously announced. As long as you're making little payments, you won't have an issue with them. If you don't pay and they don't hear from you, they could suspend your driving privileges. Do you understand?
Yes, Your Honor. Can I ask about my license being suspended?
Yes, sir.
Is there any suspension on that charge?
On an adjudication on the possession of methamphetamine, I have to suspend your driving privileges for a period of 6 months. I have no objection to you obtaining a work permit, should you qualify.
Okay, thank you, sir.
Mr. Kane, I'm taking a look at your criminal history. It looks to be mostly substance misuse related. Do you have a plan once you're released?
Yes, sir. I have a family member I'm moving away with.
Okay. Are you participating in any programs while you're there in the jail?
Yes, sir.
All right. Good luck to you.
Thank you.
If I didn't give you your appellate rights, you have 30 days to appeal. If you wish to appeal, you must do it in writing. Can't afford an attorney, won't be appointed for you. Thanks. All right, we're going to go to the top of our pretrial docket. The first case that I have is Kareem Acevedo.
That's Nicole DeBrand Parker's.
All right.
Acid.
Is Mr. Acevedo present? Yeah, it looks like he's present in the back. Good morning, Mr. Acevedo. All right, who has Mr. Acevedo's case? Mr. Prey, and for the
Officer
state?
Tank Deere on behalf of the state.
Thanks. Is there an offer of resolution on Mr. Acevedo's case?
Not at this time, Judge. He has some other pending cases.
Thanks, Mr. Prey.
Your Honor, Mr. Acid is currently in the competency track. He has another case, case number 2019 CF 2751, which has a status hearing tomorrow. I guess in that case, there's a evaluation that the court is awaiting on. I did file notice of incompetency in our case, and we were just tracking his other competency case.
Okay, is his 2019 case with us?
Yes, Your Honor.
All right. Thanks. Based on the filing from defense, the court's going to take this off our pretrial docket, and it will track with our 2019 competency evaluation. We'll see Mr. Acevedo tomorrow for a hearing. Thank you, Mr. Acevedo. Yes.
You have two state attorneys in your waiting room, just trying to maneuver on technical difficulties. They're been trying to see if they can get in.
Okay.
They're not pull up before when you call their cases.
Yeah, initially I didn't see them present. I don't see anybody present other than Ms. Dupre.
Okay, I'll let them know that now. Thank you, Your Honor.
Although I'm showing a number, yeah, I don't understand. Mr. Prey, I'm gonna leave this meeting and then rejoin, and sometimes that fixes the problem, so I'll be right back.
Okay, no problem.
All right, today's calendar, morning docket, going. I did it.
Should be Ms. Kazi and Testa.
I see Ms. Testa, I see Ms. Kazi. I do not now see Ms. Dupre. So if Ms. Dupre could dial back in, or I can invite her, I think. I'll try that.
Apologize, Your Honor, I just didn't want you to call the case and hold up the court.
Ms. Kazi, Ms. Testa, can you hear me?
Yes, can you hear us?
Yes, I can hear you. All right, we had Ms. Dupre on our previous Teams meeting, and I couldn't see you guys, and now I can see you guys, and I can't see Ms. Dupre. So we're contacting Ms. Dupre, and perhaps she can join the morning docket again.
Sounds good. I will just mute myself until we're ready.
Okay, thanks.
Yes, I can hear you as well, Your Honor. Sorry.
Thanks, Ms. Kazi.
Ms. Dupre does not have a different link. She's trying to rejoin the same link, but she's not getting access.
All right, I have sent an invite, and I have Ms. Dupre.
Thank you.
Thank you. All right, I think we got everybody. Do the Assistant Public Defenders want to go through their dockets? Good morning.
Good morning, Judge. I have two on the docket.
Yes, ma'am.
David Davis, which is the bottom of page 2 of your docket. There's no offer from the state at this time. I know your trial period starts the beginning of January, which is when Ms. Broadway should be back, so I don't want to leave it set for trial and then potentially she comes in a day as set for trial and asks for a continuance. So if we could set it for, if I could ask for a continuance and I guess set it for the pretrial in January to give her a chance to be back up to speed on it.
Yeah, the reality of the situation is January 4th is full, January 25th is full. These cases are going to be landing in March.
I don't think Ms. Broadway would have an objection to that.
All right, is Mr. Davis in custody?
No, Judge, he's outside in the hallway.
All right, thank you. State?
I have no objection to setting it on the March docket.
I will expect that all the discovery issues will be sorted out by then. Trial period begins March 1st and goes through March 19th.
And so pretrial would be in February?
No more pretrials. This is the pretrial for that.
Okay.
That trial docket. The February pretrial docket's likely to land in April. So.
Gotcha. So you're just setting it straight on a trial docket?
Correct.
Gotcha. Thank you, Judge.
Yeah, we've got 200 cases set for our January 25th trial period, and 50 set for our 1-week January 4th trial period. I'll consider reasonable requests to advance specific cases if the request is made by the assistant public defenders and with the blessing of the state. If any in-custody cases need to be added to one of those dockets, but otherwise everything is going to land on 3/1/3/19.
Thank you, Judge.
Thanks.
And then next, I have Ms. Echevarria, which is page 3 of the docket.
All right.
I didn't file, and I can if the court would like, I didn't file a notice of reasonable grounds of incompetency. She's set for an evaluation this Friday with our office at 9:30. I have medical records that seem to indicate that that's gonna be the way it was going, and that was what were Ms. Broadway's notes, but that was the first available date the doctor could come down to our office to do her evaluation. I can file the notice, or if the court wants to set it for a status pending the evaluation on Friday. I wasn't really sure how the court wanted to handle it, so I didn't do either.
Mr. Tagdiri, do you have a preference either way? I don't.
Judge Pache, on behalf of the state covering for Peter Donnelly, there's no objection from the state judge.
If there was reasonable grounds to believe that Ms. Echevarria may not be competent to proceed, why don't we just file the document? I'll set a status hearing off for about 30 days, and then
Okay.
maybe we'll have some more guidance by that point.
Perfect, that works, Judge. I'll file that notice today.
All right, thank you. Let me give you a status date in January. It's going to be Monday, January 11th at 9 o'clock.
Thank you, Judge. Those are the only two I had.
All right, thanks. Mr. Drew?
Yes, Your Honor. I have one other case, Kabir Ramnarine. It's 19 CF 1792.
All right, thank you. Yes, sir.
And the request on this case is set up for a plea date in January.
All right, thank you. Mr. Baird, do you need to coordinate with the victim's family?
I will, Your Honor.
All right, thank you. How about Wednesday, January 20th? Does that work for the parties?
That should be fine.
Is that too far out, Mr. Baird, or will
That
that?
should be plenty far out. Let me just check my calendar. Yes, that should be fine.
All right, this will be set for a plea on 1/20 at 9 o'clock.
Thank you, Your Honor.
Do we anticipate this will be a lengthy sentencing hearing?
Only if the family wants to give victim impact statements. I don't know if they want to give impact statements. A lot of them are out of the area, so I don't know what their intention is. But I believe it's going to be an agreed upon resolution, so that part should be relatively short.
All right, if you anticipate some victim impact statements, if you'll coordinate with Ms. Hafner, and she'll set aside the requisite amount of time that we'll need.
Yes, sir.
All right, thanks, Mr. Baird. Thanks, Mr. Petrillo. Is that your last case?
That is my last case. Yes, Your Honor. Thanks.
See you up here on unrelated matter.
Yes.
Mr. Johnson, morning.
Morning, Your Honor. A couple cases today. The first one I have is Andrew Baker on page 1 of the docket, 20 CF 1060.
All right, thank you.
Mr. Baker is present outside and was requesting to keep the set on the trial docket. We do have some depositions that are going to be conducted on Monday.
Yes.
But we should be good to go by January.
All right, who's the state on this one?
Justin Collins for the state, Your Honor.
All right, the request is to leave on the trial docket. It's Speedy trial has previously been waived. This one will land on the March docket. Any objections to that, State?
No objection from the state.
All right, 3-1 through 3-19, and as we get closer, I'll generate a trial order.
Yes, Your Honor. The next case I had was Teresa Clausen in 20 CF 675 on page 2 of the docket. I filed a waiver of appearance in her case yesterday, and she was also indicating that she wants to keep this set for trial.
All right, this one's getting a little old. Who's the state on Ms. Clausen's case?
Just calling for the state, Your Honor.
Is there an offer of resolution on this?
There is, Your Honor. The last offer is adjudication of guilt, 24 months supervised probation, 200 hours of community service, impulse control class to be completed within 90 days. Restitution is the amount of the contracted price on offer up, like it's a text thing for cars. No return and no contact with the victim and court costs.
Prior criminal history?
I'm sorry, Your Honor?
Is there a prior criminal history that supports the adjudication?
Per the score sheet, I had only one prior battery, but not a felony.
Is that the hangout, Mr. Johnson?
It's a little bit of that, and also Ms. Clausen has been pretty adamant that she wants a trial.
Okay. I don't know if the situation will improve if the jury doesn't see things her way. So we'll leave it on the jury trial docket, March 1st through March 19th.
Thank you, Your Honor.
Thanks.
The next case I have is John Magnan in 20 CF 3313. He's on the add-on. I don't know where he is on the docket now. This was the gentleman that had arraignment last week.
Yes, sir.
We are filing a motion to continue in this case. I believe it did hit the system this morning.
This looked like a quick set. Who's the state on this one?
Posh State, here on behalf of the state.
Any objection to a continuance?
No objection, Your Honor. And I filed a motion for fingerprint exemplars. I have the fingerprint card. If we can get his fingerprints rolled today in court.
Motion to continue would be granted. When do you want to be back for pretrial? February?
Yeah, that should work.
New pretrial date will be February 16th at 9 o'clock. Court's going to find a waiver of speedy trial in Mr. Magnan's case, 2020 CF 3313.
Thank you, Judge. And
Madam Clerk, the trial dates will be April 5th through April 23rd for that pretrial. Thanks.
And he's present outside, so if we wanted to do the fingerprints, we could do it.
Okay.
Yeah.
If we can bring in Mr. Magnan and get those prints rolled before he leaves the courtroom. Thanks, Deputy.
Thank you, Judge. Sorry for that. The next case I had was Mario Lamboy in 20 CF 2215. On this case, we'd be asking for a motion to continue in this case. There does have a co-defendant case that was set for
March 1st through March 9th.
Yep, exactly. And I believe it was unopposed, and that would be Ms. Demers on the case.
All right, thanks. Do we have somebody appearing for Ms. Demers this morning?
Your Honor, Posh State here on behalf of Lauren Demers. There's no objection to a continuance in this case.
All right. Court will accept the continuance. We'll set the case on the March 1st through March 19th. Do you want to pre-try this one again, Mr. Johnson?
If we could, Your Honor.
Yeah.
When we get close to that date.
I'll give you a, we'll put it on the February 16th, 2/16 pre-trial date. This trial period will be March 1st through March 19th.
Okay.
March 1st through March 19th.
The next case I had was Carlos Vargas on page 9 of the docket in 20 CF 1347. Mr. Vargas is present outside, indicating that he wants to go to trial as well.
All right. What is Mr.
Posh State here on behalf of the state.
What's the offer, Mr. Taglieri?
Your Honor, the offer in this case was an adjudication, 12 months in the Osceola County Jail, followed by 5 years of supervised probation, impulse control class, 200 hours of community service. Count 2 would be adjudication, concurrent jail and probation. Defendant currently scores bottom of the guideline 26 months, so this would be a downward departure.
Let's bring in Mr. Vargas.
Yes.
Carlos Vargas. Morning, Mr. Vargas. Mr. Vargas, we're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Mr. Vargas, you are charged with, is that the F2? Is count one an F2 or an F3?
One moment, Your Honor.
Sure.
F2.
Right. In count one, you're charged with a second-degree felony that's punishable by a maximum sentence of up to 15 years in prison, 15 years supervised probation, or a $10,000 fine. Count two is grant that. That's going to be a third-degree felony. It's punishable by up to 5 years in prison, 5 years supervised probation, or a $5,000 fine. If you were convicted by a jury, you understand that the maximum sentence you could receive is up to 15 years in prison.
Yes.
All right. You understand, as it sits now, in a consideration of your prior criminal history, the score sheet is indicating that the lowest permissible sentence would be what, Mr. Tagdiri?
26 months.
Be 26 months incarceration, absent some legal downward departure. If you were convicted as charged, that would be the sentence that you would be receiving. Do you understand?
Yes.
All right. And I understand that there is a downward departure offer that has been made by the state. Mr. Tagdiri, if you'll repeat that.
Yes, Your Honor. On count one, it's an adjudication of guilt, 12 months in the Osceola County Jail, followed by 5 years of supervised probation, impulse control class, 200 hours of community service. Count two would be an adjudication with concurrent jail and probation, court costs, cost of prosecution.
And Madam Clerk, how much time served does Mr. Vargas have? Okay. And we'd give you credit for the 2 days. Has that offer been transmitted to you by your attorney, Mr. Johnson?
Yes, sir.
Have you had enough time to think about that?
I just thought about it. Am I allowed to speak?
Why don't you run anything that you want to tell me through Mr. Johnson, because I don't want you to say anything about the facts of the case.
Thank you, Judge.
Didn't know if you needed me. Thank you. So, Mr. Vargas, understand that you are requesting a jury trial, and you have a constitutional right to have the state of Florida prove the allegations against you to a jury beyond and to the exclusion of every reasonable doubt. I'm sure it's been explained to you. I have no ability to downward depart on your case. That would be up to the state unless under a specific set of circumstances, some evidence is presented to the court that justifies a downward departure, and I would consider that if that was presented. Other than that, I'm stuck within what is recommended by your score sheet if you were convicted as charged. So as long as you are understanding of all of that situation and the fact that the state of Florida can pull their offer of resolution at any time prior to your trial, is it still your wish to have your jury trial with the court? All right, thanks. We're going to set you on our March trial docket. You're going to be set for trial sometime between March 1st and March 19th. You need to be ready for trial within that trial period. You need to stay in contact with Mr. Johnson and be fully prepared. Mr. Tagdiri, anything further?
Judge, just that the offer is revoked.
Okay. All right. Thank you. That will complete our hearing. Mr. Vargas will see you sometime back between March 1st and March 19th. It's your obligation, and the court will order you to be available that whole time, and I will let your attorney know when you need to come back. Thanks.
Judge, the last case I had was Ricardo Vasquez, 20 CF 682. He's in custody of the Osceola County Jail.
Thanks. Mr. Vasquez, are you with us?
Yes, he is.
Thanks. Good morning, sir.
Catching me up to state.
All right, I'm looking at Ms. Kazi, who is the prosecutor on the case on my computer screen. Your attorney, Mr. Johnson, is present with me. Yes, sir.
Yes, Judge. This morning we had some last-minute negotiations with the state. Mr. Vasquez would be accepting a plea. I was going to ask if, do you have the jail feed this afternoon?
I do.
If I could run out as soon as I'm done with this and complete a plea form with him, and if we could have this heard this afternoon.
All right, thanks. I'm also doing initial appearances, so if we could have Mr. Vasquez brought with our initial appearance group, and he's got the paperwork completed, I could complete his plea.
Perfect. I can do that, Your Honor.
Yeah. Madam Corrections Officer, can we have Mr. Vasquez this afternoon included with the initial appearance folks, and he's going to be resolving his case?
No problem.
Thank you very much. Mr. Vasquez, we'll see you back this afternoon.
Thank you.
Thanks. Okay.
Thank you, Your Honor.
And that's all I have this morning, Your Honor. May I be excused to go run and get that plea form done?
Yes, sir, Mr. Johnson, thanks.
Thank you, Judge.
Ms. Jimenez,
Yes, Your Honor.
good morning again.
Yes. I thought in the morning you were calling only the one with plea form, so. I have on the docket, page 2nd, Orlandito Cristobal Ortiz, 20 CF 3244.
All right, thanks. I saw a waiver of his appearance was
Yes, Your
filed.
Honor. And there's an unopposed motion to continue in this case.
All right, thanks. Who's the state?
Joseph McCollum from the state, Your Honor. I have no objection.
What, more negotiations? Are we waiting on evidence? What are we doing?
More negotiations and information that is needed.
All right.
And Your Honor, also, you signed an order having his fingerprints. I tried to get it to the jail before he was released. It was a little too late, so you directed an order to report to the sheriff's office. And I've already sent that order over. They're waiting for him to make the appointment.
Your Honor, my client did went to the sheriff department's office to get the fingerprints, so that should have been taken care of.
Sounds like discovery is ongoing. The motion to continue is granted without objection. I'll find a waiver speedy trial 2020 CF 3244. New pretrial date will be 2/16 with a trial period that begins April 5th through April 23rd.
Thank you, Your Honor. My next case is on page 4. 20 CF 984. Mr. Jabri.
Mr. Jabri, are you with us?
Yes, one moment.
Thank you, Madam Correction Officer.
Your Honor, there's a motion to withdraw in this case that was filed.
Is that based on conflict or another attorney subbing in?
I'm sorry?
Is that based on conflict or another attorney has substituted in?
No, Your Honor, it's
Okay,
ex parte request.
thank you. Good morning, Mr. Jabri. All right, Mr. Jabri, your case was continued back in June. It was reset a couple of times. The Office of the Public Defender has requested to withdraw. Do you take a position on their request? Mr. Jabri, can you hear me?
I'm sorry?
Said, can you hear me okay, Mr. Jabri?
Yes, now I hear you.
All right, thanks. We're going to place you under oath.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to enter into this case is the truth, the whole truth, and nothing but the truth, so help you God?
All right, thanks. Let me pull your case up, Mr. Jabri. Give me just a moment. All right, Mr. Jabri, the Office of the Public Defender has certified a conflict and requested a motion to withdraw. Do you object to that motion? Yes. You do object? All right. Thank you. Ms. Jimenez, I have reviewed the motion. Without belying your attorney-client privilege, is there any additional information you can give the court regarding the request to withdraw?
No, Your Honor.
Right. This always places the court in a quandary as to what to do. It has been represented in the certification of conflict that defense counsel is unable to complete their obligations pursuant to the requirements that under the Florida bar rules.
Your Honor?
Yes.
Your Honor, I've been involved in this case. I could probably maybe give some clarification for the court.
Thanks.
There was a supplemental report that was filed where the sheriff's office received an item that is relevant to this case from our office. And so because our office is now listed in it, we don't feel it's appropriate and there would be a conflict with us continuing representation.
Understood. All right, Mr. Jabri, I understand you object to your attorney's request. They are under some obligations pursuant to the Florida bar rules as to how they operate as attorneys and their obligations to you. They have represented that based on circumstances, they're unable to continue with that representation in a conflict-free manner. I am going to appoint you another attorney, and that will be the Office of Regional Conflict. We are going to leave your case on for trial, and is there an offer of resolution on Mr. Jabri's case? Does he have other matters?
He does have other matters, Your Honor. When the plea negotiations were happening with opposing counsel, the supplement that was just referred to was part of that, and because the laptop was recovered, the state, which is adjudication of guilt, credit time served, because that was what the victim is impacted to me, was they just really want the laptop back. So adjudication of guilt, credit time served is the current offer right now.
Okay.
And based on my communications with the client, he always mentioned that he wanted trial.
Okay.
So that should be up to the.
All right. I think we've had a discussion with Mr. Jabri. I remember Mr. Jabri, and you understand that the offer would be an adjudication of guilt, time served, and court costs. Has that offer been given to you, Mr. Jabri?
I'm sorry?
Has the offer of an adjudication, I'm sorry, Mr.
I apologize, Your Honor. I just remember something I told opposing counsel, and to be candid with court, it'd be pleaded to the lesser included of petty theft of $100 or more with adjudication of guilt and credit time served, Your Honor. So it actually is the lesser included petty theft of a misdemeanor.
All right. Mr. Jabri, the offer to resolve your case at this point is that you would enter a plea of no contest to a lesser included offense of petty theft of over $100. That is a first-degree misdemeanor. You would be adjudicated guilty of a first-degree misdemeanor. I would sentence you to the time that you have already served in the jail, and you would pay court costs. Has that offer of resolution, has that been given to you? Okay. And you are entitled to have a jury trial to make the state of Florida prove the allegations against you. Do you wish to accept that offer, or do you wish to have a jury trial?
No, I wish to have a jury trial.
All right. Thank you, Mr. Jabri. That is your constitutional right. And you understand that based on the court's trial schedule, that could cause you to be incarcerated until I'm able to try your case. Do you understand that?
Yes.
All right. Okay, we're going to keep Mr. Jabri on the trial docket. We're going to appoint the Office of Regional Conflict to represent Mr. Jabri's interest. They will be notified and out to talk to you, Mr. Jabri. I'm going to put you on the January 25th trial docket. This case has been going on for some time, and I believe that you need to have your case resolved one way or the other. So this will be set on for trial 125 between January 25th and January 12th, which is my very next trial period. Thank you, Mr. Jabri. Your next case, Ms. Jimenez?
Yes, Your Honor. On page 6, James Victor Neri. This defendant is in Volusia County Jail, and we received communication from Ms. Hafner that they were not going to release him. I checked the case on Volusia 2016-303, 217 CFDB, and they have a BOP status for January 14. So I would ask the court to reset pretrial conferences after January 14th to see if they're going to release him.
It's astounding to the court that they would consider a hearing more than 40 days out as an upcoming hearing and deny our transport order for pretrial over a status hearing. But apparently that is the situation that the court is faced with.
My understanding, Your Honor, is that they did celebrate a hearing before. I just took note of the future hearing just to make sure where could we set this case for the next court date. So that's,
I'm going to place the case on for our February pretrial date, 2/16, and then I'll ask the state to file yet another transport order for that date or shortly before so we can try and effectuate his attendance.
thank you, Your Honor.
2/16.
I have on page 8, Edwin Toro Jr., 20 CF 1986. A motion to continue was filed.
I saw that. That was filed yesterday. Is that opposed?
Yes, Your Honor. Not opposed.
Right, speedy trial
Have been waived already, Your Honor.
been previously waived.
Yes, Your Honor.
Is Mr. Toro in or out of custody?
He's outside the courtroom.
Okay, what are we waiting on? Is he making some efforts to try and get a driver's license back?
Yes, Your Honor. My client has already paid almost $4,000 in traffic ticket. He's only missing 3 more traffic citations that he needs to fix to be able to get his driver's license, and that's why the defense is asking for the motion to continue.
Why don't I do this, Ms. Jimenez? I'm going to deny the motion to continue, but I'm going to put it on the March 1st to March 19th.
Yes, Your
I'll
Honor.
docket a de facto continuance, and hopefully he's got it sorted out by then.
Yes, Your Honor.
Thanks.
Judge, so that's just going on the trial docket, not another pretrial?
I'm not going to give it another pretrial.
Okay.
And my next case is Keisha Lean Vandermatt. This is with ASA Testa.
Thank you. Ms. Testa, you still with us?
Amy Testa on behalf of the state.
Thanks. All right.
And Your Honor, in this case, we will be asking for a continuance too. I was able to talk to the defendant. She wants me to do some depositions in this case, and I need to request those. So at this time, the defense will be waiving speedy and entering into asking for a continuance.
Ms. Testa, does the state oppose a motion to continue?
No objection.
Court will accept the motion to continue. Was that already filed?
No, Your Honor.
Why don't we supplement the court file with a written request?
Yes, Your Honor.
I'll find a waiver speedy trial in 2020 CF 803. Is Ms. Vandermatt still present, or is
She should be outside, Your Honor.
Can we have her fill out a change of address form? We're having mail returned.
Yes, Your
And we
Honor.
have an old address. And the new pretrial date will be February 16th, the trial period between April 5th and April 23rd.
Sure. And next case, Your Honor, will be Brandon Sloan.
I missed the name.
Page number 8, 20 CF 1319.
All right, thank you, Brandon Sloan.
Your Honor, in this case, we will be setting this case for trial. We have received a jail offer, but we're trying to get a probation offer. So I have provided the information to State Attorney Pasha Tagdiri, but we're still waiting for confirmation from the state for a probation offer. So we would like to set it for trial, but probably in the meantime, we request a plea certain.
Judge Posh-Tagdiri on behalf of the state. In this case, defendant has quite the lengthy history, so the offer was an adjudication, 6 months in the Osceola County Jail, restitution and cost. Defense attorney was providing some mitigation. They provided me a letter from his employer. I just wanted to talk to his employer because his employer said he's been employed since January 1st of 2020. This event took place in March of 2020, so he was stealing while he had a job, so I just wanted to talk to his employer first, and before I thought about making a revised probation offer.
I'm going to set this case for a plea status on either the 21st or the 22nd of December. Are the parties here that week?
The 21st or 22nd will work for me, guys.
I think I won't.
You think you're out?
Yes, Your Honor.
All right. How about the 18th, Friday the 18th?
That works for the state.
That works for defense.
12/18 at 9 o'clock for a plea status. Let's see if we can hammer that one out.
Thank you, Your Honor.
Is that your last case?
I have 2 more cases, but I need to.
Okay, who do we have waiting patiently at the jail facility?
I have Brandon Joshua, and Rodriguez Joshua.
Okay, so let me take care of the
Those are Nicole
cases
first,
and then
yes.
I'll
Thank you.
circle right back to you. Let's call up Mr. Joshua.
I have 2. I have Brandon Joshua and Rodriguez Joshua.
Oh,
On page 1, Mr. Joshua Brandon, he's in custody, he's also my client.
thanks. We'll take Mr. Brandon first.
Okay.
Good morning, Mr. Brandon.
Good morning, Your Honor.
Thanks. All right, we apparently got Mr. Brandon back. I thought he was in the Orange County Jail. What's the status of his case?
Your Honor, Mr. Brandon currently has an offer that he wishes to accept. The only point of contention he has right now is the credit for time served. According to the credit time served docket, he has 99 days. However, there's time where he was served with the warrant, he was in DOC, and there are a few other arrests that he thinks he is entitled to a bit more credit. So I was going to request the court to set it off for a plea date so I could look into this more and see what his actual time served is and if we could provide that to the court.
Sure. December 21st or 22nd, either of those dates work for you?
Yes, Your Honor.
One works for the defense.
All right. Thank you. And state?
You said 21st, Your Honor?
21st or 22nd?
Either date works for the state.
We'll do it Monday, the 21st at 9 o'clock. Mr. Brandon will need to be brought over on that day.
I'm sorry, Your Honor.
Okay, and if I can figure it out earlier, I'll ask for a different request.
We're going to transport you to the courthouse on December 21st at 9 o'clock. I'm going to wake you up early, and we'll address your case then. If you wish to resolve it and we've sorted out the time served issue, we can do it then.
Yes, Your Honor.
Thanks.
Your Honor, just for the state's, does the state need to prepare an order or anything like that for that?
No, we'll bring him over.
Thank you, Your Honor.
Thank you. Plea. And
I also have Mr. Josh Rodriguez. He was on the add-on docket, I believe.
all right, thank you. Good morning, Mr. Rodriguez.
Good morning, Your Honor.
All right, we have Mr. Rodriguez. I know that there was some confusion as to another Joshua Rodriguez. I think we have sorted that out as to this case.
Yes, on Mr. Rodriguez's case, he just was transferred here from Lake County on the 7th. He does have an offer to resolve. I was quickly able to talk to him this morning, but
Oh, you've dropped out.
in Lake County, so I couldn't talk to him. Sorry.
That's all right.
He does have an offer to resolve it, but since he just got transferred here from another jail, I haven't been able to in length have a conversation about it. I know this morning I spoke to him and he wanted the Office of the Public Defender to try and get him some form of drug treatment as a part of his offer. So if we could also set him maybe on that December 20th date so that I can actually convey the offer properly and it would probably be resolvable.
All right. court's going to set Mr. Rodriguez's case for a plea status. That's Monday, December 21st at 9 o'clock. Mr. Rodriguez, your attorney's going to be hammering out the issues of your request with the state of Florida. We'll bring you back on the 21st, and if you wish to resolve your case, we can do it that morning.
I also want to know the jail time also, just so I know my options.
Sure. Let's get you credit for time served, and then I'll see if the state of Florida has a straight jail offer for you.
He has 18 days credit time served.
We're showing 18 days since you've been in our jail. I don't know whether you've been continuously incarcerated or where in Lake County, but on our charges, we're only showing 18 days.
Judge, depending on how much credit he has for Lake County, it could be a credit time served offer. I just have to know.
Okay. All right, so they're going to be considering perhaps a credit for time served offer. They're going to be checking into your credit for time served. We'll see you back on Monday, December 21st at 9 o'clock.
Thank you, Your Honor.
Yes, sir. And Mr. Rodriguez will need to be transported if Ms. Hafner is listening in. Thanks.
Your Honor, that's all I have here.
Thank you, Madam Corrections Officer. All right, did Ms. Jimenez step out, or you have additional cases?
I have more.
Okay, thanks, Mr. Cray.
I do have an
Right, good afternoon, Osceola County Corrections.
Good afternoon, Your Honor.
Good afternoon, Ms. Chrysler. Can you hear me okay?
Yes, sir.
All right, thank you. Most of you here are here for initial appearances. Initial appearances is the time when I'm just going to formally advise you as to what the allegations are pursuant to the charging affidavit. I'm going to take a look at the charging affidavit and determine whether there is probable cause for your initial arrest. We're going to talk about getting an attorney on board for you if you do not already have one on board. And after that, I'm going to talk about any conditions of bond that'll get you back to your lives while the case is pending, if they are appropriate. Many of you may disagree with what is in your charging affidavit. Today's not the day to have that discussion. I'm very likely not your trial judge. So you'll need to save that argument for your attorney and the trial judge. I have an attorney appearing virtually. I'm going to call that case first. Mr. Zimiewski,
Yes, Judge.
your client's name, please.
Ms. Gwendolyn Waring.
Oh, Your Honor, she's not here right now. They're doing this in two waves because of the amount of people that we have today. She's on the second group.
All right. Zumansky is going to be in the second group, so if you want to stand by, and you can go ahead and mute your microphone, and I will give you the high sign when we have your client present.
Yes, sir. Thank you, Judge.
Thanks. First case then that I have is a Spanish interpreter case. Let me get the interpreter on board. And for the state, your name for the record?
Maria Morales for the state, Your Honor.
I didn't hear the last name, sorry.
Morales?
Morales, thank you. And as always, we have Officer Kendo present. Good afternoon.
Good afternoon, Judge.
Good afternoon. This is the interpreter, Dalia Romero, already sworn in today.
Good afternoon, Ms. Romero. We have Mr. Villamil Cardona. The case number is 2020 CF 3576. He's at the jail facility, and you'll do the interpreting over our intercom system.
And, Your Honor, is this courtroom 4F?
It is, but we're doing initial appearances by video, and Mr. Villamil Cardona is out at the jail facility.
Señor Cardona, ¿puede escuchar la intérprete? He can hear the interpreter, Your Honor.
Thank you. So, Villamil Cardona, you were arrested based on an allegation of battery, domestic violence, and false imprisonment. I have read your charging affidavit. I do find probable cause.
Señor Villamil Cardona, usted fue arrestado en un caso de agresión, violencia doméstica y de haber retenido a alguien con pretextos falsos.
Court is going to set bond in count one. Well, court's going to set bond in count one in the amount of $500 plus pretrial release conditions of no contact with Madison Lutterlow.
And Judge, he doesn't qualify for a pretrial release due to some immigration issues.
El juez se le está dando una fianza de $500 más libertad preventiva y que no puede tener contacto con una Madison Lutterlow, pero el oficial del programa de libertad preventiva ha dicho que usted no es elegible para ese programa por el hecho de que hay alguna cuestión con inmigración pendiente.
All right, based on the representation of the pretrial release program, your bond will be set in the amount of $500 with the special condition that you have no contact with Ms. Lutterlow and you not return to the Wynwood Drive address.
Bien, dado por lo que el oficial del programa de libertad preventiva ha dicho, la fianza es de $500, no puede tener contacto con la señora Lutterlow y no puede regresar a la dirección de Wynwood.
Do you have any personal belongings at the Wynwood address?
¿Usted tiene algún artículo personal en la dirección de Wynwood?
Yo vivo ahí, mis padres viven ahí.
I live there, and my parents live there.
Does I'm going to appoint the Office of the Public Defender to represent your interests. Ms. Chrysler, do you want to ask him if Ms. Lutterlow also lives at that address?
Le está designando el defensor público para que le represente, el señor juez, y le está permitiendo a la abogada que le pregunte si la señora Lutterlow vive en esa dirección también.
Your Honor, the problem is I don't speak Spanish.
El problema, su señoría, es que yo no hablo español.
Yeah, I don't want to have him inadvertently admit any of the elements of the crime.
Yo no quiero que él admita ninguno de los elementos de este delito.
Judge, a victim notification card provided by law enforcement officer states the same address, 4790 Wynwood Drive, for the victim.
Your Honor, he does speak some English, but the translator is definitely necessary. From what I was able to discuss with him, it does appear that she did grab her items that she had at the home and leave.
Él habla un poquito de inglés, su señoría. Definitivamente necesitaríamos un intérprete, pero aparentemente él ha dicho que ella agarró las cosas de sus pertenencias de la casa y se fue.
Would, in order to maintain separate residences, satisfy the court?
Una orden que le ordene a mantener residencia separado, ¿eso satisface la corte?
Ms. Morales?
Your Honor, I would agree. I was going to ask for that same.
Yo estoy de acuerdo, iba a pedir lo mismo.
Right, as a condition of the bond, you are to maintain separate residences from Ms. Lutterlow.
Como condición de libertad, usted tiene que mantenerse viviendo separado de la señora Letterlow.
As to count two, your bond will be set in the amount of $500.
Y en la segunda causa, la fianza es de $500.
Madam Clerk, any additional court dates?
On demand.
Más adelante le van a proveer las fechas de corte.
I'm sorry, Your Honor, what was the bond amount on count 2?
500.
500?
500 la fianza en la segunda causa también.
That will complete our hearing. Thank you.
Eso concluye esta audiencia. Gracias.
Ms. Romero, thank you for your help.
You're welcome, Your Honor. Have a good afternoon.
You too.
Thank you.
Vernon Poe. Good afternoon, Mr. Poe.
Good afternoon.
Mr. Poe, you were arrested based on a warrant out of another county. That's Marion County. Fortunately, Marion County has issued no bond, so you're going to remain on no bond until we can get you to Marion County and address that issue with that court. I am going to appoint one of our public defenders to represent you to make sure that you have a voice while you're there in the jail facility. And Marion County will be noticed that you're here with us in Osceola County. Thank you.
Yes, Your Honor, thank you.
Roberto Rodriguez. Good afternoon, Mr. Rodriguez.
Good afternoon, Your Honor.
Mr. Rodriguez, you're in a similar situation as Mr. Poe. You were arrested based on an out-of-county warrant. That warrant is out of Hillsborough County. It is alleged to be for a driving under the influence charge, and it is alleged that there was a failure to appear. Unfortunately, that judge has issued no bond. You're going to remain on no bond until we can get you back over to Hillsborough County. We'll notify Hillsborough County, and we'll appoint our public defender to represent your interests while you're there in the jail. Thank you.
Thank you.
Yes, Your Honor.
Right. Ms. Chrysler, is there any private counsel there?
Your Honor, no, there's no private counsel here at the time.
All right, thanks.
I do expect one of the people here today to have private counsel.
Yeah, we were contacted by two private counsel on two cases, so I'll skip over. I think Mr. DeWitt may have private counsel, and then Mr. Zimiewski's client.
Yes, Your Honor, that was the person that I expected to have private counsel.
Thanks. All right, I'll call Mr. DeWitt's case in just a minute. Tarvis Burgess.
You approved?
Hey, good afternoon, Mr. Burgess. Mr. Burgess, you were arrested based on a warrant. That was a warrant for failing to appear on case number 2020 CT 1696. I don't want you to talk about the circumstances. You'll need to explain that to Judge Epperson. He's the one that issued the warrant. The warrant has no bond. Ms. Chrysler, is Mr. Burgess already a client of your office?
Yes, Your Honor, he is, and I will be letting his attorney know. Your Honor, this is just a no valid. Is there any way that we can set bond today for him?
Yeah,
I
Judge,
believe that there might have been a paperwork scuffle. I had seen in our file that a waiver had been sent, but I didn't see one returned. I think there might have been an issue with the mail.
let me see if I can track down Judge Epperson and get some guidance from him. He was in the best position to issue the warrant and the bond amount. If I can hear back from him, I'll recall Mr. Burgess, and maybe we can readdress the issue of his bond.
Yes, Your Honor, I appreciate that. Thank you.
Thanks. Give me just a moment. All right, I've sent that message to Judge Epperson. We'll recall Mr. Burgess's case.
Thank you, Your Honor.
David DeBose?
PD approved.
Pronounce your last name for me, sir.
It's Dobosh.
DeBosch? Dobosh?
Yes, sir.
Thank you. Mr. Dobosh, you were arrested based on an allegation of violating a domestic injunction and violating another, first was going within a location within 500 feet. The second was communicating or contacting, both first-degree misdemeanor allegations. Looks like I want you to talk about the case, Mr. DeBosch. Judge has already found probable cause for the allegations. Court is inclined to grant you a bond.
Your Honor, because of the domestic nature is the reason why zero bond would have been set. He would be entitled to some form of bond at this point in time.
Yeah, I just said I was inclined to grant him a bond.
Your Honor, I'm so sorry.
That-
I misheard you.
It's all right. In count one, the court is going to set bond in the amount of $1,000. In count two, in the amount of $500. He's to have no contact whatsoever with Brittany Stapleton. There is an active injunction which prohibits him from going within 500 feet of the Kenansville address.
She moved within 100 feet of my permanent.
Mr. Bosch, I'm going to appoint the Office of the Public Defender to you. I understand that you disagree with some of the allegations in your charging affidavit. You're being recorded, and I don't want you to say anything that's going to admit inadvertently some of the elements of the crime. So anything you want me to know, if you'll run that by your newly appointed attorney, that may be a good idea. You're also out on bond, and I'm sorry, you're on county probation in 2020 MM 91. Court's going to find an on-view violation of probation based on the court finding, based on another judge, Judge LeBlanc, finding probable cause that you committed a new law offense while you're out on probation. You're on probation with a case in front of Judge Epperson. I'm going to issue no bond on your on-view violation of probation. You need to get in front of Judge Epperson and have him consider any issues of bond. I will appoint the Office of the Public Defender on 2020 MM 91, but you can remain with us until you can get that sorted out with Judge Epperson.
Yes, Your Honor.
Thank you. Jeremy DeWitt, 2020 CF 3570.
Good afternoon, Your Honor.
Good afternoon, Mr. Ledan.
Amir Ledan on behalf of Mr. DeWitt.
Thank you. Good afternoon, Mr. DeWitt. Good afternoon, Your Honor. Mr. DeWitt, you were arrested based on a warrant. Another judge has found probable cause for the allegation of failing to register as required. Court is going to set bond in this case. I'm not aware of any request by the state for pretrial detention, so you are entitled to bond. Your bond in this case will be set in the amount of $1,500.
Your Honor, may the state be heard?
Of course.
Mr. DeWitt has another open case. It's 2019 CF 3928. So state would be asking that the bond be revoked in that case.
All right, thanks. As to the new law offense, the Judge Yancevich had indicated you may not leave the jurisdiction of the court without express consent of the court. That's going to be a condition of your bond in this new law offense, 2020 CF 3570. Officer Akendo, I didn't see the other law offense on
Judge,
the
when
face
we
sheet.
sent you the paperwork this morning, we sent you these extra pieces of paper with several of the cases that the defendant is out on bond. We count 5 cases where he's out on bond, 4 of them being from Orange County, and he's on ROR status out of Orange County on 5 other different cases.
Does he have any cases with us in Osceola County that he's currently out on bond?
We find out on bond for 19 CF 3928.
Mr. Ledan, do you wish to be heard as to the state's request?
Yes, Your Honor. We appeared before Judge Barber this morning. Mr. DeWitt was already slated for a hearing before her this morning for a plea status. The judge declined to take action on revoking any of the bonds. The state did make the request this morning, and that was denied by Judge Barber. I'm aware of part of the allegations within the narrative that's before the court. My concern is that in part, they allege some type of violation of a temporary residence or a temporary residence being used. And for the court's consideration, Mr. DeWitt was improperly charged by the Orlando Police Department with a domestic violence charge. The victim in that case has never cohabitated with my client, and it was determined that OPD classified it as a domestic case so that when he got arrested on the charge, he'd be held and would have to appear before an initial appearance judge. I appeared before Judge Carter on that case last week, and the state, in particular Michelle Latham, had no-billed that case either the morning of that initial appearance or contemporaneous to it, but the judge was aware of that, and Mr. DeWitt was released. And I bring that up because I'm very frustrated by law enforcement's conduct in Mr. DeWitt's cases. I know he has plenty of cases pending, but to do something deliberately to misrepresent the nature of an offense, to then try to seek a warrant for his arrest, to then try to revoke these bonds is what appears to have happened last time. Now we're here before the court on a new charge alleging similar conduct about being out of place or having some type of temporary abode. And I think it smacks of impropriety, and I'm very concerned about it. And so I know we're only here on a PC determination. That PC determination has been made. However, the court does have the discretion not to revoke the bond. I'd ask that this matter be set for a hearing, have the state file whatever appropriate motions they wish to file to have the bonds revoked and give us an opportunity to be heard on it, because there is some substantial backstory that I think needs to be presented to the court before his bonds are revoked. Judge Roach has ROR'd him on probably a half a dozen cases that came subsequent to the original series of cases that are now pending based on her review of those charges as well. And so I think that also speaks to what I'm speaking to, Your Honor. So I would ask the court not make that determination today, but to set it for a hearing if need be.
All right, I'm not going to take any action on the Orange County cases. I'm familiar with some of Mr. DeWitt's ancillary issues. Who's got the Osceola County case, the 2019 case?
It's actually in your division, Your Honor.
All right. Thanks. Has there been a motion for pretrial detention filed in this case?
Not yet, Your, like, motion to revoke bond, I don't believe so, just because the new law just came in. So that wouldn't occur until afterwards.
All right. I'm going to request that the state file a motion to revoke bond in the alternate case, give counsel an opportunity to digest the request and prepare a hearing. I'm going to ask that the state set that for an evidentiary hearing before me. I will consider the state's request to revoke bond based on there being probable cause being found by, looks like Judge John Savich, of this new law offense. And I will consider the request, but I want to give defense an opportunity to react to the state's or a tennis request today. So,
And, Your Honor, just for the record, I just want to note, state would be objecting to the ruling because the defendant was already on release, and a PC being found for a new violation would be a violation. So I just wanted to put that on the record.
Okay.
Thank you, Your Honor.
Thanks. I think that's within the discretion of the court at IAs to revoke bond, and the answer is not no. It's just I need some more information to make that determination. So
I understand.
the request today is denied without prejudice. Mr. DeWitt, you are bondable on this case and under those terms and conditions. Do you have a passport?
No, Your Honor, I already turned that into
All right.
passport.
All right.
Yeah, it's been surrendered.
All right, thanks. The court's going to find that Judge John Savich's requirement that he surrender his passport has been satisfied, and his new condition of bond is he is not to leave the Orange and Osceola County?
That's going to be my request, Judge, is Mr. DeWitt's business actually operates out of Orange County, and they do funeral escorts typically outside of county boundaries. So I would ask that as long as it's demonstrated for work purposes, that he be permitted to travel within Central Florida.
Yeah, I'm allowing to travel within the 9th Judicial Circuit, which is Orange and Osceola County. Any additional travel needs to be proposed to the court and approved.
Yes, Your Honor.
All right, thank you.
That's all I have before the court, Your Honor. May be excused?
Yep, that'll complete our hearing. Thanks.
It'll be Collins.
Colin, okay, thank you.
All right, let's recall Mr. Burgess's case. Tarvis Burgess. Good afternoon, Mr. Burgess. I was successful in getting word back from Judge Epperson. Judge Epperson has left it within my discretion to consider a bond in your case. The address that we have is the Dorothy Way address down in West Palm. Is that still your valid address?
Yes, sir.
All right, thanks. Is it a house or an apartment?
It's an apartment, sir.
All right, does it have a number?
Yes, 94.
94? Okay. So we have 94 Dorothy Way West, West Palm Beach, Florida. Is that correct?
Yes, sir.
All right, that's where your mail is going to go. I am going to consider setting a bond in your case. Do we have any additional court dates for Mr. Burgess?
February 9th for the pretrial.
All right.
9:30 a.m.
All right, Mr. Burgess, your pretrial is February 9th. That's in front of Judge Epperson at the Osceola County Courthouse. Do you understand?
Yes, sir.
Court's going to set bond in this case in the amount of $500. We'll need to post that bond, and then you're ordered to appear in front of Judge Epperson on that date.
Thank you so much, Your Honor.
Yes, sir. Good luck.
Your Honor, I'm sorry, that date was February 9th for the...
That was the date that was given. Thank you, counsel. Joshua Franceschi.
Your Honor, he is currently in hospital.
Okay.
But if I could be heard, Your Honor, This was a FTA on a,
Looks like failure to appear for traffic courts.
yes. He is the victim in another case in which he received a gunshot wound, Your Honor. And I would ask if there's any way that he can just be released. He is currently in hospital.
All right, looks like this was a failure to appear. Judge Epperson was the issuing judge. Does the state have any additional information?
I do not, Your Honor. Did I hear correctly? Counsel said Mr. Franceschi is in the hospital currently?
Yes, Ms. Morales, he is. It is mentioned in the police report.
Okay. I don't-
That he was remotely booked into the Osceola County Jail from ORH, and that he is the victim in KBD case number 208640. And that was his initial contact with the officers, was because he was a victim of a gun shooting.
Okay, thank you. I'm sorry. I don't, state doesn't get the police reports. We just get a paper with the warrant.
Oh, no worries.
Yeah,
Your Honor, it just looks like it's a standard duelist, the case where he got the warrant issued. I'm pulling up. I don't really see anything particularly special about it that would...
looks like Judge Epperson considered that and set bond the amount of $250.
Oh, cool.
Yes, Your Honor. I doubt he anticipated that Mr. Franceschi would be shot, though.
Well, I understand that, but the court's not going to amend that low bond that was contemplated by Judge Epperson. He'll need to post that bond and appear in front of Judge Epperson. Do we have any additional court dates?
Yes. December 17, if still in jail, or January 12 at 8:30 a.m., if released.
Thanks. Brendan Haven Gulp. Good afternoon, sir. Sir, you were arrested based on a warrant. That was Judge Morgan's warrant. The allegations are a violation of Condition 2, and there are a variety of other allegations in the affidavit which Judge Morgan found probable cause. I actually consulted with Judge Morgan. Although the warrant only reflects the violation of Condition 2, there are a number of other violations alleged in the probation officer's warrant that were considered by Judge Morgan. He issued no bond. You're going to remain on no bond, and I will appoint the Office of the Public Defender to represent your interest. Thanks. Derek Marslock.
You approved?
Good afternoon, Mr. Marslock. Mr. Marslock, you were arrested based on a warrant. Judge Arenda signed a warrant. It is alleged that you failed to appear for a rule to show cause in 2020 MM 732. She has issued a bond. That bond is set in the amount of $2,999, and I'll appoint the Office of the Public Defender to represent your interests.
Yes, Your Honor.
Thanks.
Your Honor, I do believe that he may have been in, from my conversations, that he may have been in Orange County at that time.
Okay. If you can get that information over to the state and they agree to, for the court to consider something different, I'm sure Judge Arendis will be willing to consider that.
Your Honor, I'll inform my colleague.
Thanks. Chandler Meyer?
PD approved.
Good afternoon, Mr. Meyer. Mr. Meyer, I'm looking at the affidavit of violation of probation. I don't know if I have the face sheet on him. Is it out of order? All right, looks like there was a warrant issued by Judge Wooten issuing no bond for an allegation that you violated probation in 2018 CF 3887. It is a violation of Condition 5, which is an allegation of a new law offense. I'll appoint the Office of the Public Defender. You're going to remain on no bond, and they'll get you in front of Judge Wooten as soon as they can. Thanks. Yep.
My client seems to indicate to me that there had already been an agreed-upon plea
Okay.
in Palm Beach County that anticipated the violation of probation.
All right. I'm looking at the warrant here, so that very well may be the case. If there was some, that would have required Judge Wooten's consent prior to resolving the case here, so there must be some paper trail of that, so he'll have to raise that issue with Judge Wooten.
Yes, Your Honor.
Thanks. Jorwan Parker?
Yes.
PD approved.
Good afternoon, Mr. Parker. Mr. Parker, you were arrested based on my bench warrant for failing to appear. The allegation is the failure to appear, not sure what date that was, would have been around July 15th, 2020 of this year. I did set a bond in your case. Bond in count 1 set in the amount of $3,500 and count 2 in the amount of $500. And I believe you probably already had the public defender appointed, but I will appoint the Office of the Public Defender to represent your interest. Thanks. Do we have additional court dates for him?
Yes, December 16 at 8:30 a.m.
Mr. Parker, we'll see you back in front of me on December 16th. Thanks. Jarrell Perez.
PD approved.
Good afternoon, Mr. Perez. Mr. Perez, you were arrested based on an allegation that you violated probation in 2010 CF 3950. The warrant showing a allegation of violation of Condition 5 for a new law offense out of Volusia County. Judge Morgan issued the warrant. He issued no bond. You're going to remain on no bond. And I will appoint the Office of the Public Defender to represent your interest. We'll announce any new court dates that we may have.
December 28 at 8:15.
Right. Thanks. Jose Salinas Calderon.
PD approved.
Mr. Salinas Calderon, you are here based on a warrant signed by Judge Yansevich indicating that you have violated the terms and conditions of your probation in 20 CT 1755. Judge Yansevich issued no bond. You're going to remain on no bond until you can get in front of her, and I will appoint the Office of the Public Defender to represent your interests. Thank you.
Your Honor, When I last checked benchmark on this case, he was set for arraignment on 1/8, but given that he's in jail, can you be set for the next available jail arraignment?
Yeah, we'll see if we have a court date for you. Hold on just a sec.
Thank you, Your Honor.
Mr. Zimiewski, give me your client's name one more time.
It would be Salinas
It's
Calderon.
Gwendolyn Waring.
All right, thanks. Yeah, we'll get you a date if we can here in just a minute for Mr.
Sorry, Your Honor, I didn't realize
Calderon.
you were talking to somebody else.
Problem.
Give me one sec, I'm trying to see her availability. We can do December 18 at 2:30 PM.
All right, 12/18 at 2:30. Ms. Chrysler, did you get that?
I apologize, Your Honor.
12/18 at 2:30?
Thank you.
All right, thank you. Would it be possible for corrections to get Ms. Waring, who's on our IA docket? Do we have enough room in the IA room now? We have her?
Your Honor, they're saying that we have to get everybody else finished in here first for.
Oh, is it a quarantine issue?
purposes. Yes, Your Honor.
All right. Sorry, Mr. Zimiewski, I tried. If you'll remain.
That's okay, Judge.
Thanks.
All right.
Adele Cochran?
Again, Your Honor, she is not available either. She's going to be with the next group.
All right, thank you. Jose Hernandez Perez?
Committee approved?
He's also going to be with the next group.
Thank you. Stephen Joseph?
He is here.
Good afternoon, Mr. Joseph. Mr. Joseph, you were arrested based on a violation of injunction stalking. I took a look at the charging affidavit. I do find probable cause for your initial arrest. I am going to set bond in the new case in 2020 MM2959. Bond will be set in the amount of $1,000. Bad news is that you're out on bond on 2020 CF 3312 with serious allegations, aggravated assault with a deadly weapon, battery, and tampering in Judge Wooten's division. Court's going to find probable cause that you have violated your terms of your bond. I'm going to revoke your bond in 2020 CF 3312. Your bond's going to be set at this time at none, and you can make a petition in front of Judge Wooten for bond. Ms. Chrysler, is he currently a client of the Office of the Public Defender in 2020 CF 3312?
One moment.
Thanks.
Your Honor, I don't believe so.
Do you have private counsel?
No, I actually don't see any counsel assigned. I don't know if the clerks would.
Your Honor, he says that he's hired Attorney Hughes
Okay.
on that case.
I'm going to go ahead and appoint the Office of the Public Defender to make sure he has a voice while he's in there in the jail on 2020 CF 3312. If there's an attorney named Mr. Hughes, they can, or Miss Hughes, they can substitute in at any time.
Yes, Your Honor.
All right, thanks.
We'll make attempts to reach out.
Awesome, thanks. What's that? 0 on 2020 CF 33, $1,000 on the violation of injunction stalking. 1,000. Kenneth Prasad?
Committee approved?
Good afternoon, Mr. Prasad. Mr. Prasad, you were arrested based on an allegation of violation of a domestic injunction. I read the charging affidavit. I do find probable cause for your initial arrest. On that case, your bond is going to be set in the amount of $500. You're also out on bond in 2020 CF 3403, again, in front of Judge Wooten. Court's going to find probable cause that you committed a new law offense while you were out on bond. I'm going to revoke your bond on that case, set bond in the amount of none, and you can petition Judge Wooten for any changes. I'll appoint the Office of the Public Defender on both cases. Thanks.
Yes, Your Honor.
Jason Porter.
He bonded, Judge.
Thank you. Mr. Porter has bonded out. Natalie Rivera.
She is also going to be in the next group, Your Honor. I believe what we have left in this group is Vasquez, White, and Banks.
All right, thanks. Lodwin Vasquez, please.
Good afternoon, Your Honor.
Good afternoon, Mr. Vasquez. Mr. Vasquez, you were arrested based on an allegation of possessing a controlled substance and possessing drug paraphernalia. I do find probable cause for your initial arrest. Bond in count 1 be set in the amount of $1,000 and count 2 in the amount of $500. And I will appoint the Office of the Public Defender in your new law offense 2020 CF 3575. I note that you're also out on pretrial release in 2020 MM 2930. Court's going to revoke your pretrial release. In that case, I will set a bond in that case in the amount of $1,000. Will PTR take him with a bond?
No, Judge.
All right. Thank you. As a special condition of his bond in 2020 MM 2930, he's not to possess or consume any illegal substances. Thank you. Brennan White.
Duly approved.
Good afternoon, Mr. White.
Your Honor, we would like to waive reading of the charges, please.
I didn't hear you, Ms. Chrysler.
Your Honor, we would like to waive the reading of the charges, please.
All right, thank you. Mr. White, your attorney has requested a waiver of the reading of your charges, which indicates to me that you are aware of what those charges are. Is that correct? All right, thanks. Court's going to find probable cause as to count 1. Bond is going to be set in the amount of $7,500. You're not to return to the scene where this occurred. You're to have no contact with the alleged victim in this case. As to 2020 MM 2966, the court finds probable cause for that arrest. Court's going to set bond in that case in the amount of $500. You're to have no contact with the victim in that case, which is a Mr. Fador. And I will appoint the Office of the Public Defender to represent you on both.
Yes, Your Honor.
Thank you. Simone Banks.
Duly approved.
Good afternoon, Mr. Banks. Mr. Banks, you were arrested based on a accusation of failing to comply with registration and failing to register as required. Take a look at the charging affidavit. I do find probable cause for that arrest. I'm going to set bond count 1 in the amount of $1,500. As to count 2 in the amount of $500, I'll appoint the Office of the Public Defender to represent your interests.
Thank you, sir.
Thanks. All right, that should do it for the first group. Mr. Zimierski, I'll call your case as soon as we have your client present.
Thank you, Judge.
We'll be in a brief recess.
Oh, Your Honor, I have Attorney Johnson here. He has,
Hey, Mr. Johnson, you ready on your plea?
It's not over here yet, but I was going to ask, is it okay if I do it here, or do you want me to run back to the courtroom?
No, I'm happy if you do it there.
Okay, that works.
Cool, thanks.
thank you, Your Honor.
Is there a plea as well, Your Honor?
No, I've got a plea on my regular docket. Ms. Morales, so I
Is
think,
that Mr. Vasquez?
yeah,
May I have a quick moment to get a score sheet printed out?
sure.
Apparently,
Are you
I'm
covering?
Apparently, yes.
Got it, okay.
Judge, I have a question on one.
Yes.
It was Mr. DeWitt.
Yes.
Well, I don't know if I missed anything. I don't, like, I know that he had a few cases, but I don't have any case numbers. So I know he was currently on bond, but I don't have a case, so.
Okay, I took no action on the Orange County cases,
Right.
and there was a face sheet in there that
Okay.
that listed them all out, or listed out the allegations, but I didn't, that one.
So was it 1, 2, 3, 4 cases?
Right, these would be the,
So I'll just write
and
them,
it was
okay.
represented that I took no action on those based on those being brought before trial judge.
And then what about ones in Osceola? So I'll just put them all and you took no action.
Took no action, state to file a motion to withdraw.
Right, I wrote that there, so I'm gonna write it somewhere. And then you said, defendant not to leave outside of Orange and Osceola County,
Correct.
may travel within both counties for work purposes. Okay, all right. So I just didn't even had a copy of those.
Yeah.
So I'll write them.
Thank
I'll
you.
make space. These are the large ones. Limited.
It was, yeah, no, it was represented that a judge had already considered revocation on these cases. No one today. So I wasn't going to do that again. And the only case that I was this one.
Also, it's just on that case. That needs to file that. Okay, all right. If you want to start signing, please.
All right. Hey, did we do Mr. Haven's vault? Was he?
Which one?
Haven vault.
Yes.
All right. And I had Godwin Roman as well, so maybe he'll be in the second.
Yeah, on the second group, we should have Gwendolyn Warren,
Yes.
Adele Cotron,
Yes.
Jose Luis Perez, Natalie Rivera,
Yes.
and Roman.
Yes.
That's it.
Got it. Thanks.
Oh, you probably have him. I can tell you. I can tell you, the judge has, yeah. So this one was 700. Maybe that's the one she didn't get.
7,500?
Right.
Yes.
And the
And
other
then
one,
the other one was 500.
right. Yeah, it was, for Mr. White?
For Mr. White.
Yeah.
He was reading of the felony charge.
Right.
Correct.
So on the, 20 CF 3577, it was $7,500. And then, on the other one, it was 500.
Okay.
Misdemeanor is December 17, if still in jail, or the 12 if released.
This is the score sheet for Mr. Rasmus.
That's for the plea?
Yes.
Okay, she'll be writing, the clerk. These guys are done.
You at the courthouse, Mr. Zimewski?
I'm actually at OPD.
I'm sorry.
That's all right. I texted the D. I said, behind.
Got it.
Your Honor?
Yes, Ms. Kersler.
So, looking over my notes with Stephen Joseph, were we appointed on 20 CF 3312 as well? I'm pretty sure that he might have been talking about the civil injunction is where he has the attorney.
I think I appointed you on both cases, if I recall.
Okay, I just wanted to make sure, because I had it on the one, and I was like, I said he had an attorney on that, but I'm not entirely sure now.
Yes, ma'am. I think I announced both cases.
And Your Honor, if I may, I believe Ms. Rosas is the PD assigned on the 3312 case.
Awesome, thank you so much.
Thanks.
Thank you. All right, are we ready? Corrections, can you hear me out at the jail? All right. Let's go ahead and call up Emmanuel Pope.
Good morning, Your Honor.
Matt Kazera for the state.
All right. Good morning, sir. Tell me your name.
Emmanuel Pope.
Mr. Pope, you were previously placed on probation for, looks like 2 separate cases. It's now been alleged that you violated your probation. Originally, we're on probation for armed burglary in 19 CF 2125 and burglary of conveyance in 19 CF 2135. Your attorney's here in the courtroom. How does he want to address this at this point in time?
At this time, we'll enter a denial, Your Honor.
All right, we'll enter a denial as to each of your cases. I'm going to set you for a violation of probation status hearing on Thursday, February 4th, 2021 at 9 a.m. Defendant will remain in the Osceola County Jail pending disposition of his violation.
Thank you, Your Honor.
Anything else?
Nothing for me, Your Honor.
All right, excellent. Have a good day.
Thank you, you too.
Which one? All right, Mr. Scatorcio, what do you have this morning?
I have a motion that we're prepared to move forward on.
Remind me who your client is?
It's Miss Ann Stoll, S-T-U-L-L. Spot on page 5 on your docket.
Okay. Let's have Ann Stull come up. State, are you ready to go? Who's the state on Ann Stull?
Ms. Olvera.
All right, let's go ahead and swear Ms. Stull in.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you should give to this court is the truth, the whole truth, and nothing but the truth to help you God?
All right, good morning, ma'am. Tell me your name and your date of birth. All right, Ms. Stull, the state's, you've got one case on my docket today. The state's charged you with 3 crimes. The first is grand theft, 3rd degree of a motor vehicle, a 3rd degree felony, 5 years in prison. Count 2 is possession of controlled substance, another 3rd degree felony, punishment of 5 years in prison. And count 3 is possession of drug paraphernalia, 1st degree misdemeanor, punishment to a year in the county jail. We're here for a bond hearing today. Mr. Scatorcio, what is the current bond status in this case?
Currently, Your Honor, her bonds have been pulled. It looks like she had a new law violation in Orange, which brought her in, held her in Orange, and we had to do the transport to get her down here.
Okay. What's the nature of the new offense in Orange County?
The new offense, I've not been retained on it. It seems to be substance related. It sort of falls, I think, contemporaneously with what we have with the line of facts here. It seems to maybe the same individuals were participating, so they're likened to each other.
State, what's your position on, I assume the request is for me to give her new bonds on this case so she can get back out of jail?
That's correct. We've been working really closely with the family and trying to establish what it's going to look like with her being released. It looks like we're going to be retained on the Orange case, be representing her to resolve possibly Osceola, here. I spoke to Ms. Olvera. I think we're going to be able to reach a resolution, but I have a lot of information to convey to Ms. Stoll and to meet with her on. So we'll resolve this case. The Orange one obviously remains open at this time. I don't know if formal charge has been filed in that yet.
All right, Ms. Olvera, what's your position on whether it's appropriate for the court to consider giving the defendant a bond in these circumstances? Are you objecting to me giving the defendant a new bond?
Yes, Your Honor, just based on, however, I do want to bring to the court's attention the Orlando case, case number 2020 CF 13376. Just looking at our system right now, it hasn't been charged yet. So, a charging decision hasn't been made. I'm not sure if they're, if she goes under another name or something, but that's just what I saw on our minute.
All right, so here's the interesting thing. I actually originally signed an order revoking her bond and pretrial release because she had a positive drug test on August 14th. When did she pick up her charges in Orange County?
November 6, 2020.
There was an interesting kind of conversation I had with Ms. Stoll and the family. When this was consolidated, they had received notice that it was going to be consolidated from the misdemeanors into the felony division. And there was this presumption that the matters were dropped. And I think there was some issue with appearance early on in this case. It looks like notice was properly served, but I think there was some sort of miscommunication regarding an appearance. So that has been cleared up, and I've established everything with her now.
Like I said, the order that I issued revoking her bond was based on the fact that she violated conditions of pretrial release by testing positive for methamphetamine. I didn't revoke her release because of the new arrest in Orange County, but my concern is that positive drug test was on August 11th. That warrant gets issued, it doesn't get served until she gets arrested on a new offense in Orange County, which apparently is also a controlled substance offense. Is that correct?
It's a grand theft of a motor vehicle, also involves a U-Haul.
Both cases have this common U-Haul scenario here. I don't need to dig into the facts of it really, but for the bond purposes, I was going to use Orange as well as an example to discuss with our case to see if we could somehow find a middle ground between the two. It's not very often we do that, but I think in this situation, given the facts and how these are kind of cohesive, that might be something to be worked out. I'd like to see her out, Judge. I've visited her a couple times now. We've already discussed her case in depth. Now I have some information to give her from the state to also discuss potentially some other offers. She's a young lady that needs help. She definitely has substance abuse issues, it appears, just from her behavior and track record of picking up new charges.
Your Honor, I do have a score sheet. However, it doesn't include the,
Let me ask you this. Do you have the PC affidavit on the Orange County arrest?
I can pull that up.
Could you print a copy for me because I can't directly access?
Yes, Your Honor.
Orange County Case Management. So, Mr. Scorchio, my concern is that she was placed on bond for an offense, including pretrial release. She violates pretrial release with a positive drug test. And then the warrant gets issued. And 3 months later, the warrant gets served because she gets arrested for committing what appears to be the exact same offense in a different location. So my concern is, while I understand the ultimate goal is to get her out, try to get her some help, and see if whatever's the underlying things driving this, my concern, without that stuff in place at this point, all I'm doing is putting her back out and inviting her to commit yet more criminal offenses in the circumstance. So,
On the score sheet, Ms. Morales just went to go get the.
are you challenging the probable cause on the Orange County case?
I have little working knowledge of the Orange County. It's like I said, it seems to stem from some of the same ordeal she's already involved in with Osceola, and the dirty urine test that obviously promulgated what the court did. But when I spoke with her, she thought the presumption was because the warrant was issued, wasn't because of the test, it was because of a failure to appear, because the cases were dropped. So I don't think there's a blatant disregard for what the court was asking for.
Well, she had to go to pretrial release
Do you want to read it?
on August 11th and take a drug test, so I assume she had to know that the case was still active at that point in time, so. Do you have the probable cause affidavit for me?
Yes, Your Honor, and the score sheet.
All right. All right, State, you can have the documents back. Mrs. Catorcio, I'm not comfortable that any conditions of release at this point in time are going to ensure the defendant's compliance with all court orders and the defendant's return and appearance for future court proceedings. So I'm going to deny the request to set bond in her case at this point in time. Ma'am, I'm talking to your lawyer, okay? He'll talk to you afterwards. Now, Mr. Catorcio, I'm open to the idea at some point in the future, if you come back to the court with a very specific plan on if she gets out, this is where she's going to go, this is what treatment she's going to get, this is why we're confident if you let her out, you can trust that she's not going to continue to commit the same offenses, then I may reconsider the decision. But at this point, if I just let her out cold, my concern is that you and her family may not see or hear from her, and she just decides to go off and wait till she gets caught again. So, and I think that's not an unreasonable expectation based on the procedural history of this case. So the motion is denied. At this point in time, you can continue to work on the case, and you can certainly come back before the court when you have a plan that's a little more specific and detailed about how the court's concerns are going to be allayed. That's the other court. Ms. Stull will remain in the Osceola County Jail at this point pending disposition of her case.
Thank you, Your Honor.
All right, have a good day.
You too.
Has anybody seen Mr. Boomershine this morning? All right, I have a Jennifer Espinoza. Are you ready to go, Ms. Rosas?
Your Honor, Ms. Espinoza has been trying to contact me since last week to ask for a reset. I was going to tell the state yesterday, but I forgot to. So we're asking for the plea to be reset.
State, what's your position?
Matt Kazera for the state. Can I ask why?
She says that she's having family issues right now.
Can can I ask why with more specificity? I'm not sure what that means.
Well, she has some illnesses in the family. Her father just tested positive, or actually was diagnosed with cancer. She has children that she needs to take care of, and it's just a really hard time for her right now. She can't make it in today, but she still wants to resolve the case, so she's just asking for a reset.
So here's my question. Originally, back on October 7th at pretrial, there was an indication that she was going to be entering a plea. And my order was that she needed to do that, and she needed to set it prior to our next pretrial date. And then we gave it a pretrial date of November 4th. Looks like on October 28th, you set it for a plea date certain on November 17th. And on November 13th, the case was reset again to today's date.
Yes.
So my concern is that while your client on some level thinks a plea is the best course of action, the actual commitment to that idea wavers and vacillates and results in her asking for a reset every time the plea date gets close. So, now State, I'm not comfortable issuing a capias at this point, but because it doesn't look like I ordered her to appear. These were proceedings scheduled by the defense. But here's what I'll do. I will set her for pretrial conference next Wednesday, December 16th. I'm going to ask the clerk of the court to notice the defendant and the bondsman and indicate that this is a mandatory appearance in person for pretrial conference. If she's not here on that date, Ms. Roses, then I'm going to consider that this is symptomatic of a larger problem, and I am likely to issue a capias depending on what I hear at that time.
Your Honor, I'll just place on the record, I share the court's concerns, and it's the reason that I asked what the reason was for yet another reset in this case. Ms. Espinoza scores 98.25 months in the Department of Corrections and was being given a non-incarcerative sentence. If a plea is not set in a timely manner that she shows up for, I will withdraw that offer, and we can either go to trial or she can spend better part of the decade in prison.
So, Ms. Roses, you need to have a conversation with your client about the importance of coming to court and the risk she takes if she continues to ask for delays. Mr. Boomershine, are you ready to go?
Judge, I will be in just a minute. I'm just asking for the state's signature on a plea form, and then we'll be ready to go on Ms. Emery's case.
Okay. All right, I have an arraignment on an Edward Gutierrez.
His problem is that he is hearing impaired.
Okay.
Rose Rosas on behalf of Mr. Gutierrez.
I've been advised that Mr. Gutierrez has a hearing issue, and so he may not be able to clearly hear what is going on, but your office is appointed to represent him, correct?
Yes, I just wanted to waive his arraignment and enter a plea of not guilty.
Will enter a plea of not guilty. State, on Edward Gutierrez, when would speedy trial normally expire?
Your Honor, speedy would normally expire on May 6th of 2021, COVID notwithstanding.
All right. On Mr. Gutierrez's case, I'm going to go ahead and give a pretrial conference date of Wednesday, April 7th, with a trial period starting April 19th of 2021. And Ms. Rosas, just make sure the court is aware going forward that potentially we may need to make arrangements to bring him over for proceedings so that we can put the headset on him. Okay? All right, corrections. Mr. Gutierrez has court dates. His public defender has waived his arraignment, so y'all can take him back to population. All right, I have a Terry Harris on the arraignment docket.
That's my case as well, Your Honor. I filed a waiver of arraignment and entered a plea of not guilty on his behalf.
Right. We have dates to Mr. Harris?
Yes, March 3rd and March 15th.
All right, March 3rd, March 15th, thank you. Then I have Angelina Izquierdo for a VOP. It shows the public defender's office. Do you know whose case that is, Ms. Rosas?
I'm not sure, Your Honor. It's not on my docket. I think that whoever had it waived her appearance.
Maria Morales for the state on Ms. Izquierdo's case, Your Honor. I believe that's Ms. Romero Sanchez's case, and I do believe that her VOP arraignment was waived.
We'll enter a denial. Have we given a court date yet?
Yes, December 21st.
Okay. She's set for 12/21 VOP status. I have Luis Rafael Rodriguez for a VOP arraignment.
That's also my case, Your Honor. So I'll waive his arraignment and enter denial on his behalf.
I'll set him for violation of probation status hearing on Thursday, February 4th, 2021 at 9 a.m. And then I have Drew Alexander Smith set for arraignment this morning.
He is represented by Ms. Romero Sanchez. I'm assuming that she entered a waiver since she's not here.
Corrections, do you have Drew Smith? Okay. Can we check on Drew Smith's case and see?
Yeah, go for it.
Yes, there was a waiver filed. He's set for a pretrial March 3rd. Trial March 3rd.
All right. Waiver, March 3rd, March 15th. And then I'm showing Michael Sagarakis.
Yes, Your Honor, this is my case. So he's going to be entering a plea today.
All right, so let me just, what I'm trying to figure out is what I've got left for corrections. Mr. Boomershine, is your client an inmate?
No, not an inmate, Judge. She's here for a plea. She's in the gallery.
All right, we'll get her case in a second. So corrections, who do you have left that I've not talked to? Albritton was a waiver. Court date is January 27th, pretrial. Okay, thank you. Y'all are free to disconnect. All right, so before I take these pleas, let me talk to the attorneys about the trial docket so I can get a batting order. So we have 3 cases currently set for trial. We have Mr. Fletcher, represented by Mr. Salazar, who is charged with DUI, having 2 prior DUI convictions. We have Mr. Grace, represented by Mr. Morrison. He is charged with aggravated assault with a deadly weapon, possession of a firearm by a convicted felon, domestic battery by strangulation. And then we have Mr. Torres's case, defendant Diego Vargas Orlando, who's charged with possession with cocaine with intent to sell or deliver, amongst other charges. And that's a case where we need the services of our interpreters, and our interpreters are here in the courtroom. So I'll start with the defense attorneys. Mr. Salazar, still ready to go to trial?
Yes, Your Honor.
Mr. Morrison, still ready to go to trial?
Yes, sir.
Mr. Torres, still ready to go to trial?
Your Honor, we're not ready. My client is not here.
Okay. Well, I had a long conversation with him last week in court. He asked me to remove you. After I talked to him about that, I didn't find a reason to remove you. He then suggested, which was a little surprising since he has previously claimed to be indigent, what if he went out and hired a lawyer and came back? And I said, that's fine, but if you come back with a lawyer, that lawyer needs to understand that he needs to be ready to try your case today, given the history of the case. So my concerns, and then I explicitly told him to be here at 8:45 today to try his case. So Mr. Torres, unfortunately, I feel like the defendant's granting himself a continuance by not appearing for trial today. Do you have any reason to suggest that my interpretation of events is inaccurate?
No, sir.
State, what do you think I ought to do in this circumstance?
Judge, I think you ought to issue a capias.
I think that is the appropriate course of action under the circumstances. So here's what we'll do. And I'm assuming, Mr. Torres, that you've had no contact with him, no suggestion that there is an extenuating circumstance beyond his control that prevents him from being here today?
I have none.
All right. My recollection is at our proceeding last week, one of the problems was he wasn't returning your calls, not responding to emails and other forms or efforts by you to contact him. Do I remember that correctly?
That's correct, Judge.
All right, here's what we'll do. I'm going to find that the defendant has failed to appear. I'm going to find under the specific circumstances. So first thing I'm going to do is I'm going to forfeit the bonds on all 4 counts. Under the circumstances, the particular history of this case, I find that it's willful and I find that no bond would ensure his future appearance. So I'm actually going to issue a capias with no bond on counts 1, 2, 3, and 4, failure to appear for trial. Mr. Kazera, anything else I need to do on Mr. Vargas Orlando's case?
No, Your Honor.
All right, that's the order of the court in regards to Mr. Vargas Orlando. I will go ahead and excuse our interpreters with my thanks for your readiness to be here today. All right, so State, tell me what your thoughts are on a batting order between Mr. Grace and Mr. Fletcher. I'll hear from the attorneys, I'll make a final decision. I'll order my panel, and then I'll take pleas while the panel's assembling and heading up.
Judge, I think we're both ready. So I don't think that we have any input on which one goes first.
Mr. Morrison?
I'm prepared, Judge, but likewise, I'm prepared not to do anything today. I'm prepared to go to trial today.
Okay. And Mr. Salazar?
Your Honor, we're ready for trial. The only thing is, given the nature of the gravity of the charges facing the other defendant, I would assume the court would prioritize that case over ours.
Well, is my general thought, but I wanted to give the lawyers an opportunity to share with me if there's something unique about the situation, or if we don't try it today, we're going to have a witness problem later in the week, and no one's telling me anything like that. So, all right.
Witnesses are local on the case. They're all same file.
All right. Let's do this. Let's have Mr. Grace come on up. Let's go ahead and swear him in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give to this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, good morning, sir. Tell me your name and date of birth again.
My name is Sean Grace, born on December 30th, 1969.
Mr. Grace, as a reminder, you're charged with 4 crimes. Count 1 is aggravated assault with a deadly weapon, a 3rd-degree felony, punishable up to 5 years in prison. Count 2 is possession of a firearm by a convicted felon, a 2nd-degree felony, punishable up to 15 years in prison. There's also a 3-year minimum mandatory sentence associated with that. And count 3 is domestic battery by strangulation, a 3rd-degree felony, punishable up to 5 years in prison. Count 4 is tampering with a witness to hinder communication to a law enforcement officer, another 3rd-degree felony, punishable up to 5 years in prison. Going back to count 2, a minimum mandatory sentence means If that sentence is imposed, you should assume that you'll serve each and every day of that sentence. You should not assume that you'd be eligible for any type of gain or good time. So do you understand the 4 crimes you're charged with?
I do.
You understand the maximum possible punishment you're facing?
I do.
And you understand the minimum mandatory sentence associated with count 2?
Yes, I do, sir.
We had a case management conference on your case previously. I think it was the week before Thanksgiving. And the state put their offer on the record, said they were ready to go. Mr. Morrison said you were ready to go. You rejected the offer and asked to be set for trial. As I explained to you then, your options today are have a jury hear the evidence and decide if you're guilty, or if you want, you can enter a plea to the bench, and I will proceed to a sentencing hearing and determine what an appropriate sentence is, understanding if you plea as charged to count 2, then there's no legal basis for me to not impose a minimum mandatory sentence. Doesn't matter to me which decision you make, but we had that discussion, you understood your options, but I always give a person, before I bring the jury up, that last chance to tell me, you know what, I think entering a plea would work out better for me than having all the evidence presented and a jury returning a verdict. So it's your decision, sir. You can enter a plea this morning. Whenever we're ready for sentencing, we'll do a sentencing proceeding. And the alternative, we'll get your jury on the way upstairs. Doesn't matter to me.
Going to trial, sir.
All right, let's go ahead and order a jury panel for Mr. Grace's case. 20 jurors. Let's make sure that they understand our setup in this courtroom so we get a seating chart that reflects where we're actually going to put people.
I went down there and gave it to them, but they said they understood.
Well, I still want that message conveyed, that we're in 5A, we want a 5A seating chart. Okay, well, sometimes when you say things 3 and 4 times, it works better than saying it twice. All right, Mr. Grace, you and Mr. Morrison can grab a seat. I'll take care of other matters. At this point in time, Mr. Salazar, once we actually get the jury up here and there's no last minute hiccup, I'll release you and Mr. Fletcher, probably to come back tomorrow to see where we stand. Again, if I know for sure that I won't be able to proceed forward on your case tomorrow, I'll have Sharice contact your office to let you know that. So I thought I was going to be finishing my first trial this morning, and events intervened. So I don't want to be in a situation where I'm sitting by myself tomorrow morning. I get lonely. So I want lawyers to keep me company. All right, fantastic. All right, so Mr. Boomershine, let's go ahead and take care of your plea, and then Ms. Rosas, you're on deck. Let's go ahead and swear Ms. Emery in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you should give to this court is the truth, the whole truth, and nothing but the truth to help you God? Yes, I do.
All right, good morning, ma'am. In a nice loud voice, tell me your name and your date of birth.
Cassandra Emery, August 26, 1987.
Ms. Emery, as you stand here, you're currently charged with 3 crimes. Count 1 is fraudulent use of personal identification information. Count 2 is cashing or depositing a worthless item with intent to defraud. Count 3 is uttering a forged check. Each of those is a third-degree felony. Each of those is punishable by up to 5 years in prison. Do you understand the crimes you're charged with and the maximum possible punishment you're facing?
Yes.
Mr. Boomershine, how does she want to resolve these 3 charges?
Good morning, Judge. She's here today to enter a plea of no contest as charged to counts 1 through 3 pursuant to negotiations with the state attorney's office. Those have been reduced to writing and submitted to the court, but I'll announce the terms for the court's edification here. The agreement is that she'll be adjudicated guilty on counts 1, 2, and 3. She'll serve 3 years of supervised probation. As special condition of probation, she'll be required to submit to a 9 p.m. through 5 a.m. That's an 8-hour curfew from 9 p.m. to 5 a.m. She'll also complete 100 hours of community service, submit for a drug evaluation plus any recommended treatment. She'll be required to pay restitution to the victim, whose name is Alfredo Solis, that's S-O-L-I-S. The restitution amount is $200. She'll also pay cost of investigation to KPD, $1,661. She'll be required to have no contact with Mr. Solis, the victim in the case. She will not return to any Chase Bank while on probation, and she'll pay mandatory minimum court costs.
State, is this your agreement?
Maria Morales, covering for ASA Amy Testa for the state. It is, Your Honor.
And Ms. Emery, have you decided this is the best way to resolve your case?
Yes.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No.
Do you read and understand the English language?
Yes.
Your attorney has given me a document called a plea form. I'm holding it up. It's a 2-page document. It's printed front and back. It's got your name on it, your case number on it, the charges you're pleading to, the resolution, and all of your rights. Did you go over this with Mr. Boomershine?
Yes.
Did he explain to you all the rights you have and the rights you give up when you enter a plea?
Yes.
Did he answer any questions you had about your rights?
Yes.
Did you then go through here initially in each paragraph indicating you understood it?
Yes.
Did you sign on the last page?
Yes.
Do you understand you're entering a plea today, which means there won't be a trial in your case, and I'll sentence you this morning?
Yes.
Has anyone forced, threatened, or coerced you to enter this plea?
No.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive?
No.
Are you satisfied with the work Mr. Boomershine has done in handling your case?
Yes.
It looks like he's got a good outcome for you, ma'am.
Yes, I agree.
Do you understand, ma'am, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes.
State factual basis?
Yes, Your Honor. On November 6th of 2019, the defendant tried to cash check number 197 for the amount of $900 that was dated for November 6th of 2019 at the Chase Bank that's located at 1477 East Osceola Parkway. The check was drawn on Chase Bank account ending in 8989. That account belongs to the victim. The victim did not authorize the defendant to cash a check from his account. All these events occurred in Osceola County, Florida.
Any objection to that factual basis as to these 3 counts, Mr. Boomershine?
No, Judge, for purposes of the plea, we stipulate to the factual basis.
Ma'am, I'm going to accept your plea. I find you're alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea based on the representations in court and the affidavits filed in this case. Is there any legal reason why sentence should not now be imposed, Mr. Boomershine?
No, Judge.
Anything else state before I impose sentence?
Nothing from the state, Your Honor.
All right, Ms. Emery, I'll go along with the negotiated resolution on count 1. I'll adjudicate you guilty. I'll sentence you to 1 day in the Osceola County Jail with credit for the 1-day time served you have. That's going to be followed by 3 years of supervised probation. I'm going to order that you report to Department of Corrections probation no later than 4 p.m. tomorrow, Thursday, December 10th, 2020. You should go today, but if for some reason they can't process you today. Oh, we're on the 8th, that's why.
Only Tuesday, Judge.
Okay. Just felt like I spent a week yesterday. All right, ma'am. No later than tomorrow, Wednesday, December 9th. But again, you should go today.
I will go today
All right.
after this.
While you're on probation, I'm going to order that you have a curfew each and every day from 9 p.m. in the evening until 5 a.m. the following morning. You need to be in the residence that you've identified with Department of Corrections. It's not good enough that you're over at a friend's house and you go inside the house at 9 p.m. and you stay inside that house until 5 a.m. If you haven't figured it out yet, why do I want you in the residence you have with Department of Corrections? Why do you think I want you there? So that when they come and check,
I'm there.
You're there. And if you're not there, there's no question about you were confused. You thought as long as you were somewhere inside, you have to be in your residence that you've identified with Department of Corrections each and every day from 9 p.m. to 5 a.m. the following morning. I'm going to order that you perform 100 hours of alternative community service at a minimum rate of 8 hours a month. I'm going to order within 45 days of today's date, you get a substance abuse evaluation and you comply with whatever recommended treatment comes out of that while you're on probation. I'm going to order that you pay restitution to the victim Alfredo Solis in the amount of $200. I'm going to order that you pay cost of investigation to the Kissimmee Police Department in the amount of $1,661. I'm going to order that you have no contact with Mr. Solis while you're on probation. I'm going to order that you not return to any Chase Bank while you're on probation. I'm also going to order that you pay any statutorily required fines, fees, and costs. On count 2, I'll adjudicate you guilty. I'll sentence you to 1 day in the Osceola County Jail, followed by 3 years of supervised probation. The terms and conditions on count 2 are comply with everything I announced on count 1. And then on count 3, I'll adjudicate you guilty, sentence you to 1 day in the Osceola County Jail, followed by 3 years of supervised probation. Terms and conditions on count 3 are comply with all terms and conditions I just announced on count 1. The sentences on counts 2 and 3 are concurrent with the sentence on count 1. Madam Clerk, can you announce the cost in this case? And then give me a total including the restitution and the cost of investigation.
Restitution is $200. The court cost is $415. Teen court fee is $3. Cost of prosecution is $100. The cost of investigation is $1,661, which totals to $2,379.
Tell me the total one more time.
$2,379.
All right, Ms. Emery, is there any reason you can't pay $100 a month towards your cost?
As of right now, I am currently unemployed.
When was the last time you worked?
April.
And what did you do?
I'm a server, hospitality.
Okay. And do you have any, do you have a mortgage? Do you have any court-ordered child support, anything of that nature?
I don't receive child support. I'm a single mom of 2 kids, and I have a rent every month to pay.
Okay. Do you live with anyone else, or you're on your own?
My boyfriend lives with me.
Okay. And does he help provide financial support?
A little, what he can. He's an Uber Eats driver, so.
How does the rent get paid each month?
My mom will help if necessary.
Okay.
If whatever, we can't come up with. But.
Well, ma'am, you're going to have to figure out a way to budget cost to pay this off as well. So here's what I'm going to do. I'm going to give you 60 days from today's date to figure out your budget, figure out what kind of work you can acquire, and begin making payments at a minimum rate of $100 a month towards your cost until your costs are paid in full. If you want to borrow the money, if your mom's willing to front you the money so you can just pay all your cost off, that's fine with me. It doesn't matter. Maybe that's going to make it easier for you to manage. But otherwise, it's a condition of your probation, and you'll pay through probation. Here's a news flash. If you do everything else and you think, you know what, I'd really like to be off probation, I'd really like to not have this curfew hanging over my head, I'm going to ask for one of those early terminations. First thing the judge is going to do is check and see if the financials are cleared. So again, you might want to consider an alternative legal way to pay off all of your costs, all right?
Gotcha.
Nate, anything else?
Nothing from the state, Your Honor.
Mr. Boomershine, anything else?
Nothing else, Judge.
Madam Clerk, anything else?
No, sir.
Ms. Emery, last thought. Looking at your score sheet, you've been picking up criminal charges on a fairly regular basis. If you were to violate this probation, particularly if you violated with a new offense involving theft or fraud, you probably won't have to worry about paying rent. What you'll have to worry about is who's going to watch your kids while you're in jail or you're in prison. Not threatening you, I'm just trying to explain to you, you've probably burned up all the goodwill that you have. Mr. Boomershine did a good job for you convincing the state to this agreement. I'm going to go along with it because they know the case better than I do. But I'm just telling you, if you were to violate, whether it's me or another judge, you're probably going to be in a difficult circumstance. So think carefully about the choices you make. It's time to turn your life around and move in a different direction. Does that make sense?
Yes, thank
Mr. Boomershine, anything else?
No, Judge. Ms. Emery and I talked a lot about probation and, what a violation looks like under these circumstances. In this case, she scored 32.7 total sentence points. So, we talked a little bit about what a violation does in terms of point accumulation and where that puts her relative to the magic 44 cutoff. So I think she's very aware of the circumstances and eager to be diligent about it.
All right. That's the order of the court. Ma'am, step over, be fingerprinted, sit down, sign for your paperwork, make sure you're put through probation. Let's go ahead and call up Mr. Sagarakis.
Thank you, Judge. Good seeing you.
Have a good day, Mr. Boomershine. Good seeing you as well. Go and swear him in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you should give to this case is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Morning, sir. Tell me your name and your date of birth.
My name is Michael George Soccerakis Jr. My date of birth is 02/22/1979, sir.
How do you pronounce your last name again?
Soccerakis.
Soccerakis.
T silent, sir.
All right. Mr. Soccerakis, you're currently charged with 2 crimes. Count 1 is possession of methamphetamine, a third-degree felony, punishable to 5 years in prison. Count 2 is possession of drug paraphernalia, a first-degree misdemeanor, punishable to a year in the county jail. Do you understand the 2 crimes you're currently charged with and the maximum possible punishment you're facing?
Yes, sir.
And Ms. Rosas, how does he want to resolve this case today?
Your Honor, Mr. Sagarakis will enter a plea of no contest as to count 2 only, the possession of drug paraphernalia. The proposed resolution is an adjudication of guilt, credit time served, and court costs.
State, is this your agreement?
Yes, Your Honor.
Soccerakis, is this how you want to resolve your case?
Yes, sir.
As you stand here today, are you under the influence of any drugs, alcohol, or other medication?
No, sir.
Have you ever been treated for a mental illness, emotional disturbance? Are you suffering from such at this time?
No, sir.
Do you read and understand the English language?
Yes, sir.
Your attorney's given me a document called a plea form. It's a 2-page document. It's printed front and back. It's got your name on it, your case number on it, the charge you're pleading to, the resolution, all of your rights. Did you go over this with Ms. Rosas?
Yes, sir.
Did she explain to you all the rights you have and the rights you're giving up by entering this plea?
Yes, sir.
Did she answer any questions you had about your rights?
Yes, sir, she did.
Did you go through here initially in each paragraph indicating you understood it?
Yes, sir.
Did you sign on the last page?
Yes, sir.
Do you understand you're entering a plea today, which means there won't be a trial in your case, and I'll sentence you this morning?
Yes, sir.
Has anyone forced, threatened, or coerced you to enter this plea?
Yes, sir.
Other than what's been discussed here in open court, has anyone made any other promises to you about the sentence you'd receive?
No, sir.
Are you satisfied with the work Ms. Rosas has done in handling the case?
Absolutely.
Looks like she's done a good job for you, sir.
Yes, sir.
Do
Thank
you
you.
understand, sir, if you were not a citizen of the United States, entry of this plea would result in your deportation?
Yes, sir.
State factual basis for count 2?
Yes, Your Honor. On June 30th of 2020, law enforcement responded to a residence in reference to a male attempting to gain entry into an occupied residence. When law enforcement arrived on scene, they found the defendant hiding behind a truck. A search of the defendant, law enforcement found a methamphetamine pipe. And as law enforcement was transporting the defendant to the jail, the defendant advised that he had another bag of meth in his sock. FDLE confirmed the residue within the bag was methamphetamine. This incident occurred in Osceola County.
Any objection to that factual basis for purposes of this plea? Ms. Rosas?
No objection.
Sir, I'm going to accept your plea. I find you alert and intelligent. Your plea is freely and voluntarily entered. You understand the nature of the charges against you, and you're represented by competent counsel with whom you say you're satisfied. I also find a factual basis for the acceptance of the plea. Is there any legal reason why sentence should not now be imposed?
No, Your Honor.
All right, so the court having accepted your plea on count 2, I'll adjudicate you guilty. I'll sentence you to 3 days in the Osceola County Jail with credit for the 3 days you've already served. I'm going to order that you pay all statutorily required fines, fees, and costs associated with this first-degree misdemeanor. Madam Clerk, what would those be?
Court cost is $273, a surcharge is $15, and a public defender lien of $50, which totals to $338.
All right, sir, how long is it going to take you to pay $338 to the clerk of the court?
Can you give me like 60 days?
Sure. I'll order within 60 days of today's date, you pay your $338 in court cost in full. State, do you have an announcement on count 1?
Yes, Your Honor. In case number 2020 CF 1848, the state would announce an all pros on count 1.
All right, just a second, sir. They're going to have you step over to be fingerprinted. Before you go, let me just share a thought with you.
Yes, sir.
You originally were charged with a possession of methamphetamine charge. The state's dropped that. So you've walked away from this experience without having to worry about being a convicted felon. I don't know what your history is.
Yeah.
That's a big deal when
Yes.
you're out in the world trying to find a job. But more importantly, if there is a problem in your life that's causing you to look to methamphetamine as an answer, I'd advise you to go see if you can find some help, find some counseling, because once people start using that as their way to deal with problems, it oftentimes leads to a very, very nasty spiral
Yeah.
where you quit standing in this courtroom, you start standing over in the Osceola County Jail because it's got control over you. So just free advice. There's no probation in this case, there's no requirement you do it, but you just might want to make sure there's not a bigger problem, all right?
Sir, thank you.
You're welcome. Step over, be fingerprinted, sit down, sign for your paperwork, and you're free to go, sir.
Thank you.
All right, is there anything left on the docket other than Mr. Grace's trial and the standby on Mr. Fletcher? Or we got everything? All right, have a good day, Ms. Roses. Where has Mr. Morrison gone? Do we have an ETA on my jury?
When you're ready.
Sure.
I need to try something new today with jury selection, so I'm not kind of talking, I'm right behind you. And this the little thing that amplifies your voice, is when I just set like all of the posts there.
Okay.
And I'm going to listen, if I may, sit as an actual witness.
It's fine with me.
Julie and I tested it this morning.
Okay.
It's sounding promising, so that way
Okay.
I'm nowhere near anybody and.
That's fine. Just obviously, if it's not working, you got to let me know so we can try plan B.
My next question, if you don't mind, if it's not going the way I was hoping to interrupt you.
You have blanket permission to interrupt anyone, to tell them, speak up, slow down, quit interrupting, whatever you need to do your job, okay? All right. All right, let's get them on their way. I'm going to step off these, make sure I'm ready to go. I'll be back in 2 or 3 minutes, and we will get started.
Short recess.
Three. Why? Oh, okay. Oh. Oh, yeah. Yeah, he was ROR. Oh, dang, sorry. There, I have the docket on the, I had the docket on the thing, on the defense table. I had a copy of the docket on the defense table with the credit time served on there.
The document is accurate. Resent that.
Well, Sharice doesn't put no, that no.
Okay, okay. But you guys put it.
Yeah.
whenever You guys put it on their desk. Okay.
Mm-hmm.
Can't we do it too?
Sure. I can do that, yeah.
Then it would be like,
That sucks, huh?
yeah, no, definitely.
Yeah.
I was like, wasn't expecting that. But,
You're welcome. Are you up today?
no, mine would be the DUI. That one is
Okay.
going to be shut.
Oh, okay.
Yeah, it'll be fun.
Are you sitting second again?
No, not today. I have to actually do work. Yesterday was good though. For testimony.
Yeah.
Everything was good.
Did you ever get my email?
I did.
Okay, good.
Today I'm gonna be working and getting.
I was hoping that it was the right email, 'cause-
Yes.
Okay.
Yeah. Just the director of the CCIS. And that's it, and we'll just talk about like the jury members who's going to take. But again, this was going to be really short because we only had that one.
Yeah, I've noticed
I don't think I just figured.
It's good to have somebody just to kind of.
I've had enough speeches of, you really interesting to do.
It goes forward, but if not, yes.
Alternate. I'm running on like an hour and a half this week. I'm better. I'm hurting, but I can do this now.
Okay, good. So we're all about muscle strain and stuff.
I knew it had to be more because there's no swelling, there's no bruising. So.
Under order?
He's getting his endorsement, he made his appointment already. My mom and my mom about the fact that we're already motorcycle fans.
We have to start like a whole, fighting game.
So, he's a big, you know, he's, maybe like 180. We can't have any passenger on passenger. Yeah.
Yeah.
Yesterday's trial was interesting, Your Honor.
I don't know that I would bless it with interesting. Didn't go exactly as planned, which is not shocking for the, first trial back in a long time, so. Tracy, can I do a couple of preliminary things while your digital still got it? Okay, so we are here in State of Florida versus Sean Michael Grace. Mr. Grace is present in the courtroom with his attorney. Mr. Morrison, Mr. Donnelly is here from the state. Just a couple of preliminary matters. We're bringing a jury upstairs to proceed. Mr. Donnelly picked a jury with me yesterday. He's also picked a jury with me in the past. Mr. Morrison, I don't believe you've ever picked a jury with me. Is that correct?
That is correct, Your Honor.
All right. I'm not going to force you to divulge what you've heard about my jury selection. I suspect I know. I do what many people consider a fairly thorough voir dire, covering things including all the basic things, ability to see, hear, understand, ability to sit for 60 to 90 minutes at a stretch. I talk about the roles of the court reporter, clerks, attorneys introduce themselves, announce their witnesses. Then I talk about my job during the trial, talk about what a juror does, talk about the timing of the case. I read the charge. I then read the standard instruction on plea of not guilty, reasonable doubt, and burden of proof. Conduct an inquiry on their ability to follow that instruction. If the defense wants, I will read a portion of defendant not testifying to make sure and conduct an inquiry on the jury's ability to follow that instruction if that's what happens. If either side wants it, I will read the standard instruction on nature and quality of evidence and conduct a brief inquiry on the ability of the jurors to follow that instruction. If either side wants it, I'll read the standard instruction on law enforcement witness testimony being, shouldn't be treated more favorably or less favorably because they're in law enforcement, conduct a brief inquiry on their ability to follow that instruction. That does not preclude the attorneys following up on any of those issues. But if the jurors are going to be asked about their ability to follow an instruction, I want them to hear the instruction from me, and I want it verbatim. Oftentimes I've seen issues where lawyers say, well, if you got an instruction that basically said X, and then they don't actually give the specific instruction, they get answers that in my mind are worthless, because what we don't know is the juror's ability to follow the actual instruction. That doesn't mean that we're going to read all the jury instructions. I just find that the ones I've identified come up over and over again, and that's why I'm prepared to present them if either side asks me to do it. So, questions on how I conduct jury selection?
No, Your Honor.
Okay.
I did have one request, Judge.
Okay.
I have medical issues that prevent me from standing for long periods of time. So
Okay.
at some point, I may turn to the court, ask if I could sit down and resume questioning either of the witness or who I hear for seated position.
That's fine with me. There may be a point in time when I tell the lawyers to sit down if we have, well, no, because this issue with masks makes it difficult for the court reporter. And sometimes getting just a few feet away from the microphone is all the difference in the world between them getting a record and them not. We had a gentleman yesterday who needed the hearing assistance that basically picks up the microphones. As soon as Mr. Donnelly got about 3 feet away from the microphone, he immediately had his hand up. I can't hear him anymore because he's moved away. So I may force y'all to sit, and I'll make it clear that I'm telling y'all to do that for that reason, so the jury's not wondering. But if you need to sit for that reason, just let me know. Okay? All right. Any questions about what I present during my portion of voir dire?
No, Your Honor.
And do you in fact want me to give defendant not testifying?
No, Judge.
Okay. I will try to remember to not do that. State or Mr. Morrison, do you want nature and quality of evidence?
Yes, Judge.
And either of you want law enforcement witness?
No, Judge.
Yes, Judge.
Okay. All right. State, do you have draft jury instructions that you have sent to Mr. Morrison?
Yes, Judge, I sent those over to Mr. Morrison. The big thing missing is the lesser included charges that I think me and Mr. Morrison need to discuss which ones we anticipate.
And Mr. Morrison, have you seen the draft instructions?
I haven't, Judge. I reviewed them, and I don't have any issues with them.
Okay. So last couple thoughts. Count 2 is possession of firearm by convicted felon. I assume that we're going to bifurcate that, at least to the extent that the jury's not going to be told that that's not an issue. I'm not going to announce that count when I read the charges. And if there's a verdict of guilty, then we can have the jury go back and reconsider the issue of whether he's a convicted felon or not, or is there a stipulation?
There's a stipulation, Judge, and we actually signed one that I wanted to
Right.
enter.
Okay.
So, Judge, I'd ask we not have a bifurcate proceeding. He'll be testifying during this trial, and people are hearing on the issues of convicted felons, so it's not.
Okay, I mean, so you are fine with me reading count 2 when I read the other counts?
Yes.
Okay. I got all dressed up for nothing. Take my little note off.
I have not included that in the jury instructions at this point, so I will put that in there.
All right. Last thought, Mr. Morrison, we're limited by social distancing, so we're going to bring 20 jurors up. We'll pick through the 20. If we can't seat a full jury out of the 20, I'll simply ask for additional jurors to be brought up, and we will continue on with jury selection. The one thing that I indicated to the lawyers yesterday is don't assume, if one side or both sides exhaust all their peremptory challenges during the first 20, don't assume that I'm necessarily going to give additional peremptory challenges when the next group comes up to fill out the panel. If one of you feels like that there's case law right on point that says you can't do it that way, Judge, I'll be happy to see that case law, but I just want both sides to understand, I don't want to be in a situation where a peremptory gets used and then somebody gets stuck with a juror they like less in the next group, and then they find out I'm not going to let them have another peremptory challenge to deal with that. So, just something to be thinking about as we go through this process. Yesterday, we were able to seat a jury out of 20. So we'll see what happens this time. Mr. Salazar, my jury's on the way.
They're in the hallway now, Your Honor.
I will release you and Mr. Fletcher at this point. I'll ask that you be back tomorrow at 9. If that changes, I'll have Sharice reach out to you. One possibility is, depending on how long this case goes, we could end up starting jury selection on Mr. Fletcher tomorrow afternoon.
That's harsh.
Well, they're bringing a morning group and they're bringing an afternoon group.
Okay, so they're not just sitting there.
The people will not have been sitting there. At least that was what has been explained to me. So assuming that that is the case, I'd like to get, if I can, I'd like to get started tomorrow afternoon and then hopefully just present the case on Thursday.
On a procedure inquiry along the lines of the discussions you were having regarding jury selection, since you don't anticipate giving additional preemptories for that second group, would the court entertain backstriking someone from that first group for preemptories? Hey, man, you gotta address these things.
No, I haven't. I haven't specifically thought about that scenario. I think if the peremptory challenges still existed, I can't see why you wouldn't be able to backstrike somebody out of the first group because you like people in the second group better. My primary concern was a situation where a lawyer used a strike with an assumption about how things are going to work on panel 2, and I dislike when people feel shocked or surprised by how things turned out in the courtroom. So that was my thinking. But at this point, I'll release you and Mr. Fletcher, and currently plan to be back here tomorrow at 9. If that changes, Sharice will let you know.
Thank you, Judge.
All right, have a good day.
Can I have the stipulation up to you, Judge, or to the clerk?
Go ahead and hand it to the clerk. Is someone going to be nice and prepare the standard instruction on stipulations so that I can read that? Or is it incorporated into your stipulation?
It has not been incorporated, Judge.
Okay. And Mr. Morrison, in fact, you and your client signed the stipulation, is that correct? Okay.
Not thinking today is the 9th.
I have salad left, so we'll see. I might spoil myself. Let's-
May Clark be seated at council table?
He may. Come on up, Mr. Grace.
This time they put a note.
Do you want the stipulation language for jury selection?
No, just at the appropriate time when I read it. Sorry. Is Bert getting them stacked up? Okay.
Hide it or do anything with it? Or just swallow it like normal? And so for the joint stipulation, swallow it like normal?
Well, he just said, that's not it. It's supposed to be on the stipulation, but anyway, it was-
Okay. Put on the joints.
Mr. Boomershine, are you waiting? Okay.
Yeah,
I
okay.
didn't know if you had bought the VIP ticket to watch my jury selection. So. Well, then, the governor suggested if we can find different ways to fund the judicial system, it might be a good idea. So.
If I didn't have to deal for enjoy watching.
Does it-
I haven't seen them. I haven't conducted nor have I seen them go to jury trial.
I would say my experience from yesterday was, it was not, it was more normal than I expected it to be.
Yes.
Okay.
And then
So I think sometimes you worry so much about stuff that you convince yourself that it's just going to be completely different. Most of it was pretty typical, so.
Well, I've heard good stories of going smoothly and some horror stories of going sideways.
I would say overall, what I've heard has been positive.
Yeah.
That for the most part, people seem to be arriving, understanding the situation that we're in, and they seem very open to the things we need to do to deal with that.
Hopefully we keep the train moving.
Depends on how people spent Thanksgiving in Central Florida. So, I think when we see our numbers at the end of this week, we'll have a much better idea of what January's going to look like.
From attendance showing how many days jurors reported. Okay. Oh, Tammy, where did you get that? The list of the time that you had for us?
this wasn't
Green room.
It is. Wife just actually read that. It's spelled a little different.
I'll just direct me on the L driver in an hour.
And then follow me.
Okay. He said it's time. Oh, there it is.
Doing it really long.
Yeah, I found it. Thank you.
Well,
Just a quick timing question for the lawyers. Let's assume that we get a jury seated early afternoon and we can start. We don't have to bring a second group up or any of that. State, how long do you anticipate the presentation of your case? How many witnesses are you thinking?
I think the tops would be 3 hours, and it'd be 3 witnesses.
Okay. And Mr. Morrison, you've indicated your client's going to be testifying, which I'll talk to him about that in a moment. You can stay seated right now. How long, other than your client, are there any defense witnesses? What do you think what's your best guess of the defense case, including anticipated cross-examination? Okay. So depending on when we can start, one possibility, I typically don't like working past 6, just give me. So if we're getting to 6, I'm going to find a natural stopping point. It's possible if, defense rests at 5:30 and, we can do a quick charge conference and the jury's comfortable staying, I might actually give it to the jury. Otherwise, I'd anticipate coming back first thing in the morning and letting y'all close, charge the jury, let them deliberate while I do other work. That's my general thought. Obviously, if we have to spend the afternoon picking additional jurors, then it sounds like it would take all of tomorrow to probably present the case and get it to a jury. Does that sound reasonable?
Yes,
Mr. Donnelly?
Yes, Judge.
Okay. All right, let's get the jury in and get started.
Judge, the stipulation language appears that it's something that, at least from the Supreme Court's point of view, would be given during the preliminary instructions to the jury.
Can I print a copy of that for me, and I will.
stay on track. Mine's a little tight.
All rise.
Everybody can stand up, raise your right hand, face the clerk.
Do you solemnly swear or affirm that you will answer truthfully all questions asked of you as prospective jurors, so help you God?
All right, everyone may be seated. Good morning, everyone. Good morning, everyone. Excellent. I'm Wayne Wooten. I'm a circuit judge here in the 9th Judicial Circuit. I sit in the criminal division of Osceola County. You've been summoned upstairs today to serve as potential jurors in the state of Florida versus Sean Grace. State, are you ready to proceed at this time?
Yes, Judge, the state's ready.
And Mr. Morrison, ready to proceed at this time?
Yes, Judge.
We're here today for a jury trial. This is a criminal case, and our Constitution guarantees every person accused of a crime the right to have a jury made up of members of the community to come in, have them fairly and impartially hear the evidence, and return a fair verdict based on the Constitution and the laws that flow from it. In order for that to work, we have to ask people like you to come down to this courthouse and participate in this stage of the process. That stage involves the court and the lawyers asking you questions to figure out of this large group who's best suited to serve as a juror in this particular case. This is going to work best if you listen carefully, stay engaged with the process, answer to the best of your ability. Don't try to guess and tell us what we want to hear. Tell us what you're thinking. Answer the questions to the best of your ability. Now, as each of you is aware, we're conducting this trial in the midst of a pandemic, which means we've had to change how we normally conduct these proceedings. Normally, when I would have a jury up for jury selection, nobody would be seated across this bar here. Y'all would be much closer together. I'd have 40 people sitting in here as potential jurors instead of 20. I'm pointing that out, and obviously nobody be wearing masks. We have thought very carefully about what it means to have a trial. We have come up with this plan, which is not ideal for the setup of this courtroom, but this is the best way to make sure that we can bring you in, safely talk to you, safely pick a jury to resolve this case. I'm sure some of you saw videos downstairs about the things that have been done. I want to assure you that not only is it the judges who've thought about this, we've actually brought the health department in, walked them through our whole process from downstairs to these courtrooms to where the jurors are going to be while they are deciding the case. And they've indicated to us that our steps meet all appropriate guidelines and criteria to do this in a safe manner. So hopefully that's put you at ease. Also, something that we have noticed as we go through this process is when people wear masks, sometimes it's difficult to clearly understand what they're saying. Y'all have clear masks on right now. That is on purpose. The clear masks are so that lawyers can not only hear your answers, but they also can see your face, see your facial expression, make sure they're picking up on nonverbal cues that they might want to follow up on. But when we wear masks, again, it's difficult to clearly hear sometimes. So I want to make sure you're talking in a nice, loud voice. For some people like me, it's not really a trouble. What I normally hear from my wife is I'm too loud, never that I am too quiet. But if you're someone who's soft-spoken, this may be a challenge for you. I'm just going to ask you to do the best you can and not be offended if we ask you to speak up or repeat something. We have a court reporter off to my right. She is taking down everything that's going to be said. I've already told her, if for some reason you can't hear, interrupt as soon as possible to tell me so that we can address the situation. So I don't want you shocked or surprised if she suddenly says, I can't hear, or can you speak up, or anything like that. She's the only one who's going to know whether she can do her job or not in these circumstances. So, with the preface over, again, we're here to try a case today. At no point today am I going to ask you who has nothing better to do than sit here and be a juror in the trial of this case. I understand that all of you have your own individual lives. I'm sure all of you have things you'd rather be doing today than being here serving as a juror. But if everyone's position was, I'm too busy, my time is too important, we would never try any cases. And you may think, well, I don't have a case, so I don't care. Well, when cases don't get tried, that means victims don't have an opportunity to have their day in court. It means defendants don't have an opportunity to get a charge resolved, to have a jury return a verdict of not guilty so they can go forward in life and not have hanging over their head the fact that they're accused of a crime. So we know that you're going to make a sacrifice if you're selected to serve as a juror. We know you've already made a sacrifice coming into the courtroom today. It's a sacrifice that we ask members of our community to make from time to time. It's a sacrifice that's critical to the administration of justice in the community in which you live. So I hope each of you understand the importance of what we're doing and accept that it might be an inconvenience for you, but it's an inconvenience that helps make sure your community is a better place, a more just place. So I've been talking at you for a little bit. Now I'm going to start asking you some questions. Let's start with a basic question. Am I loud enough? If you can clearly hear me, raise your right hand. Unsurprising, I am loud enough for you. If you can clearly see me from where you're seated, raise your hand. Okay, looks like all the hands are up. Some people have glasses, some people don't. If you can see me from where you're currently seated, I'm confident you're going to see anything you need to see during the course of this trial. Now, next question. Is there anyone here whose first or primary language is something other than English? If so, raise your right hand. So I see several. We'll start on my back. Mr. Amaya Flores? What's your first or primary language? Okay. And how long have you been familiar with the English language? 29 years. Did you, when you were in school, did you have classes on English? Yes. All right. In your daily life, how long or how often do you use English in your daily life? Okay. Have you been able to understand me so far? 90%. Okay. Is there something in particular where I was talking and you weren't quite sure what I was trying to communicate to you? Okay. Have you actually not understood anything at this point, or you're worried that you won't be able to understand later? Worried. Okay. Well, so here's one thing I can tell you, Mr. Amaya. I'm not sure if it's going to help or not. Probably every single juror is a little bit worried that I'm going to start talking in Latin or start using big, long legal terms that they don't understand. We don't require anyone to come to jury duty with any type of legal education, training in the law or familiarity with legal terms. One of the things I do during the course of a case is I give instructions to the jury, instructions written by the Florida Supreme Court. They're written in a way to, as best as possible, not use legal terms. We don't use Latin. We try to use everyday words to make sure that all jurors understand what the instructions say. So if we proceeded forward, how confident are you that you would understand what's being said if we use everyday English language? 75% maybe. Okay. Thank you, sir. I will let the lawyers ask you some additional questions. I saw another hand or two. So is it Ms. Lorenzo? Okay. What's your first or primary language? How long have you been familiar with the English language? 20 years? Okay. Did you receive any type of English language classes when you were in school? Okay. In your everyday life, how often do you use English? Have you understood everything I've said so far? If all of our proceedings were in English, would you be comfortable that you could follow along? You've got your hand kind of going sideways, so, maybe? All right. I'll let the lawyers ask you some additional questions. Thank you, ma'am. I saw one more hand. Is it Colon or Colon Velez? All right, Mr. Colon, what's your first or primary language? How long have you been familiar with the English language? 39 years. 39? Yes, sir. Okay. Okay. Well, and I try to phrase the question in a particular way because I don't make assumptions. But by the same token, I need to know if there's someone that does have a potential challenge. So you're comfortable speaking in English. You're comfortable participating if everything's in English. Okay, thank you. Anyone else? A first or primary language, something other than English? Mr. Is it Sanchez? What's your first or primary language? How long have you been familiar with English? 4 years. 4? Did you receive any type of educational classes in speaking English? Just taught yourself? Okay. In your daily life, how often do you use English? Okay. Have you been able to understand what I've said so far? Okay. If all of our proceedings were in English, would you be comfortable that you could follow everything that's being presented? Yes, you think you can? Yes. Okay. I'll let the lawyers ask you some additional questions. Thank you, sir. All right. So jurors sit and they receive evidence. And where they sit during our trial is over in this jury area. Again, pre-coronavirus, all the jurors would be in that area we call the jury box. Again, to make everyone comfortable and make our proceeding safe, we've actually spread our jury out now. So each little green cross is where one juror will sit, and there'll actually be one juror on the other side of the bar over there, most likely. Mr. Johnson here in the front row, what do you notice about those chairs right over there?
They're just typical chairs.
Okay. Well, how do they look in comparison to the bench you're on right now?
More comfortable?
Almost like they're summoning you. Mr. Johnson, come over here. This is the best seat in the house. They are more comfortable than the cold, hard bench you're currently on. Typically, I keep jurors in those seats for 60 to 90 minutes at a stretch, listening to evidence, listening to instructions, or listening to arguments from the lawyers. What I need to know is if there anyone here who has some type of condition, health condition, mental health condition, that makes it impossible for you to sit for 60 to 90 minutes. If so, raise your right hand. I want to talk to you a little bit about that. Okay, I don't see any. Thank you. So folks, believe it or not, you're here for a job interview today. You may be thinking, no. I never wanted to be a juror. I never applied for this job. Well, by residing in our community, you have, in fact, applied to be a juror. You may not realize that, but you have. And I find, like many job interviews, an important thing to do is make sure the person understands what the job is that they're interviewing for. And I find that if I take a few moments to talk about what everyone else does in a case, it helps jurors understand what they're going to be asked to do. So I want to talk about the different roles that take place in a case. We have divided the responsibilities and duties that govern a process to determine whether someone's guilty of a crime or not. I'll start with our court reporter. I've already talked to you about her situation, but she's going to take down everything that we say. What I say, what the lawyers say, what you say, what witnesses say. Again, she's the only person who's going to know whether she can clearly hear and understand, so I've given her permission to interrupt anybody to tell me and tell them, slow down, speak up, whatever it might be. It's possible that another court reporter may come in during the course of the trial to make sure that they are fresh as they go through the process. Seated to my left are our clerks. They're going to swear in juries, swear in witnesses. If there are items of evidence, they're going to take those in. If I issue orders, they're going to keep track of those. At the end of the case, they read the verdict that the jury returned. You've already met our court deputies. Their job is to make sure our trial is conducted in a safe and orderly fashion. They're going to be getting you in and out of the courtroom. They're going to be showing you where you're going to be staying on breaks. If you ever have a question about something that's going on and you're not in court with me, just grab the closest court deputy, explain the situation, they'll bring it to my attention, and if I can address it, I will take care of it. We also have lawyers involved in the trial of criminal cases. There are two types of lawyers involved in the trial of case. There are lawyers who serve as prosecutors. Here we call them state attorneys. Some places they call them district attorneys. Their job is to decide what charges to file, what evidence to bring, what arguments to make, and they have the burden of proving whatever charges have been filed beyond every reasonable doubt to a jury. In just a moment, I'm going to have the prosecutors introduce themselves, and I'm going to have them announce any witnesses who they might be calling. We also have attorneys who defend people accused of crimes. They have the ability to question jurors, question witnesses, make legal arguments to the court, make arguments to the jury, question witnesses. And each lawyer has a different job to do during the course of the case. We've divided those responsibilities. We have what's called an adversarial system of justice. But just because it's an adversarial system It's not going to be like trial on TV dramas. It's not going to be like My Cousin Vinny or other movies like that. The lawyers are going to be respectful. They're going to be focused on doing their job, and everyone should expect that that's what they're supposed to do and not worry about how they do their job. Again, in a moment, I'll allow the defense to introduce themselves and their client as well. So, State, would you like to introduce yourself and announce any witnesses?
Yes, Judge. Good morning. My name is Peter Donnelly and my co-counsel.
Maria Morales.
And today, the witnesses that you may hear from the state are Erica Weiss, Morgan Weiss, and Justin Ziegler.
Is there anyone here who believes they know either of the prosecutors or any of the witnesses they just announced? If so, raise your right hand. All right, defense, would you like to introduce yourself and your client?
Hi, I'm Michael Morrison, and today my client is Mr. Sean Grace.
Is there anyone here who believes they know Mr. Morrison or Mr. Grace? If so, raise your right hand. All right, you may be seated. And again, I am Circuit Judge Wayne Wooten. I'm currently assigned to the Criminal Division of Osceola County. Is there anyone here who thinks they know me? If so, raise your right hand. As much as it hurts my ego, I don't see any hands up. All right. So let me talk a little bit about my job, and then that leads us to what jurors are going to do during the trial. I have three main jobs during the trial of a case. Number one, I act as the quote-unquote gatekeeper of evidence. Well, what does that mean? Well, I'm sure if you've ever watched a TV show or a movie about a trial or watched a real trial, you've seen the situation where a lawyer asks a question or they want to offer a piece of evidence and the other lawyer erupts out of their chair, I object. And if it's something meant to entertain, then the lawyer may make a big, long, flowery speech, maybe make fun of the opposing counsel, crack a joke, whatever it might be. That's not what objection is going to look like in this courtroom, but an objection is when one lawyer believes that the evidence that's being presented is either not relevant and appropriate to the crime charged, or it's not properly being presented. My job is to resolve that disagreement. I resolve it by looking at what the Constitution of the United States says, what the Florida Constitution says, and then I apply something called the Florida Evidence Code. And for your benefit, I'm going to hold up my big, thick book that talks about the Florida Evidence Code. All the rules and procedures for evidence coming in are contained in this book, and the cases interpreting them are contained in this book. With a book that thick, it might not surprise you that sometimes lawyers disagree about a particular piece of evidence or the particular manner in which it's going to be presented. And again, my job is to listen to their arguments. If I'm comfortable that I'm sure how the law applies, I'll simply rule. Sometimes I'll invite them up to talk to me, and while they're talking to me, you'll hear the following. You won't hear the lawyer's arguments about the law surrounding evidence and how it gets admitted, because your job as a juror is not to decide what evidence comes in or what evidence stays out. Your job is to evaluate the evidence that you do receive, determine if you find it credible, and determine if you find it sufficient to prove the crimes charged beyond a reasonable doubt. I have a second job during the course of a trial. My job is to instruct you on the law. Again, based on what the Supreme Court of the United States has said, the Florida Supreme Court, and the Florida Legislature have said. We use something called instructions. You may have heard me mention them a moment ago, and I'm going to demonstrate a few of them and present a few of them later in my questioning. We have standard instructions so that a jury in Kissimmee hears the same instructional law that a jury in Tampa or Miami or Jacksonville or Pensacola or Lake City or Palatka or wherever it might be in the state of Florida. We use the same instructions to make sure that justice is consistent across the state, that all juries receive the same instructions to decide cases. You don't need to know anything about the law. You don't need to have any legal education to be a juror. As a juror, what you need to do is listen to my instruction on the law and apply it to the evidence that has been presented and see whether the evidence presented is sufficient based on the law to support a conviction or not support a conviction. The jury has no right to disregard the law, even if the jury dislikes the law. And let me stop there for a second. Mr. Toomey, here on the front row right. I mentioned this idea that no juror has the right to disregard the law. Does that make sense to you?
I say yes.
Okay, you hesitated, and
Because,
go ahead.
well, I mean, it depends how the evidence is given out. It depends how both sides perceive themselves.
Okay.
I need to make a judgment, I have to know what, I have to have those on both sides. I can't just sit there and, without knowing what's what, you know what I mean?
Well, obviously, as I said before, the primary job of the jury is to decide what the evidence means to them.
Yeah.
Okay, but let me give you an example of the situation that jurors can't do. It won't be an example related to this case, but for example, there's a substance known as cannabis, commonly referred to as marijuana. Okay? Currently in the state of Florida, it's illegal for someone to possess cannabis except for certain circumstances where they have a medical marijuana card, things of that nature. Okay? That might change. It may not surprise many of you that there are many people who think the law should change. But here's what we can't have as a society. We have a trial in this courtroom. The charge is possession of cannabis. The state brings in the evidence. The evidence proves beyond a reasonable doubt that the defendant in that case possessed cannabis. Jury goes back. There's no doubt, but one juror says, this is a stupid law. I personally disagree with the law. I personally think cannabis should be legal. So even though the state proved the case beyond a reasonable doubt, I'm going to vote not guilty because I don't like the law. Do you see how that'd be a problem, Mr. Toomey? Because you could be in another courtroom down the hall, exact same facts, same situation, the jury follows the law, so one person's found not guilty, another person's found guilty, and the only difference is one juror didn't want to follow the law. So that's what I mean. The jury's job is to take the law that I give and apply it to the facts. Can you do that? All right, way in the back, Mr. Holyman? I saw you kind of nodding your head up and down as I was discussing that. So were you intentionally doing that, or were you subconsciously doing that, or did I misinterpret your body language? Okay. So does it make sense to you, the idea that whatever the law is that I give you, your job as a juror is simply to apply the facts to the law? And does it make sense that you shouldn't say, well, I don't like this law, or I wish the law was different? Can you just apply the law that's given? And does it make sense that that's the only way our system of justice will work, if jurors apply the law that currently exists? On. Is there anyone here who feels like, I'm sorry, Judge, if I don't like an individual law, I am not going to return a verdict of guilty, even if it's proven beyond a reasonable doubt? Anyone feel that way? If so, raise your hand. Okay. The last job I have in a criminal case is, if a jury returns a verdict of guilty, then the law says it's my job to determine what an appropriate sentence would be. I do that by looking at the facts of the case. I do that by looking at what the legislature has said the range of punishment is for an offense. And I also consider facts that the jury may not have heard that aren't relevant to the issue of guilt, but they might be relevant to the issue of what a fair and appropriate sentence is. So Mr. Is it Steyer? Mr. Steyer, sitting over here on my front left. If you're a juror, do you accept and understand that if you're a juror and you return a verdict of guilty, that will end your involvement in the case? I'll bring you in, I'll thank you for your service, I'll send you on your way.
Yes, sir.
And you understand, if you return a verdict of guilty, that it'll be up to me to decide what the appropriate sentence is based on the facts, the law, the evidence of the case, and then other factors that might not have been relevant to the issue of guilt.
Yes, sir.
And are you comfortable being a juror, understanding that's the division?
Yes, sir.
Mr. Guzman Alvarez, Are you comfortable being a juror, understanding that if you vote guilty, that's the end of your involvement, then it's up to me to determine the appropriate sentence?
Yes, sir.
Ms., is it Barbado? Ms. Barbado, are you comfortable with this division between what a jury decides, whether the defendant's guilty or not, and then what the judge does afterwards? If the verdict is guilty, what's an appropriate sentence? And are you comfortable being a juror, understanding that division? Is there anyone here who's uncomfortable with that idea? Well, Judge, I don't want to be voting guilty if I'm not going to have a say in the punishment. And that's not a whimsical question on my part. There are other states where when juries return a verdict of guilty, they're also asked to make some type of recommendation to the court about a sentence. And oftentimes I find that people living here started life somewhere else. Maybe they were jurors in another state. And they might think, you know what, I think that's a better system. I don't understand why we don't do it that way. So it's not a coy question. I want to make sure there's not someone in this room who feels that they should be involved in sentencing. If so, if you do think you should be involved in sentencing, raise your right hand. Okay. So those are really the things I do, and I secretly have already told you what you do as I went through my job. Some of you may have caught on to that. Jurors are asked to sit, listen to witnesses testify, evaluate the witness's credibility, listen to arguments from the lawyers, listen to instructions from the judge, evaluate if there are physical objects or items to be reviewed, and then the jurors go and they deliberate. And deliberate means the jurors have a group discussion about what the evidence means to each of them as an individual. They discuss it, and then they reach a unanimous decision on whether the evidence does or does not support a verdict of guilty. So, Mr. Toomey, based on what I've described, do you think you can do the job of juror?
Yes.
Mr. Johnson on the front row, do you think you can do the job of juror?
Yes.
Mr. Torres Calderon?
Yes, sir.
Do you just go by Torres?
Oh, yeah.
All right, Mr. Torres, based on what I've described, do you believe you can do the job of juror?
Yes, sir.
Ms. Davia, do you believe you can do the job of juror the way I've described it? Mr. Singh, do you believe you can do the job of juror the way I've described it? All right. I'm not going to ask every single person, but here's my question. Is there anyone who feels like they can't do the job of juror the way I've described it? If so, raise your hand so we can talk about that. Okay. So let's talk about timing. It's the least favorite subject I have to talk about because every time I feel like I make a commitment to a jury about exactly how long something's going to take, life throws me a curveball. So yesterday there was a malfunction with the jury software, so our trial was delayed an hour through no fault of anyone other than software didn't work. Had to get the vendor on the phone and fix the issue. There can just be any number of things that arise during a trial that cause it to not go exactly as planned. But here's what I can tell you. I've talked to the lawyers. We anticipate this case proceeds forward today, assuming that we get our jury selected by lunchtime. There'll be evidence presented this afternoon. It's possible, depending on how things go, that we could be in a position to quote unquote close the case and send it to the jury to decide late this afternoon. That's not a promise, it's a possibility. If I feel like we're going to go too late into the evening resolving the case, then I will bring us back tomorrow to finish whatever has not been done. So here's what I don't need to know. I don't need to hear someone tell me I have nothing to do today, I have nothing to do this early evening, and I have nothing to do tomorrow. Because I don't know how many people would tell me that. I suspect all 20 of you would tell me, I could do this, I could do that, someone would like me to do the other, I would enjoy doing this. That's not the question. What I need to know right now is if you or someone who relies on you is going to suffer a substantial hardship if you end up being here trying this case versus wherever. And I want to emphasize the word substantial hardship. I understand all of you would do something else other than be here. That's not what I'm asking you. I need to know about substantial hardships so we can address and determine how to proceed. So I'll start here on my front row right. Mr. Toomey or Mr. Johnson, any substantial hardship with the timing I've described?
No.
Mr. Johnson?
No.
All right. Second row on my right. Just raise your hand if you think you have a substantial hardship with the timing I described. Okay, go ahead, Mr. Torres. Typically what it means in my mind is either you or someone who relies on you is going to suffer some great harm, whether it's a health harm, some great financial distress, if you're here being a juror as opposed to doing whatever you would do. Okay? So do you feel like your situation falls in the substantial harm versus the inconvenient situation?
No, there's no harm.
Okay. Third row on my right. Anyone think they have a substantial hardship serving with the timing I described? Ms. Lorenzo, what's your concern? All right, I want to make sure I understand. You indicate that you work as a bartender. I'm sorry, say that a little bit louder. You work 2 jobs? 1 job. When are you supposed to be working? When are you supposed to be working? Tomorrow? What time? Lunchtime? Okay, and how long would you work? 12 to 6? If you were picked as a juror and you called your boss, is it possible they could switch you to a shift later in the week to let you make up the time you miss? Okay. Okay. So, are they covering you today? Okay. If you called them and talked to them about tomorrow, would they be able to cover your tomorrow? And if you didn't work tomorrow, what impact would it have on you? Okay. Who else lives with you? Okay. And are they adults or are they school age? Okay. All right, I'll let the lawyers ask you some additional questions about that, okay? Fourth row on my right, any substantial hardship with the timing I've described? Raise your right hand. Okay, front row left, any substantial hardship based on that timing? Second row left? Third row left?
Does that apply to animals?
Well, what's the situation you're worried about?
Birds are killed.
Okay. Are they your birds or somebody else's birds? Okay. And when you have to take care of them, what is it that you have to do?
Feed them.
Okay. Is anyone going to feed them today?
We always feed killed.
Okay. And when would you normally feed them tomorrow? Okay. What time in the morning? Okay. What time do you normally wake up? Okay. But if you knew what time you had to be here, let's just say I told you to be here at 9 o'clock tomorrow.
No, we'll have a problem.
Okay. All right. Thank you, sir. Third row on my left, any substantial hardship? And then last row on my left, Mr. Amaya, any substantial hardship? Shaking his head no. All right. All right, in just a moment, I'm going to read the charges in this case. I want to emphasize their charges. As I mentioned before, the prosecutor is an attorney, and one of the jobs the prosecutor has is they decide what charges to file. They do that by filing a document called an information. They file it with the clerk of the court. A copy goes to the defendant. The purpose of the charge, the document, is to tell the court and the defense what crimes the state believes they'll be able to prove if there is a trial. The charging document itself is not evidence. So I'm going to read the charges to you, and then when I'm done, I'm going to immediately read an instruction that's given to every single juror in the state of Florida in a criminal case that talks about the burden of proof in a criminal case. So I want you to listen to the charges, then I'll read the instruction, I'll stop partway through and ask you some questions, and then I'll finish the instruction. Here are the charges in this case. Actually, just give me one moment. To pull one thing up. The state of Florida has accused the defendant, Mr. Grace, of 4 crimes. In count 1, they have accused Mr. Grace of on or about the 22nd day of October 2019. In count 1, they've alleged that here in Osceola County, Florida, the defendant did make an assault upon Erica Lynn Weiss with a firearm, a deadly weapon, and in furtherance of said assault, Sean Michael Grace did intentionally threaten to do violence to Erica Lynn Weiss with said firearm, thus creating a well-founded fear in Erica Lynn Weiss that such violence was imminent. In count 2 of their information, the state has alleged that on or about the 22nd day of October in 2019 in Osceola County, Florida, the defendant did unlawfully own or have in his or her care, custody, possession, or control a firearm, to wit, a Bersa handgun, Sean Michael Grace having been prior thereto on the 2nd day of May 2014, convicted of a felony. In count 3, the state has alleged that on or about the 22nd day of October, the defendant did knowingly and intentionally, against the will of Erica Lynn Weiss, a family or household member or a person in a dating relationship with Sean Michael Grace, impede the normal breathing or circulation of the blood of Erica Lynn Weiss, creating a risk or causing great bodily harm by applying a pressure on the throat or neck or by blocking the nose or mouth of Erica Lynn Weiss. In count 4, the state alleges that on or about the 22nd day of October 2019, the defendant did knowingly use intimidation or physical force or threaten another person or attempt to do so or offer pecuniary benefit or gain to another person with the intent to cause or induce Erica Lynn Weiss to hinder, delay, or prevent the communication to a law enforcement officer of information relating to the commission or possible commission of a criminal offense. Those 4 crimes are commonly referred to in count 1 as aggravated assault with a deadly weapon, count 2, possession of a firearm by convicted felon, count 3, domestic battery by strangulation, count 4, tampering with a witness to hinder communication to a law enforcement officer. Those are the 4 crimes the state has alleged the defendant committed. I'm now going to read you a standard instruction. It reads, the defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. So let me stop there for a moment. Mr. Steyer, you heard me read the charges, correct?
Yes, sir.
All right. Before you came to this courtroom today, were you familiar with a concept that we talk about that in our country people are innocent until proven guilty?
Yes, sir.
All right. This instruction basically reinforces what I think most people understand, And it specifically explains that a defendant accused of a crime is presumed to be not guilty, and a jury must maintain that presumption unless and until the state proves otherwise beyond every reasonable doubt. Are you comfortable being a juror, understanding that you must presume the defendant is not guilty at this point and maintain that presumption unless the state proves otherwise beyond a reasonable doubt?
Yes, sir.
Mr. Guzman Alvarez, before you came to this courthouse today, were you familiar with this idea in our society that someone's innocent until proven guilty? And again, this instruction just basically explains that and emphasizes that when a jury decides a case, they start with the presumption the defendant's not guilty, and they keep that presumption unless and until the state proves otherwise beyond a reasonable doubt. Does that make sense to you?
Yes, sir.
If you're a juror, can you follow that instruction?
Yes, sir.
Ms. Barbado, before you came to this courthouse today, were you familiar with this idea that someone accused of a crime is presumed to be innocent until proven guilty? And you heard me read the instruction. If you're a juror in this case, will you be able to follow that instruction? Presume Mr. Grace is not guilty unless and until the state proves otherwise. All right. Ms. Williams, good morning.
Good morning.
We haven't talked yet. How are you doing?
I'm doing fine, thank you.
All right, good. Ms. Williams, before you ever came to this courthouse today, were you familiar with the idea that someone accused of a crime is presumed to be not guilty until proven guilty?
Yes.
And do you accept that if you're a juror, you have to follow this instruction? That means if you sit as a juror in this case, you must presume Mr. Grace is not guilty and maintain that unless and until the state proves otherwise beyond every reasonable doubt.
Yes.
All right. Mr. Is it Padilla?
That's correct.
How are you doing back there?
You're good.
Were you hoping I'm way off in the corner? There's a couple people in his line of sight. He might not even realize I'm sitting here. Okay? Okay. So I suspect if I wasn't sitting up on this elevated bench in this chair, people wouldn't notice me either. So, Mr. Padilla, before you ever came to this court, were you familiar with the idea that someone accused of a crime, it's innocent until proven guilty? And I just read this instruction. So do you accept that if you're a juror in this case, you have to presume Mr. Grace is not guilty? You maintain that presumption unless the state proves otherwise beyond a reasonable doubt. All right. Is there anyone on my left-hand side who is either unfamiliar with this idea, or you have a problem with the idea that when someone's accused of a crime, they're presumed to be not guilty, and the state has the burden of proving otherwise? Anyone uncomfortable with that idea? Raise your right hand. Mr. Sanchez, in seat 12, you didn't raise your hand, but did you follow everything I explained?
Yeah.
And are you comfortable that you could follow that instruction as a juror?
Yeah.
All right. Over on my right-hand side, Mr. Rodriguez in seat 15, how are you?
I'm okay, other than this mask.
I'm sorry, what was the last part?
Other than this mask.
I will tell you, the number one complaint we've had is those masks are not comfortable. Here's the good news. If you're picked as a juror, those masks go away. You can use a regular mask like the rest of us have on in the courtroom for the rest of the trial. Does that help you?
Sounds good.
All right. So, Mr. Rodriguez, before you ever came to this courtroom, were you familiar with this idea that people in our country are presumed to be not guilty? They're innocent until proven guilty.
Absolutely.
And you heard me read this instruction. If you're a juror in this case, can you follow the instruction, presume Mr. Grace is not guilty unless and until the state proves otherwise beyond every reasonable doubt?
Yes, sir.
Mr. Horvath, way in the back, how are you? Are you familiar with this idea? People are innocent until proven guilty?
Yes, sir.
And are you comfortable with the instruction I just read?
Yes.
If you're selected as a juror, can you apply that instruction, presume Mr. Grace to be not guilty unless until the state proves otherwise? Is there anyone on the right-hand side who's uncomfortable with that instruction, uncomfortable with the idea that someone accused of a crime is presumed to be not guilty and the burden is solely on the state to prove otherwise? If so, raise your right hand. All right, now I have mentioned the phrase reasonable doubt several times. I suspect if I handed out 20 notepads and 20 pens and I said, write 3 or 4 sentences in your own words telling me what a reasonable doubt is, I'd get 20 different answers. It's one of those terms that we all know, and we all think that everyone has the same definition that we personally use. I find from experience that, in fact, once you start asking people to define reasonable doubt, you get all kinds of different answers. Here's the good news. It does not matter what you thought or believed a reasonable doubt was before you came to this courtroom today. The Florida Supreme Court has created a definition of what a reasonable doubt is. I'm going to read it to you in a minute. It's the same definition that every juror in the state of Florida gets in a criminal case. What I need to know is, regardless of what you thought a reasonable doubt was before you came to this courthouse, I want you to very carefully listen to the definition. And then all I need to know is, can you use the definition the court's given and apply it to the evidence in this case? So, here is the definition. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Mr. Torres, in seat 7, if you're selected as a juror, and that's the definition of reasonable doubt that we give in this case, can you use that definition and apply it to the facts of the case, even if you assumed reasonable doubt was something other than what I just explained? You won't be able to do it. All right. And what specifically about the definition do you disagree with or doesn't sit well with you? I don't know what you mean. So,
The case, whatever is said on the case, your opinion doesn't matter on the reasonable doubt.
well, the jury's job is to listen to all the witnesses, decide whether they find the witnesses credible or not. If they don't find them credible, then they are free to not believe what the witnesses say. If they find the witnesses credible, and the testimony of the witnesses or other evidence meets this definition of reasonable doubt, would you be able to apply that definition and return a verdict of guilty? Okay, all right. And thank you for being honest about your concern, because I'd much rather explain something now and make sure that you're okay with it than just guess. Ms. Davia, if you're selected as a juror, and this is the definition of reasonable doubt that you're given to work with, can you use it and apply it to the evidence in this case?
Yes, I have a question.
Go ahead.
This case is surrounded by domestic violence, isn't it?
There is at least one allegation suggesting that there was a domestic relationship between the defendant and the victim. Is there something about that? If those are the facts that are presented, is that going to be a challenge for you to apply the reasonable doubt standard fairly and impartially to the evidence?
Yes, it would.
Without going into detail, is your concern based on either a prior personal experience of yours or a personal experience of someone you're close with? And would you be more comfortable giving us some more details if we did it outside the presence of the rest of the jury?
We're not speaking about it at all.
But if I allowed limited inquiry on that point, and trust me, no lawyer's intention is to distress you or cause you any emotional harm, but by the same token, they need to understand what the situation is.
I
All right. So here's what we'll do. When we take a break, I'll have you remain behind. I'll let the lawyers ask a few additional questions to make sure we're all on the same page. Does that make sense? All right. Mr. Singh, if you're selected as a juror in this case, would you be able to apply the definition of reasonable doubt that I gave to the evidence in this case? All right. And Mr. Colon, would you be able to apply that definition of reasonable doubt to the evidence in this case? All right. Is there anyone on my right-hand side who's concerned about using that definition of reasonable doubt as the standard of proof in a criminal case? If so, raise your right hand. All right, over on the left, Mr. Cabrera Martinez?
Yes.
How are you today?
How you doing?
I'm good.
Good.
If you're selected as a juror, do you have any concern about using the definition of reasonable doubt I just gave and applying it to whatever the witness testimony and other evidence might be?
Yes, sir.
You can do that?
Yeah.
All right. Mr. Campbell, how are you?
Good. How are you?
Good. If you're selected as a juror, would you be able to use this definition of reasonable doubt and apply it to whatever the evidence was, whether it's witness testimony, pictures, things of that nature?
Yes.
All right. I'm just going to present a couple of other instructions to you, and then I'm going to have the lawyers up here and ask them a question about timing. So here's another instruction that you may very well get if you're a juror in this case. It's about the nature and quality of evidence. It reads, whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. So Ms. Williams in seat 5, let me go back to you. So, ma'am, what this means is there's no magic number of witnesses that the state is required to call in order for a jury to return a verdict of guilty. There's no particular type of evidence that must be presented to a jury in order for them to return a verdict of guilty. There's no legal requirement that there be a video, no legal requirement there be a scientific test. What the law requires is the jury listens to whatever the evidence is, and the jury has to decide, do we accept that evidence? Is it credible? And does it prove all the elements beyond a reasonable doubt? So here's my question. If you're a juror, can you I don't know if you have any preconceptions about what kind of evidence you might require. Can you set aside whatever preconceptions you might have? Just listen to the evidence, determine if you find it credible, and determine if you find it proves the case beyond a reasonable doubt. All right. Mr. Padilla, if you're selected as a juror, can you simply set aside any preconception about the type of evidence you would assume you would hear or the type of evidence you would think you would need? Just listen to the evidence presented, decide whether you find it credible or not. If you find it credible, does it prove the case beyond a reasonable doubt? All right. Mr. Is it Cudjoe? Did I pronounce that correctly? All right. Mr. Cudjoe, if you're selected as a juror, can you simply listen to whatever evidence is presented, decide whether you find it credible, decide whether it convinces you beyond a reasonable doubt?
Yes, I can.
All right. Is there anyone here in the room that feels there's a particular type of evidence you must have or a particular number of witnesses you must hear from before you could even consider returning a verdict of guilty? If so, raise your right hand. Okay. Last instruction I want to talk about involves law enforcement witnesses coming to the courtroom and testifying. I'm well aware that particularly in this year, 2020, the issue of law enforcement and how law enforcement interacts with our communities and how they make decisions and what techniques they use are a subject of fierce debate. Debate amongst politicians, debate on Facebook amongst people who have different views, debate amongst people who take to the streets to express their concerns. I'm not asking this question to have that debate inside this courtroom. The issue is not what people's feelings are about law enforcement in general. The issue is, can each juror promise that when a witness comes in, they're going to evaluate the witness as an individual They're going to decide whether that individual appears to be credible, does their testimony match with the other evidence, and does it prove the case beyond a reasonable doubt. That's all they have to do with each witness. So I'll start there. Mr. Colon, can you do that? Can you evaluate each human being that takes the oath, sits down to testify, decide whether they're credible or not, and decide whether their evidence can help you reach a verdict or not? Let's see who I'm going to pick on. Mr. Holloman, you worked previously for Walt Disney World, is that correct?
Yes, sir.
That's a big company, right?
Yes, sir.
Lots of people work there. All right. In your experience working at Walt Disney World, would it be fair to say that there were people you worked with who were great at their job? They had the right skill set, they understood the company's vision, they understood all the rules. When they came to work, they did an A+ job. If you knew you were working with them, you had no worries about what was getting done. Does that sound reasonable? Would it be fair to say that you worked with people who maybe they weren't A's, but they were B's? They knew how to do the job, they were suited for the job, they knew the rules, they'd come, they'd do reliable, acceptable work every time they showed up.
Yes, sir.
Would it be fair to say in your time at Disney that you ran across people who didn't have the right skill set for the job they were in, or didn't understand the rules, or chose not to follow the rules?
Yes, sir.
And would it be fair to say if a witness came in, raised their hand, and said, I work at Walt Disney World, you would not be able to tell, unless you personally knew them, whether they were an A worker, a B worker, or somebody who maybe should be doing something else for a living? Would it make sense that you could make that decision if they sat down and they started answering questions? You got to watch how they answered questions. You got to listen to their answers. You got to think about whether it made sense or not. You got to watch them get cross-examined to see how they dealt with that. All those kinds of things would help you determine whether they were an A, a B, or somebody who should be doing something else. All right. Mr. Horvath. You work at Four Seasons, correct? So another, pretty sizable operation, is that fair to say? Same kind of questions. Are there people that work there who are top shelf, fantastic people? Okay. So nobody ever gets fired from Four Seasons?
Not that often.
Okay. If somebody does get fired, is it because they have maybe the wrong skill set, or they don't follow the company's rules, things of that nature?
I don't know. I've never seen anybody get fired.
Okay, all right, that's fair. Anybody here ever need to go find a doctor? You're new to town, you don't have a doctor, you need to find a doctor. Anybody ever in that situation? Mr. Rodriguez over in seat 15. Before you went to a particular doctor, what'd you do?
Looked up reviews, where to go.
And did you find some doctors who had good reviews?
Sure.
Did you find some that had bad reviews?
Yes, sir.
So would it be fair to say if someone came in, they raised their right hand, they said, I'm a doctor, that alone wouldn't tell you whether they were a good doctor or a bad doctor, someone you would or would not trust your care to?
Correct.
Would it make sense if they sat down and they were questioned about being a doctor? And did they seem to know what they were doing? Were they honest and straightforward in answering questions? How they dealt with cross-examination? Those things would help you understand whether they were a good doctor that you would be comfortable going to see, or a doctor that you really would not want to take a chance with. Mr. Shire, where do you think I'm going with this? Oh, excuse me, Mr. Steyer, where do you think I'm going with this?
Same question. Can I be honest and judge the person based on what I hear that day?
If I gave you an instruction that says the fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness, could you follow that instruction? Would it make sense that you would evaluate a law enforcement witness's testimony the way you would a doctor or a Walt Disney worker or a cook at Four Seasons or an accountant or whoever it might be? someone's job title does not automatically entitle them to greater weight. It also doesn't entitle them or should not cause a juror to automatically exclude their testimony. Does that make sense? All right, is there anyone here who has listened to all this, they get the point I'm making, but you still feel that your feelings about law enforcement are so positive or so negative that you're not going to be able to evaluate a law enforcement witness individually? If so, raise your right hand. Okay, let me have the lawyers come up for a moment.
Yes, we can.
All right, thank you, officer. All right, who do we have representing the Office of the Public Defender out at the jail today? Looks like Mr. Schmer.
Morning, Judge. Peter Schmer, filling in for the assigned PD.
All right. See Mr. Schmer, and for the state?
Alex Card for the state.
Is it Card?
Card, yeah, sorry, Your Honor.
Thank you.
C-A-R-D.
Hard to hear through the mask. All right. For the folks out at the jail, my name is Keith Carson. I'm one of your circuit judges. Joining me today is Judge Nix. She's going to be taking over Division 201 in January. So if you happen to be assigned to Judge 201, she is likely to be your trial judge. You're all here for initial appearances today. Initial appearances is a time where I, as the judge, take a look at the charging document against you and determine whether there's probable cause for your initial arrest. In making that determination, I have to assume that the facts in that charging affidavit are true. Many of you may dispute the facts in your charging affidavit. Today's not the day for that discussion. I'm unlikely to be your trial judge. You need to save that for a discussion with your attorney if one is appointed for you. That's the next consideration during initial appearances, is to make sure that you have an attorney on board if you qualify. And the last will be a discussion as to any conditions of bond to get you back to your lives while the case is pending, if they are available. First case that I have is Edwin Chapman. Yep. Good afternoon, Mr. Chapman. All right, Mr. Chapman, you were arrested based on an out-of-county warrant out of Lake County. Another judge has found probable cause for your arrest, issued no bond, so you're going to remain on no bond until we can get you over to Lake County and address the case in front of that judge. I will appoint the Office of the Public Defender here to represent your interests so we don't lose track of you, okay? And we'll let Lake County know that you're here with us. Thank you. Ryan Belknap?
Judge, he's in a self-harm unit.
All right.
The VA, so he's not here today.
All right, thank you. We're going to reset Mr. Belknap's case. Do we think that we can address that this week? We'll go ahead and set it for, I don't know, Thursday? Thanks. Chester Bell.
Your Honor.
Good afternoon, Mr. Bell. Mr. Bell, you were arrested based on an arrest warrant signed by Judge Harris. It alleges one count domestic aggravated battery. It's like that was alleged to have occurred sometime on November 16th. Based on the charging affidavit, I am going to find probable cause for your initial arrest. I was going to set bond in this case. Bond in this case is going to be set in the amount of $1,000 with these special conditions that you have no contact with the alleged victim in this case and you not return to where this occurred, let me take a look at that address. That's at the, it's alleged that this occurred, looks like in a parking lot. Mr. Schmer, I'm going to appoint the Office of the Public Defender. Do you want to ask him if he cohabitates or lives together with the alleged victim in this case?
I'll ask you, I don't believe so.
Judge, the warrant has address of 2600 Michigan Avenue for the victim.
Ms. Carson?
Yes.
We do not live together.
Okay. All right. Sir, you're not to have any contact with the alleged victim in this case, Jennifer Coach John Deans. And that will, you're not to possess any firearms or weapons as a standard condition of bond on that case. Unfortunately, you're out on another felony case in front of Judge Morgan, 2020 CF 2398. The court has probable cause to believe that you committed a new law offense, felony law offense, while you're out on felony bond. So the court's going to revoke your bond in that case. I'll set bond the amount of none. You can petition Judge Morgan to determine conditions of bond, if any, that will satisfy him, but you're going to remain with us on no bond on that case. Do we have any new court dates?
Already made.
Mr. Bell, I don't have any additional court dates for you. Mr. Schmer, can you tell if you are already, if your office is already appointed on 2020 CF 2398?
I don't have access to a computer, but Mr. Lavelle, can you tell us whether or not we were appointed? Were we appointed previously in your case? What? In the case we had the bond revoked. Yes. Yes, the PD is appointed on that case, Judge.
All right. They'll be made aware of the ruling today, and they can get you in front of Judge Morgan to consider a bond on that case. Thanks, Mr. Bell. Cody Moxley.
Be approved.
Good afternoon, Mr. Moxley. Mr. Moxley, you were arrested based on a warrant. Judge Madrigal signed a warrant for your arrest back on June 4, 2020. Something alleged to have happened on January 13th, 2018. He has assigned bonds in your cases, bond in count 1, 2, and 3, the allegations of grand theft, false alarm of fires, and resisting arrest without violence are set in the amount of $500 each. And I will appoint the Office of the Public Defender to represent your interests.
Your Honor, I've been served the warrant like 4 months ago, and they appointed a public defender for me already, and I've been trying to get in contact with him, and he's unreachable.
Okay. I don't know why you're here back before us then. I've got the arrest warrant being executed now, and that's why you were brought for initial appearance. Mr. Card, do you have any additional information on this?
No, Your Honor, not at this time.
I've tried every possible way through the jail. I've tried through my family. I've tried multiple ways, and he just won't answer. I've wrote him through the legal mail.
All right. Well, looks like your warrant has been executed on this case. It's got a 2020 case number, which means that it was filed this year, even though the allegations are from 2018. You're bondable, so you're able to get out on bond and make an appointment with your attorney. I have trying to figure out what
charges, sir?
Yes, sir. Based on, well, I don't know if they filed charges or not. I have the warrant. I don't see information on this case.
My family, they looked up the Osceola clerk report, and they said that they haven't filed charges.
All right. The state of Florida may not have filed a information, which will be the official charging document on you. All I've got is the warrant, but I'm looking at I'm looking at your out-of-county warrant, initial appearance paperwork by Judge Wilson back on August 15th, 2020. Officer Arkendo, can you figure out what's going on this? I don't know what's going on. I don't know why he was arrested again.
I do not know, Judge. This new warrant that I have here was signed by Judge Madrigal.
It's got the same case number, and I'm looking at an order of commitment back from his initial appearance in front of Judge Wilson on August 15th, 2020. Judge Wilson stayed the bonds in the amount of $500. Mr. Moxley, were you arrested back in August and go before Judge Wilson?
I've been incarcerated since 2019.
All right. They must have brought you back before Judge Wilson in Orange County. We've got you transferred over to Osceola County, and this is your first appearance, I guess, for Osceola County. Have you posted bonds in the past on these allegations?
No, sir.
All right. You've got bonds now. It's $500 on each bond, and that should effectuate your release on this case. And once you're out, you can set an appointment, go over to the public defender's office, and perhaps talk to somebody in person.
But I still have other out-of-county holds, sir.
Okay. I can only address your Osceola County case before me today. So I've set bonds in this case, 2020 CF 1627. Mr. Schmurr is a representative of the Office of the Public Defender. Perhaps he can send a note to your assigned APD and see if they can get out and talk to you.
Just one more question. Is it possible to figure out if they had filed charges? That way I know if I can push for an ROR motion?
I don't have access to that information, but I'm not showing that they've filed an information at this point.
Thank you.
Yep. All right. Thanks. Joshua Rodriguez. Good afternoon, Mr. Rodriguez.
Good afternoon, Your Honor.
Mr. Rodriguez, you were arrested based on a warrant alleging that you violated probation in 2020 MM 245. That was signed by Judge Yansevich. Judge Yansevich issued no bond. You're going to remain on no bond. The allegations are violations that you picked up a new law offense on November 8, 2020, as well as your PO couldn't get a hold of you, and you got behind on your hours of community service and costs. You're going to have to wait to go before Judge Yansevich to consider any issues of bond, but I will appoint the Office of the Public Defender to represent your interests, and we're going to just see if you have new court dates.
Next court date, December 17 at 8:05.
All right. You'll go in front of Judge Yansevich on December 17th, if not before. Thanks. Mark Cox.
Good afternoon, Your Honor.
Good afternoon, Mr. Cox. Mr. Cox, you were arrested based on an allegation of assault, domestic violence. I read the charging affidavit, taking the allegations as true. There's probable cause for your initial arrest. I'll appoint the Office of the Public Defender to represent your interests. We're going to set bond in your case in the amount of $250 with pretrial release conditions. You're to have no contact with the alleged victim in this case, and you're not going to be able to go back to the address that this occurred. Do you have any personal belongings at the Levon Avenue address?
Yes, Your Honor.
I'll allow you to return one time with law enforcement to get some personal belongings to tide you over until this gets sorted out. Any changes to those conditions of bond you need to address with your trial judge in misdemeanor court. You understand?
Yes, sir.
All right, thanks.
Your Honor, I have one question. On my bond,
Yes, sir.
I have like no funds at all. I have zero in my bank. I have nothing. I don't have family that can pay anything.
Based on the allegation, I don't think you qualify for straight release or pretrial release. Is that correct?
Correct, Judge. He does not.
Best I can do for you is set your minimum bond in the amount of $100. That's the minimum amount I'm able to do with those special conditions.
Yes, sir.
All right, good luck.
Thank you.
Carlos DePina?
Judge, he will need a Spanish interpreter.
All right, thanks.
Hello, Cisco.
Mr. Schmer, I think our interpreters are still on their lunch break, so I'll call him at the end.
Okay.
Thanks. Sir, if you'll have a seat for me. Joseph Howe? Good afternoon, Mr. Howe. Mr. Howe, you were arrested based on an allegation of battery domestic violence related. I read the charging affidavit. There's probable cause for your arrest. I'll appoint the Office of the Public Defender to represent your interests. Going to be released on a bond in the amount of $500 with pretrial release conditions. Those pretrial release conditions being you have no contact with the alleged victim, Nilda Figueroa, and that you not return to the 4990 Tompkins Road address. Do you have personal belongings there at Tompkins Road?
Judge, hold on a second. May I address that last issue, Judge?
Yes.
The alleged victim in this case is his fiancée of 6 years, their longstanding relationship. She herself appears to either be arrested or have an APS for aggravated assault against Mr. Howe issued against her. It's not quite clear what happened. The officer says that he is both an APS as well as an arrest, but regardless, if they live together, it kind of creates a conundrum. If you're going to order no return to the residence, then she will presumably have the same condition.
Yeah, that's possible, and perhaps the trial judge can amend that to that they must maintain separate residences. Absent some sworn testimony from Figueroa today, the court's going to issue no contact and no return. I'll allow him to return one time with law enforcement to get some personal belongings, then he can petition the trial judge for a change in those bond conditions based on some sworn testimony.
Okay, thank you.
Thank you. Did I appoint the Office of the Public Defender? If I didn't, Mr. Howe is entitled to the Office of the Public Defender, and I'll appoint them to represent his interests. Devontae Kinlock? Hey, good afternoon, Mr. Kinlock. Mr. Kinlock, I got your note, and I had set you for a hearing later on in the week. That was supposed to happen on Thursday. It's alleged that you were picked up on the failure to appear warrant that I issued, and it's also alleged that during that, you picked up a new law offense in 2020 CF 3564. As to 2020 CF 1738, we'll keep you on for our bond hearing later on this week. As for 2020 CF 3564, the court finds probable cause for your arrest, and in that case, you have a bond set in the amount of $1,000. So you'll be bondable on the new law offense. You're still on no bond on 2020 CF 1738. We've got a hearing set for the 10th, and we'll see you back on Thursday. What's that?
That's for the bond?
Yes, sir.
Okay, so you had got my letter, right?
Yeah, I got your letter. Problem is, when they arrested you, they said you had drugs in your car. I don't want you to talk about the facts of the case, but I had set you for a hearing so I could hear you out.
I never knew it. Y'all never said
Yeah, no. Don't talk about the new facts of the case. As far as missing court, we'll have a discussion about that on the 10th.
Yes, sir.
All right.
On
We'll see.
Mr. Kinlock's case on CF 20-1738, he tells me he had Mr. Mike Morrison on his case, but he discharged him, so he currently has no representation.
Okay, I'm going to appoint the Office of the Public Defender on both of his cases, so he'll have some representation for that hearing on the 10th.
So, okay, now so I can get everything straight. The 10th is for what?
The 10th is based on your letter indicating that you're going to have an opportunity to tell me why you didn't come to court. However, on that case, I'm also going to consider that there's probable cause to believe you committed a new law offense while you're out on bond. So I'm going to address both of those issues at our hearing on the 10th. But you already have a hearing set in front of me, so we can hash it out on the 10th.
Yes, sir.
All right, see you then. Solabeth Medina Leal. Good afternoon, Ms. Medina Leal. Ms. Medina Leal, you were arrested based on allegations of aggravated battery, domestic violence related. I took a look at the charging affidavit. I do find probable cause for your initial arrest. Court is going to set bond in your case. I'll appoint the Office of the Public Defender to represent your interest. Your bond is set in the amount of $1,500 with the special condition that you have no contact with Santo Acosto.
Can I say something?
Well, let me remind you as to the video you heard and perhaps Mr. Schmer's admonition. You may not want to talk about the facts of the case with the court. What you're saying is being recorded. I don't want you to be put in any worse position than you're already in, but I certainly won't stop you if you think I need to have some information. I'd prefer that you run that by Mr. Schmer before you let me know.
Judge Miss, I can't pronounce her last name.
Ms. Medina Leal.
She indicated, as is in the arrest report, that the alleged victim does not want to prosecute. You know, he declined to write a statement in this case here. There were some child care issues. I think they have 7 kids in total. So I would ask the court to take that into account. I know you gave a pretty moderate bond, but I would ask if you might consider lowering the bond. I know you can't ROR, well, you could ROR her. She's not eligible for PTR, but the bottom line is it's alleged that she scratched him with a knife. It's not an egregious injury by any means. I would ask that you consider lowering the bond or give her some kind of a release provision, given that the alleged victim does not want to cooperate and that there are numerous kids in the household.
Understood. And at the initial appearance stage without sworn testimony from anyone, the court is inclined to issue no contact order and not allow her to return to the 8969 Road Street address. I'll allow her to return one time to get some personal belongings. I have appointed the Office of the Public Defender, and she can petition the trial court at an evidentiary hearing as to whether contact is appropriate and whether she should be allowed to return to the home. All right, and the state is present. Mr. Card has heard that the representation that the victim is not desirous of prosecution, but we've gotten no sworn testimony today.
Judge, on Ms. Medina Leal's case,
Yes.
the PTR officer who's not here, maybe we should call him back into the room, provided the intake sheets to Mr. Petro this morning, and he passed them on to me since he knew I was covering today's IAs. Per the PTR officer, and I'll get him out here, he reports that the victim requests contact.
All right. Officer Akendo is present with me in court. Officer Akendo.
Yes, Judge, we spoke with the victim this morning, Mr. Santo Acosta, and he's requesting contact. This was a conversation over the phone, Judge.
So I couldn't hear what the officer said. Is he saying that that victim does not want contact?
He did indicate that pursuant to a conversation with the alleged victim today, that the alleged victim does want contact. There's a number of considerations that the court needs to consider when considering that request, one of which is whether this has happened in the past, whether there's fear, what the living arrangements are, whether the alleged victim has access to communication to call law enforcement should the contact be hostile. While I appreciate that he may have stated that on the phone in an unsworn statement to PTR, I'm unwilling to allow contact until there's some sworn testimony. So at this point, it's going to be no contact. And should there be some sworn testimony and those questions be satisfied, I will consider it if I'm the trial judge. So at this point, no contact. She may return one time with law enforcement to get some personal belongings. Thank you. Antonio Miller.
To be approved?
Good afternoon, Mr. Miller. Mr. Miller, you were arrested based on allegations of battery, domestic violence, and resisting an officer without violence. Took a look at the charging affidavit. I do find probable cause for those allegations. I'm going to appoint the Office of the Public Defender to represent your interests. Mr. Schmer, do you want to ask him off the record whether he cohabitates with Ms. Tilton?
Judge, Mr. Miller reports that the alleged victim does live with him.
Okay. I note that this occurred, or it's alleged to have occurred at a Neptune Road address. Is that the address of the home?
No, sir.
All right. All right, based on the allegations and based on there's no additional sworn testimony for the court to consider, court is going to grant a bond amount of $500 as to count one with pretrial release conditions. Those conditions are going to be that he not have contact with Ms. Tilton and that they not reside together. So they must maintain separate residences while this case is pending. I will allow Mr. Miller to return one time to the family home to get some personal belongings with law enforcement to tide him over until this case gets sorted out. And
Judge, he doesn't qualify for pretrial release. He has an open warrant out of the state of Georgia, a failure to appear for charges of theft, and that's no extradition.
okay, then they no contact, may not must maintain separate residences will be as a condition of his $500 bond. In count one, in count two, the bond will be set in the amount of $500. Mr. Miller, you may have a hold on you from another state. I don't know, but on this case, you're bondable. You're not to have contact with Ms. Tilton. You understand?
Yeah.
All right, thanks. Zana Saunders.
Yeah.
Ms. Saunders, good afternoon. You were arrested based on an allegation of battery domestic violence. I read the charging affidavit. I do find probable cause for your initial arrest. I am going to set bond in your case. Bond will be set in the amount of $500 with pretrial release conditions.
She also doesn't qualify for pretrial release, Judge. She has open cases back in New York.
Your bond's going to be set in the amount of $500 with conditions of bond being that you have no contact with John Hunter and you not return to the address at 4700 West US 192, which I guess is the red carpet in there. Do you have personal belongings there at the red carpet? Yeah. Yes? All right, I'll allow you to return one time to the hotel to get some personal belongings. You guys may not cohabitate with each other until this gets sorted out. Do we have additional court dates?
Yes. December 17th, if still in jail, or January 11th at 8:15 if released.
Thanks, Madam Clerk. MacArthur Fortillis,
Judge, is the court appointing the PD office in Ms. Sanderson's case?
I apologize. Mr. Schmer, yes. The court will appoint the Office of the Public Defender to represent her interests.
Judge, could you revisit the bond issue of Ms. Saunders? I know that she's not going to qualify for PTR, but she does indicate that she's pregnant, and she also has a funeral that she'd like to go to for her mother. She has nobody local to help her out as far as the bond situation is concerned.
Well, certainly, the court sends its condolences. Ms. Saunders' mother is Mr. Hunter anticipated on attending that?
I'm sorry, I didn't understand the question.
The court issued a ruling that until this gets
No, he's
sorted.
not supposed to go to the funeral.
Okay. All right, so the request, Mr. Schmer?
That she lower the bond considerably so she can get out. I might add that according to the PTR officer, the alleged victim does request contact.
All right, Officer Akendo, was there contact with the victim in this case?
Judge, we contacted the victim, and the victim is requesting contact.
All right, it indicates that they do not live together, although the victim has requested contact and an unsworn telephone call to pretrial release. The court's going to issue no contact between Ms. Saunders and Mr. Hunter. Bond was set in the amount of $500, Mr. Schmer. Are you requesting a lower bond?
Yes.
All right, bond will be set in the amount of $250 plus the conditions of no contact and no return. Thank you.
So, we did one time.
One time, may return one time with law enforcement to get personal belongings. MacArthur Fortillis.
PD approved?
Good afternoon, Mr. Fortillis. Mr. Fortillis, you were arrested based on an allegation of battery on a corrections officer. I read the charging affidavit. I do find probable cause for your arrest. We'll appoint the Office of the Public Defender to represent your interest. Bond in your case is set in the amount of $2,500. Thank you. That'll complete our hearing. Joel Burgos.
PD approved?
Good afternoon, Mr. Burgos. Mr. Burgos, you were arrested based on two allegations, the first being burglary of an unoccupied dwelling unarmed, and the second allegation being petty theft. I read the charging affidavit. I do find probable cause for your arrest. Court's going to set bond in count one, the amount of $3,500. In count two, in the amount of $500. I will appoint the Office of the Public Defender to represent your interests. Do we have any additional court dates?
On demand.
All right, no additional court dates to give you, Mr. Burgos. You have bonds on your cases now. Thanks. Rodrigo Granda.
afternoon, Judge.
Good afternoon, Mr. Granda. Mr. Granda, you were arrested based on an allegation of failing to, let's see what this was, trespass after warning. I read the charging affidavit, do find probable cause for your arrest. Court's going to set bond in your case. I'm going to lower your bond to the amount of $250.
Judge, he meets criteria for direct PTR.
All right, I'm going to release you, Mr. Granda, on pretrial release. As a condition of your pretrial release, you understand you are not to go back to the 7-Eleven at 1400 East Osceola Parkway, yes?
Can we revisit the PTR condition? Mr. Granda is homeless.
Yes.
And he also may well be an alcoholic. Setting him up for failure is to putting him on PTR. Candidly, he's not a good candidate for PTR. I'm simply asking that he be given ROR. He may or may not have some mental issues. The officer indicated in his report that Mr. Granda continued to make no sense while speaking to him. So I would ask the court to take that into account and simply give him an ROR. It is a pretty minor offense. It's only a trespass. I doubt he has the wherewithal to be able to afford the PTR costs.
All right, the court's going to order he be released on pretrial release or a monetary bond in the amount of $100 with the condition that he not return to the 7-Eleven. Best I can do, Mr. Schmer. Thanks.
Thank you.
Joshua Valle Martinez.
And Mr. Granda was appointed to PD. Is that correct, sir?
Correct. Thank you, Mr. Schmer.
Joshua Val Martinez will also need a Spanish interpreter, Judge.
All right, thanks. Let me see if I can get an interpreter on board.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter, previously sworn.
Good afternoon, Mr. Morales. Mr. Morales, we have Mr. Valle Martinez on two cases. Case number one is 2020 MM2932. His second case is 2020 CF1297. Mr. Valle Martinez is at the jail facility. You'll be interpreting over the intercom system.
Yes, Your Honor.
Good afternoon, Mr. Valle Martinez.
Buenas tardes, señor Valle Martínez.
Buenas tardes.
Good afternoon.
Mr. Valle Martinez, it is alleged that you gave a false identification to a law enforcement officer.
Señor Valle Martínez, le acusa de darle información, una identificación falsa al policía, al oficial del orden público.
I have reviewed the allegations and do find probable cause.
He leído las acusaciones y determino que sí existe motivo fundado.
I will appoint the Office of the Public Defender to represent you on that case.
Y en ese caso le voy a nombrar a la oficina a los defensores públicos para que lo representen.
As to 2020 CF1297, court notes that you were out on ROR on that case.
En cuanto al número de causa 20CF1297, se toma nota de que usted había salido pagando fianza en ese caso.
Sí, pero yo estaba aquí y de aquí me soltaron y no me dijeron que yo tenía, porque me habían dicho, el abogado me dijo que yo hacía 60 días y yo hice esos 60 días aquí y de aquí me soltaron, pero nunca me dijeron que yo tenía que ir a la corte ni nada. Porque es un misdemeanor.
I was here and I was let go from here. I got out from here and they never told me because my attorney told me that I was going to serve 60 days and I served the 60 days here. And then they let me out and then they never told me anything about having to go to court.
All right, was there a warrant? Was he out on ROR or was there a motion to revoke his ROR? He was out on ROR?
He's out on ROR, Judge.
All right, based on the court finding that there was probable cause to believe that he gave a false identification name to law enforcement, court's going to revoke his ROR in 2020 CF1297. 1297. Court's going to set bond in that case. Bond in count 1 will be set in the amount of $2,500. Count 2 in the amount of $1,000.
Muy bien, como estaba libre, se le había permitido salir bajo palabra, determinó que existe motivo fundado en el número de causa 20, el número de causa de haberle dado una identificación falsa al oficial del orden público. Voy a revocar esa libertad bajo palabra, le voy a asignar una fianza. Para el cargo número 1, la fianza es de $2,500. Para el cargo número 2, la fianza es de $1,000.
Madam Clerk?
So, the second count is the 1297, right? 20 CF, the one that you revoked.
20 CF 1297.
The amount.
He was released on his own recognizance. I'm with revoking the ROR. I'm setting bond on both of his counts.
Judge, I vaguely remember this case.
2,500 is to count 1, 1,000 is to count 2. Are there,
Oh, on the same, see, I don't have that case with me, I don't have the numbers, so that's why I was.
Judge, unless I'm
Yes, sir,
mistaken, I vaguely remember
$3,500
this case. I think we may have had a conflict, but we did file a 33-day motion, as I recall. I'm pretty sure this is the case. So Mr. Val Martinez remembers me, he says, so he was actually released on a 33-day motion, as I recall.
yeah, that's my recollection. State, can you give me some information on Mr. Valle Martinez's case?
State is showing the same information, Your Honor, that was mentioned by defense.
Has an information been filed at this point?
Yes, Your Honor, it looks like an information has been filed at this point.
Does it allege 2 counts, robbery with a deadly weapon and grand theft?
Yes, Your Honor, it does.
All right. So I will set bonds in those now filed cases in count 1, the amount of $2,500, and count 2 in the amount of $1,000.
La fianza sigue, será, como se ha mencionado, se ha asignado en la acusación número 1, la fianza es de $2,500 y la fianza para el cargo número 2 es de $1,000.
And I'll appoint the Office of the Public Defender to represent him in 2020 CF 1297, if not previously appointed.
Y en el número de causa 20 CF 1297 le voy a nombrar a los defensores públicos para que lo representen si es que no lo había hecho ya anteriormente.
Thank you. Thank you, sir.
Gracias, es todo.
Mr. Morales, we have one more case. That's Carlos DePina.
Yes, Judge.
Yes, Your Honor.
Good afternoon, Mr. DePina.
Buenas tardes, señor De Pina.
Judge, the PTR officer informs me that Mr. DePina is hard of hearing.
All right, I'm not sure how I can accommodate Mr. DePina. Mr. DePina, can you hear the interpreter?
Señor De Pina, ¿usted me escucha?
Yes, my name is Carlos.
Which I believe this defendant speaks English, it's just that he's hard of hearing.
Does Mr. DePina need a interpreter, or does he need me to speak louder?
Well, I was told that he needs an interpreter, but now the PTR officer says he speaks English. English? You speak English, sir? You speak English? Yeah, he speaks English. I was advised differently.
Thank you, Mr. Morales. I think that's all the business we have for you this afternoon.
You're welcome, Your Honor. Thank you.
Thank you, sir. Mr. DePina, can you hear me? Does the
Mr. DePina can't hear you. He's hard of hearing, and he doesn't have a hearing device.
All right, do you have a hearing device there at the jail facility?
Not here at the jail, sir.
Judge, is it possible for the public defendant to relay your message to Mr. DePina in a louder voice, since he's right next to him?
Mr. Schmer, with your permission, he's going to qualify for pretrial release. I'd like to move forward with his hearing today. Perhaps you could write that down or explain it to him?
That's fine, yes.
All right, thank you. Mr. DePina is here on 2 cases. First case is 2020 CT 3233, and the second case is 2020 CT 3235. The allegations are DUI and refusal to submit to a breath test. He will be released on pretrial release, the conditions being that he not consume or possess alcohol and that he not drive without a valid driver's license. Mr. Schmer, if you would be so kind as to give him that information, I will appoint the Office of the Public Defender to represent his interests.
I will let him know.
Thank you. Mr. Schmer, that was the last case that I had on my docket. Do you have any other clients?
I have James Austin. He's present. James Austin.
He bonded, Judge.
Mr. Schmer, someone has posted bond for him on his behalf, and
That's right, he mentioned that earlier. His girlfriend posted bond.
his release is probably pending. Mr. Austin, it sounds like some of your friends or family posted bond, and they're working on the paperwork.
Thank
Sir, I appreciate that.
Yes, sir.
All right, you have a nice day.
Have a good day.
You as well. Thanks, Mr. Schmer.
Thank you.
Judge, I'm a little lost.
Thank you.
As to the Ms. Martinez, because this is all the information I have. I don't know how many. So, okay, I will write in here that the total is 3,500.
Right.
And it's count one, and it's just like that. Now, did you state the bond on this case?
Yes, it was $250, so it was
Okay.
stayed.
All right, so I just fixed that.
Yeah.
All right, that was simple. If you can sign these things.
Of course, thanks. And I'll give this one to you, Mr. DePina. Yeah. Yeah, happy to do it. Give me just 2 seconds to sign off on some stuff, and then we'll go in the back.
You see the no contact order?
Officer Okendo?
Yes, sir.
Why don't you, if you got a minute, come on up.
Yes, sir.